Okay, we're ready to roll.
Thank you. Good morning. Welcome to the Judiciary Committee public hearing for Monday, March 21st. We should get right into it, but if there are any comments from my co-chair or ranking members, you may speak now. Seeing none, we will call Mary Jane Foster. You have your 3 minutes. You may testify.
Thank you very much. Good morning, Senators Enfield, Flexer, and Kissel, Representatives Stastrom, Blumenthal, and Fishbein, and members of the committee. I'm Mary Jane Foster, President and CEO of Interval House, Connecticut's largest domestic violence agency. We serve Hartford and the surrounding 23 towns and cities. We have a 24/7 hotline, a safe house, a court advocacy program, and we provide access and referrals to basic human needs. I've submitted written testimony. In the interest of brevity, I'll just summarize it here. The sections of SB 5 of paramount interest to Interval House and to CCADV are $1.4 million in annual state funding to support a domestic violence child and family advocate in all 18 agencies across the state. Also, including victims of family violence in various CHR anti-discrimination laws to provide protections in employment, housing, and credit transactions, and training for all state employees on domestic violence, how it can impact the workplace, and the free resources for survivors across the state. The commonality of these proposals are awareness and prevention. We can and do the business of crisis intervention really, really well. What we have to do better is raise awareness of this issue and work in every way we can to prevent it. We know, and the CDC and the DOJ have studies to support this, that domestic violence is intergenerational. When children grow up in homes where there's violence and abuse, they believe that's the norm. They believe that's the way life is lived. And so the cycle repeats itself. Children of domestic violence grow into adults who become abusers, or they choose partners who abuse them. All 18 agencies across the state provide services to children and their supporting parent. And we do it despite the fact there is no funding from the state of Connecticut to support this work. We do it because we know the way to prevent future family violence is to work with children, help them identify their harm, help them heal, and give them the tools they need to move forward in their lives without fear of violence. We are asking that Connecticut support our work with children, support prevention of family violence by allocating $1.4 million in annual state funding so that each of us can fully address the needs of these children with full-time, highly qualified advocates. We need so much more capacity than what we've got. I want to thank you for your time and consideration of these issues. I will tell you, after 30 years of advocacy in one way or another for victims and survivors of domestic violence, I have come to know this. Until we fully acknowledge and are aware of this issue, until we provide the necessary resources to break the cycle, we will not move the numbers. I appreciate your time and consideration, and I hope you will support SB 5. Thank you so very much.
Thank you. Senator Kissel.
Thank you very much, Chairman Winfield. Good morning to the chairs, ranking member, Fishbein, and other members of the committee, and Ms. Foster. So it's my understanding that in the world of domestic violence in Connecticut, the programs used to get a certain amount of money from the federal government, and that this year, because of a variety of factors, that's going to be cut substantially. So that's sort of one thing. And now you're looking for further funding for this outreach, which is laudable. And I'm just wondering, both of these sort of things, and especially the one you just testified to, seem to sound in appropriations as opposed to the Judiciary Committee. You're looking for funding. I don't have any control over funding. I can just sort of work with the leadership of this committee and my colleagues to try to set aspirational policy goals. I certainly agree with you, and I've tried to be a very good advocate to address issues regarding domestic violence, but like, what can we do in this committee as opposed to being supportive of funding, which is really within the bailiwick of the Appropriations Committee? Through you, Mr. Chair.
You may answer.
That's a great question through the chair. I would suggest that you speak with Senator Looney on this matter. This section is a piece of SB 5, and it is a critical piece in our view to support our work. But I would defer to him on this bill, on the structure of this bill.
Well, Senator Looney does like to come before this committee quite often, so we'll see what holds.
Please
But I
let me know.
Yeah, I appreciate that response, and I'll just keep paying attention to these issues today and throughout the session. Thank you very much, Mr. Chair.
Thank you, Senator. Representative Fishbone.
Thank you, Mr. Chairman. Good morning, Mary Jane.
Good morning.
Mary Jane, a lot of the comments that you made, I share. You know, it's amazing the amount of children that I see treating their moms in particular in a bad way and then say, well, that's how dad does it. And, you know, it's, you know, the fact that people don't understand that children viewing domestic violence in the home is abuse or neglect on the DCF standard. Just had a case last week where I had to explain that to a client. So, you know, I appreciate everything you do and the public awareness and all that. But similar to what Senator Kissel was saying, sorry to demote you briefly there, Senator.
A lot of people consider that a promotion, but
your testimony was to the entirety of the bill. And am I to understand that you are just here in support of sections 26 and 27?
No, given 3 minutes and the size of SB 5, I couldn't speak to all of those issues. I chose what I believe is a paramount issue, and that is support for a child advocate. It is a critical piece to preventing and breaking the cycle of domestic violence. I also support those other sections wholeheartedly.
Okay, when you say those other sections, I'm looking at in particular section 10.
Yes.
Which it appears to dovetail two concepts. There's a CHRO concept and there's the family violence concept. So could you tell me a little bit more about section 10 and why you find that to be of importance?
The reason that's important is that very often, first of all, anti-discrimination cases are either gender or race-based. So this would include victims of family violence in a cause that could be put forth. We see over and over again victims of domestic violence who are discriminated against because of the needs that they have. It's incredibly important that we protect their credit, for instance. Abusers are well known to sabotage that where they can. Workplaces need to come forward and support victims, you know, in order to achieve the stability they need to move forward in their lives. They very often have to take time off for court hearings, from medical appointments to address those issues that are still with them from the abuse. And so we are supporting additional protections for victims so that they can stabilize their lives and move forward.
So in particular in section 10, I'm looking at sub 13, which starts on line 544. And
I'm sorry, I don't have that in front of me.
oh, okay. Well, let me, if I may, let me read to you the first sentence of that. And it says, for an employer, this has to do with CHRO, and it would be a prohibitive practice for an employer to refuse to provide a reasonable accommodation to an employee who is known by the employer to be a victim of family violence unless such absence would cause an undue hardship to the employer. So tell me how that's supposed to work. It appears to be extremely subjective in a few areas, and I understand the underlying intent.
Right.
But we're stepping into the employer-employee relationship and a subjective determination on what is reasonable accommodation for an absence.
Well, I think a reasonable accommodation standard just provides latitude to grant an employee, to give an employee the ability to attend to whatever the needs are. It's not a reasonable accommodation to disrupt the business or interrupt the business, but where an employer can reasonably accommodate the needs of the victim of family violence, to attend a court hearing, to attend a medical appointment, or whatever other basic need that employee needs. I think a reasonable accommodation works very hard to step back from what is subjective. And so it's, what's reasonable as opposed to what would interrupt and disrupt.
So what size employer would have to comply with this portion of the law?
That's a great question, and I'm afraid I don't have an answer for you on that.
Okay. And who determines whether or not something is an undue hardship to the employer?
It would seem to me that when we are talking about reasonable accommodations, it would be the employer.
But ultimately, there has to be an arbiter, right? So I would think that the scenario is the individual wants, let's say, a few days off. And it's not just for medical, the way I read this.
Right.
Domestic violence situations have a level of mental anxiety also, right?
Mm-hmm.
So, I need to go to my private space for a few days so that I can deal with what's going on in my personal life. Could be a request for absence, right? So let's just take that one.
Mm-hmm.
And the individual who is the victim wants to take 3 days as opposed to 1, and it's a small shop. The employer says, no, I think that's unreasonable. The employee either takes the days in contravention to the employer's direction, or they work it, and then subsequently there's a complaint to CHRO, because I think they're the ones that would dictate over this. How does CHRO determine whether or not, unpack all of that
Mm-hmm.
with no guidance here?
It's an interesting question and a complex. One would hope, and I think very typically, the employer and the employee reach a reasonable accommodation. And if 3 days is highly disruptive, maybe it's 1. Maybe it's 1 day this week and one day next week, and that's a reasonable accommodation. I would suggest that an employee who has PTO, paid time off, or is really struggling, has an opportunity perhaps for a short-term disability or Connecticut paid family leave, and there is accommodation in that way.
Yes.
Representative Fishman, I'm just going to make a suggestion that not too far down the list, we do have CHRO, and you may be posing questions that are better for them than for the witness before us.
Yes, understood. I just had essentially 2 more. But in response to the response, this would supersede family leave as drafted. The individual would still have family leave available. So I'm just looking at what this law is providing. Well, actually, the other question I'm going to say for CHRO. So that's fair. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us, Ms. Foster.
Thank you.
Next, we'll have Deborah Del Pratt Sullivan.
Good morning, and thank you for allowing me to testify today. Senator Winfield, Representative Stastrom, Senator Flexer, Representative Blumenthal, Senator Kissel, Representative Fishbein, and other distinguished members of this committee. I'm here today on a couple of bills, but specifically on 5467, which is an agency proposal, which would allow those family relations reports that are provided currently to the judge in court proceedings ranging from the time of arraignment and throughout the pretrial process, to allow those copies of those reports to also go to the defense counsel and the prosecutor's office. We've included the prosecutors because we have found out that there is not a consistent practice currently, which allows the prosecutors to obtain all of those. So we have asked that, since this is material that's going to the judge, which talks about whether or not someone has been successful in what they're doing in diversionary programs, sometimes gives an opinion as to whether or not someone should be allowed to go through a diversionary program. These are things that we typically are not allowed to see, and we would be able to at least know what is being given to the court in order to either defend against it or at least be in knowledge of what's being presented against our client. Under due process, anything that goes to the court should go to the defense. And as I said, we have found inconsistent practices throughout the state. Sometimes these are given to the prosecutor, sometimes they're not. In most cases, we are unable to get a copy of those, and this would change it, and that's in Section 1. There is a Section 2 also, and in my testimony, I just indicated we're not part of that particular process because that's a civil proceeding. But if this was permitted to be adopted by this committee and passed by the legislature, it would be very helpful to have a transcript from these proceedings if one of our clients had been thereafter charged. I've also submitted testimony on Brace Bill 5470, just asking that not in opposition to this, of course, but asking that the placement of the victim's impact statement be after the court's determination that there has been a violation of probation, and mirroring what is currently done in the criminal section. We've also provided testimony on Senate Bill 5. We've taken no position on any of that bill except for Section 5. And the reason for that is that I'm also a member of the Trafficking in Persons Council and also with the CBA trafficking group. And this has been something of conversation in the last year to 2 years, where we have talked about grooming statutes. I know Representative Callahan is here today, and he had actually was really helpful in getting a piece of legislation through on the trafficking bill back in 2021 to look at that and then charge the Trafficking in Persons Council with that and getting some type of language in a statute that would define grooming. So we did have a discussion at the Trafficking in Persons Council. The bill, as proposed through that group, did not receive, overwhelming consensus, and so it's still on for further discussion. And we would like to be part of that group, along with other individuals that we collaborated with back in 2021, including Love 146 and the prosecutors, as well as the private criminal defense bar. We're a little concerned about some of the language in this particular proposal as being a little bit far afield and not really defined. And that's basically my testimony for today.
Thank you. I'll go to Representative Fishbein.
Thank you, sir. Hi, Deb. Nice to see you again.
Thank you. Good morning.
Morning. Did you read the testimony from the victim's advocate with regard to 5467 and their objection to Section 1?
No, I have not read that.
Okay. Their concern surrounds an intake that a domestic violence counselor may do in a particular case, and now that information is being disclosed to the other side. I wasn't sure, in the context that we're dealing with, that it was the same report or information that Section 1 addresses in 5467.
Well, the reports we're talking about are done by that local family violence intervention unit. They are provided to the court, usually in a written form. And in some courts, there is access to the defense side. And what I had only heard about was some discussions about whether or not pro se litigants might have access to that. So last year we had proposed letting defense counsel get that, but of course that doesn't always happen. You may not have defense counsel. So how to protect, that report getting into certain people's hands. We had suggested that there are already procedures where the court could order something sealed, could order something like under our practice book 40-10, that it's not disclosed to someone, to the defendant, and protects that type of document that way as well. There's always a protective order that could be in place. And, you know, we're willing to meet with anyone and try to work on this to make it available to the defense, at least as counsel, so that we're aware of what's happening. So I'm not sure they're speaking about the same thing, but we're more than willing to sit down and talk with them about that.
Yeah, so it seems that their concern has to do with confidential communications that may appear within the document. I think we're talking about the same document. So, you know, I totally agree with the due process issue, because certainly there may be something in that document that doesn't appear in the regular court file that, you know, may be the subject of cross-examination during the proceedings. I don't want to get into sealing because, you know, in the old days, you know, you could very easily seal something in court, right? You just say, I want to seal this, and the judge said yes. But now you have this whole, you know, you have to publish to the media, you have to right to object and all this stuff to seal a document. It's very difficult to seal. But, you know, maybe we can work with the confidential language. Maybe that would massage their concern. But thank you for coming here today and the exchange. So thank you, Mr. Chairman.
Thank you.
Thank you. Representative Odette.
Thank you, Mr. Chair. Thank you, Deb, for your testimony. I actually was looking for it online and I couldn't find it. If you could just have it forwarded, or if somebody could forward it to me, that'd be great. And then Representative Fishbein asked all the questions I had in looking at section 1 in trying to balance the rights of the victim with those that you're representing, or the defendant. I do agree we need to figure out a way that can be done, and brighter minds than I need to figure that out. So I'm glad that you're willing to meet and figure that out, and when you do, let me know. Thank you. Thank you, Mr. Chair.
Absolutely. Thank you, Representative.
Thank you, Representative Callahan.
Thank you, Mr. Chairman, and thank you, Deb, for coming in. I know you have very limited time when testifying, and the committee has several people to testify, but I appreciate your work on the Trafficking in Persons Council, and I wondered if you had time to take a look at 5468, which addresses some of the concerns. If not, it's okay. I just was wondering.
5468.
Which is regarding the harmful communication with a minor, which is what we discussed in the committee.
Yes, and I have to tell you, we did not take a position on that. I'd be happy to speak with you after about that if you had specific questions, but we have not taken a position on that particular bill.
That's fine. While you were here, I just want to see if you had concerns, and I know you had limited time. So thank you for coming in, and thank you, Mr. Chairman.
Thank you.
Thank you very much, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, thank you very much for joining us again this morning.
Thank you. Thank you.
Next, we have Michelle Voigt, followed by Liza Andrews and Amber Belangis. Michelle Voigt. Liza Andrews.
Good morning, Senator Winfield, Representative
Morning.
Stafford, Senator Kissel, Representative Fishbein, members of the committee. My name is Liza Andrews. I'm the Director of Public Policy and Communications for the Connecticut Coalition Against Domestic Violence. We are a membership organization of the state's 18 domestic violence service organizations. I am here today to urge the committee's support of Senate Bill 5, which contains several priority issues for CCADV. Sections 26 and 27 propose the annual allocation of $1.4 million to fund 18 domestic violence child and family advocates across our membership. These advocates provide essential supports to children and the non-offending parents, such as counseling, coordinating basic needs, school and child care enrollment, and advocacy within the child welfare system. We thank Senators Looney and Duff for prioritizing this funding. Much attention has rightfully been paid to the impact of the pandemic on the mental health and social emotional development of children. This concern is only heightened for those children who, on top of dealing with pandemic isolation, have been experiencing domestic violence in their homes. Connecticut currently does not provide any state funding to support this critical role. Federal pass-through funds pay for only about a quarter of the cost of a full-time advocate at each site. Given that over 4,000 kids walk through our doors each year, the limited funding means our advocates simply do not have enough time to address the complex needs of these kids. Sections 8 through 9 of the bill seek to require that all state employees view a 1-hour virtual training regarding domestic violence to be developed by CHRO and CCADV. Such training would include how to identify domestic violence, how it may impact the workplace, and the free resources available to victims across the state. There is substantial research that highlights how domestic violence impacts the workplace, affecting not only the productivity of the employee experiencing abuse at home, but also how the abuser's actions, such as harassing phone calls or stalking, may spill into the workplace, jeopardizing the safety of all employees. The proposed training will serve as a critical public awareness tool that will not only protect the safety of state employees, but it will also offer state agencies the opportunity to lead on creating a workplace culture that fosters support and resilience. Because for many victims, work may be the only safe place to ask for help. Finally, sections 10 and 13 through 23 of the bill, spearheaded by CHRO, seek to create protections for family violence victims in employment, housing, public accommodations, and credit transactions, addressing some of the discrimination that can follow victims long after they've ended their relationship. One of the top predictors of whether a victim will leave an abusive relationship is the victim's ability to financially support her or himself and their children. Victims sometimes lose their jobs because of absences or related job performance issues, yet in order to address the abuse and keep themselves and their kids safe, victims may need time to attend court appearances, obtain legal or medical assistance, and find a new place to live. This bill will establish critical workplace protections for victims, among other meaningful anti-discrimination protections. We urge the committee's support.
Thank you very much. Comment or question from members of the committee? Comment or question? Seeing none, Ms. Andrews, thank you for joining us again. Next, we will hear from Amber Velanges, followed by Bridget Kessner, followed by Tonya Hughes, and then Cheryl Sharp. Amber Velanges.
Hi, can you hear me?
I do.
Okay, very good. Thank you. Good morning, Chairs Winfield and Stastrom, Vice Chairs Flexer and Blumenthal, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Amber Velanges, and I'm here as a survivor of sexual harm and someone who has also been impacted in their family by the effects of the criminal legal system. Restorative Action Alliance is made up of anti-carceral crime survivors, particularly those who've survived sexual harm, individuals impacted by the criminal legal system, and restorative advocates and practitioners. We are here today in opposition to a number of bills. We support wholeheartedly the spirit of SB 5. We unfortunately need to oppose the bill based on Section 5. We have some concerns around creating child grooming as a new crime. The broad definition could have the effect of having chilling effects on normal family relationships, and the language is quite broad. We don't feel that expanding the criminal code is a good strategy, and this is what gave rise to mass incarceration. And we favor a public health approach that emphasizes education, prevention, and healing rather than new carceral interventions. We are in opposition to 5468 for similar reasons. It makes illegal what is already illegal and simply adds new tools for charge stacking. We are in opposition to HB 5470. We fully support the right of victims and survivors who we also represent to have all of the information. However, we don't feel a new victim impact statement is germane to a probation violation hearing, in that the purpose of that hearing is to determine whether a probation violation has occurred. And then last but not least, HB 5472, we are in opposition to because we feel that it is a dangerous walk towards expanding consent in a way that people just don't interact in a sexual manner. And it will be a step towards overly criminalizing our young people without them really understanding what's going on, having them swept into the system for situations that represent the way humans conduct sexual activities. So we really, these four bills were created with a very positive intent. We applaud our lawmakers for being concerned with all of these issues. We are compelled to warn that these bills ignore a more effective public health approach and have a tendency towards over-criminalization and over-incarceration, and we have a significant potential to cause greater harm and not make anyone safer. So we stand with one standard of justice in opposing the proposal on the grounds that I outlined.
Thank you very much. Representative Porter.
Thank you, Mr. Chair, and good morning, Amber. Great to see you. I missed the first bill number that you were referencing. What's the first bill? You say you support in spirit, but you oppose it based on Section 5?
That would be SB 5.
Okay.
And again, we fully support domestic violence survivors, and we believe that they need to have support in the workplace and all the way around. They need to have healing opportunities, and the large majority of the bill is good. Section 5 is what we have concerns with.
And that is what I wanted you to just expound on for me. What are the concerns in Section 5 that you have?
So while it's intended to prevent harmful actions between adults and minors, the language could really have a chilling effect. It's quite broad. It could be weaponized against teachers and parents during a divorce or by anybody with a vendetta. Risk of injury of a minor and federal crimes around internet offenses are already crimes. And again, we have concerns that this is a counterproductive strategy to expand penal codes that, again, can be weaponized against a variety of different people. Therefore, we think the language needs some tweaking. Again, we do not in any way, shape, or form support child grooming. We just have concerns with the language.
Okay, and my last question through you, Mr. Chair, do you have any suggested language that could be substituted for Section 5?
We would be happy to send some over and to be part of working on language that might work.
That would be great. If you'd be willing to do that, I'm sure the chairs would accept. And I'll let them confirm yay or nay, but that could go out to the entire committee. I would be very interested in seeing some substitute language to address those concerns. Thank you, Amber, and thank you, Mr. Chair.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? If not, Amber, thank you for joining us again.
Thank you, and I would like to say hello to my representative, Representative Callahan. Thank you for the acknowledgement. Have a great day.
Have a great day. We will next hear from Bridget Kessner.
Senator Winfield, Representative Stastrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. My name is Bridget Kessner, and I'm the Education and Youth Services Coordinator at the Connecticut Alliance to End Sexual Violence. I'm here to speak in strong support of 5472, an act concerning sexual assault and the absence of consent. The Alliance is the state's leading voice to end sexual violence and a coalition of sexual assault crisis centers. Our mission is to create communities free of sexual violence and to provide culturally affirming, trauma-informed advocacy, prevention, and intervention centered on the voices of survivors. This bill adds the definition of consent as used in our statutes covering sex offenses and acknowledges that lack of consent should be seen as a crime in statute. Creating a definition of consent is good policy in law. Each party starts on an even playing field, and prosecutors still must make their case and prove lack of consent beyond a reasonable doubt to move forward. Defining consent creates better criminal justice systems. Our Supreme Court has specifically looked to our state statutes for a definition of consent, and it is appropriate for the legislature to now respond and clarify. We currently have no statutory definition of consent and instead use a standard of whether a reasonable person would believe that there was a lack of consent. The standard relies on physical cues to constitute consent, which is contrary to what we know about the neurobiology of trauma and victimization. A definition that takes into account the experiences of victims is critical. Tonic immobility, which is the freeze response, affects up to 70% of victims. This leaves them unable to speak or fight back due to their body's trauma responses. This neurobiological reaction has been studied and understood, but this lack of response is not enough to show lack of consent under our current laws. The word in this definitions were chosen very carefully. In my written testimony, I provide a further breakdown as to why these exact words were selected. But to highlight a few important points, our definition is inclusive of stealthing, which is a practice in which a condom is removed without the consent of both parties, as well as cases of misrepresentation and impersonation. It will also protect those who've experienced tonic immobility. Victims experience trauma after an assault, often compounded by societal shame and victim blaming. With this legislation, the response to sexual assault will not be to question whether a victim fought back or showed disinterest, but the sexual activity was consensual by both parties. The definition also provides a standard to go by in community education and prevention efforts. A standardized definition and consistent messaging would instill better social norms around consent. In order to all envision a healthy culture of consent, we must collectively and comprehensively define it. A definition will not shift a burden onto the defendant, and we are extremely confident that this would not be the outcome of this legislation. I would be happy to direct you to one of our attorneys from the Victims' Rights Center of Connecticut if you have any further follow-up questions, and she would be glad to address any questions about why there would not be this shift. Connecticut would not be alone in these important efforts. The states of Washington, California, Wisconsin, and Vermont each have a comprehensive definition of consent in statute, similar to what we are proposing. New York, Illinois, and Alaska are also currently pursuing this. We would like to add.
Your time is
Yes.
elapsed, Morris.
Great. Just to finish, we'd like to add Connecticut to the list of states protecting sexual agency and modernizing statutes. Thank you so much for your time.
Thank you. Representative Fishbein.
Yes, thank you, Mr. Chairman. Good morning, Bridget. How are you?
Good morning.
So I guess we should tell the kids at home to cover their ears because we're going to talk about some interesting aspects. I'm having trouble wrapping my arms around this language. I have to be clear here. We're specifically looking at lines 65 through 70 when we define consent. And I might understand that unless one achieves by a very high standard consent as defined in 65 through 70, somebody could be charged with committing a crime. Is that the application of this?
So consent is already obviously utilized in a variety of ways in current court proceedings, and this would create a definition for spaces where it's already used. But then as you refer to in lines 109 to 110, it would include not consenting to such sexual intercourse in the statute for sex assault too.
Sure. So one who does not, the question was if one does not meet the four corners of consent as defined in 65 through 70, they could be charged with committing a crime. You would agree?
Yes, no, that's correct. And
Okay.
We think that it's important to have this standard because at this point in time, there is not a standard that's actually utilized. And so it's really essentially up to interpretation of the specific judge, specific jury. But this is a standard that we believe is appropriate and has become the socially acceptable standard of consent.
Socially acceptable by whom?
So essentially, we think that most folks would be in agreement that consent is something that should be clearly demonstrated, right, by mutually understood words and actions, that everybody should be informed as to what actions they're consenting to and under, what conditions. This is something that should be made by free will. So we don't think that somebody should be intimidated or threatened into a situation where they're submitting to sexual activity because that, they feel as if the party is not taking no for an answer and they will come to harm if they do not consent. We also want to ensure that folks understand that a previous relationship that somebody may have is not grounds for consent, as well as that if somebody is not verbally resisting or physically resisting, that somebody say that is completely still and non-responsive cannot be seen as to be consenting. But unfortunately, as our current law is written and as consent is sometimes directed to juries, interpreted by individuals, unfortunately, we see that somebody who is completely unresponsive will not have any recourse under our current criminal law.
Okay, I mean, if we were in the courtroom, I would move to strike as being non-responsive. The question was socially acceptable by whom? I agree that nobody should be forced, coerced, you know, into a sexual act. I don't think anybody here thinks that would be proper activity. But lines 65 through 70, you said that definition of consent is socially acceptable. And I think you referenced a large group, and I'm trying to figure out what group has vetted this particular language to find it to be socially acceptable.
I appreciate that. And I just wanted to go through the language to ensure I talked about some of the social norms around consent. We did have a lot of input as we developed this, including from individuals and constituents throughout the state. We talked to students on college and university campuses. We spoke with legislators, with advocates who work with individuals, work with all parties involved in these cases. And we were able to come to this definition. This is also reflective of definition that's been successfully utilized in other states. So that was how we came to this conclusion.
Okay, so you're defining consent as the unambiguous, informed and voluntary manifestation of agreement freely given without use of force, fraud, or coercion by each person who actively agrees to engage in a sexual act. So when I look at those modifiers, unambiguous, informed, and voluntary, you're talking about contract. So you're talking about before two adults, because I mean, with a minor, it would already be illegal, right? So we're talking about two adults engaging in a sexual act. They would be contracting because it would have to be unambiguous, informed, and voluntary. How else do you prove that other than a writing that is signed to, perhaps notarized, to ascertain that? And that's part of what I'm having a problem with, because we know that even there are bad things that happen. There are sexual assaults that happen. I don't disagree. But this seems very high. And then we get to the second portion of the paragraph where it talks about prior participation. So it goes on to say prior participation by a person in a sexual act. So that would mean that you had a contract originally to do the sexual act, but that contract is no good anymore for this next sexual act because it's irrelevant. It's prior participation by a person in a sexual act, the absence of verbal resistance by a person to a sexual act, or the withdrawal by a person from such agreement, once again, contract, to engage in a sexual act do not constitute consent. So I don't know that this is proper, enforceable. I understand the intent, but I'm having a lot of problems with ascertaining, you know, putting someone in jail because they didn't get someone to sign a contract to engage in a sexual act. Appears to be where this is going. And
No.
please correct me if I'm wrong. We're here for the discussion, right?
Absolutely. No, and I appreciate you sharing your concerns so we have an opportunity to have that dialogue. We are definitely not concerned that it would come to a point where there would need to be such a formal exchange. We believe that it should be standard for parties to clearly demonstrate that they're actively participating in the sexual activity, to be communicating, verbally and non-verbally that they are, that again, they are an active participant in that activity, that they are doing so at their free will and not because they feel threatened or coerced into it, right? We think that it's important to consider as well that if somebody is to change their mind during an encounter, say they, went into that encounter saying that this is something they wanted to do, or earlier that night, they told that person that's something they wanted to do. We believe that everybody should have a right to change their minds about that, right? So that's why we talked about the ability to withdraw. And while I appreciate your concerns about these particular words, it doesn't need to play out in such a formal way, but rather through, demonstrated ongoing communication between two parties during a sexual act. And we believe that that should, be communicated clearly, but does not need to be communicated formally in the respect that you're speaking to.
Well, I respectfully disagree. I mean, because these claims of many of which are true of sexual assault don't happen before the act, it happens after the act. And for the most part, unless it's attempt to commit. And the problem is that how does one prove that there was an unambiguous agreement to engage in this act when one of the parties is claiming for whatever reasons that there was not? The only way you could prove it is a writing, attested to, notarized, and very troubling. I understand the underlying intent. I just don't know. What other states have passed this particular language?
So there is similar language that has been used.
Has any state passed this language?
So Washington, California, Wisconsin, and Vermont have all used some or all of these words.
Washington, California, Wisconsin, and Vermont have.
This has been passed. And then there's also ongoing legislation that's been shown significant support in New York, Illinois, and Alaska.
Okay. When you say have used this or similar words, why did one choose to change words that other states have passed? So nobody has passed this exact statute.
No, in fact, some states have passed legislation that is more prescriptive, but we wanted to ensure that the definition was something that was accessible and applicable to the experiences of Connecticut's residents.
Okay, and not to drill down, but I'm just trying to figure out in this sphere, how is Connecticut different from those other states?
Again, this is something that we spoke with advocates and constituents to ensure that there was collective support for this definition. So again, there is legislation that is more prescriptive, and we felt that this was appropriate based on the feedback of the folks that we had spoken with.
Do you have any statute numbers for those other states so I don't have to spend a day researching?
Not at the moment, but I do have that information on hand and we'll be happy to follow up with you today.
Yeah, sure. If you could just email that to me, that would be very much appreciated. So, thank you. Thank you, Mr. Chairman.
Thank you. Representative Paul.
Good morning, Ms. Kessner. It's good to see you. Thank you for being here. I have just a couple of questions. Following up with this theory that my colleague brought up about a contract, I would argue that a social contract is an implicit agreement in a civilized society about each person's duties and responsibilities toward one another, which I think is inherent in any kind of sexual encounter. Would you agree with that?
Absolutely. And I appreciate, your view on that, because we would, I would say the same based on, the way that consent already operates, right? There's already exchanges of words and actions that individuals engage in to show that they do not have consent. We're not imagining that there would suddenly be folks that, believe that they didn't achieve consent in an encounter. So much as we understand that there are already many folks in the state that are coming to us for help, attempting to seek recourse in the criminal justice system because, say, somebody removed a condom without their consent, and now they have found out that they are either pregnant or have an incurable STI, right? Mm-hmm. We find out that there are people who their college roommates, their college roommate's boyfriend snuck into their bed in the middle of the night. They believed it was their own partner, began to engage, and then upon realizing it wasn't that person, immediately stop the action, but then have no recourse. We have individuals who have had the same experience, but it was their partner's twin. So these are all situations that folks are already facing, realizing that, as you had stated, the social contract of consent had not been achieved. However, because it is not written in our state statutes, they do not have recourse to achieve protections within the criminal justice system, nor do we have the ability to address the concerns of public safety with these individuals that might be repeatedly, committing these types of offenses.
So is this different from affirmative consent, or does it grow out of affirmative consent?
So we looked at some affirmative consent statutes, namely the affirmative consent statute that is in the higher ed legislation that we passed in 2016 for college and university campuses in Connecticut. That statute is highly prescriptive, and we wanted to ensure that, again, this was something that was sort of a compromise between such prescriptive language, but also was clear in what was expected of individuals and not left to the level of interpretation that we find consent already is in the state of Connecticut through, court cases and conversations in criminal justice sectors and things of that nature. So while there are some similarities between the two statutes, if you were to compare the two, you would see that this is less prescriptive, which allows more space for discussion, but without it being entirely up to interpretation.
Okay. And then finally, the part about prior relations is really to ensure that victims aren't assumed to be compliant because they used to be married or dating somebody and had once had consensual relations, but no longer wants to. Is that correct?
Correct. Yeah. So we find that survivors are often harmed by people that they might have had a romantic or sexual relationship with in the past. Unfortunately, that's something that happens frequently, but we believe that everybody should have a right to change their mind as to whether or not they'd like to be in such a relationship with somebody. And we believe that nobody is entitled to somebody's body to believe that just because they'd had a sexual relationship or even still do, that means that they should have a right to have sex with them whenever they should want to.
Okay, thank you. Thank you for coming before us today. That's it, Mr. Chair. Thank you.
Thank you for your questions.
Thank you. Representative Blumenthal.
Thank you, Mr. Chair, and thanks, Ms. Kessner, for being here with us today and for your testimony and answers on this bill. I just had a couple questions. First of all, I just wanted to say that, I don't necessarily, first of all, I support the intent of this legislation, and I hope that we can move it forward. I think that it's important to account for what I agree to be the social norms, modern social norms around sexual activity and consensual sexual activity, especially. One question I did have is, I think some people might be concerned that the fact that this law would require essentially an affirmative manifestation of consent would perhaps shift the burden of proof from the state in a criminal proceeding to the defendant to have to prove that that manifestation took place, and that could have constitutional problems. So I guess my question would be, are there elements of this bill that account for that? Is there precedent that we've seen from other states for how it's been dealt with on this issue?
Yeah, and I appreciate that question. I would be glad to get back to you with more information because we did ensure that we were consulting with attorneys and looking into how this was impacted in other states and the constitutionality of the issue through this process. So that was something that was strongly considered because we understand the need for and appreciate fair processes for all parties involved. So that's definitely something that we did consider through this process. As I had stated in my testimony, and can go into further, we do have attorneys from the Victims' Rights Center of Connecticut, which is our legal program. And one of those attorneys has been able to provide a lot of really helpful feedback as to how this would not shift the burden. So I would be happy to connect her with you to provide that answer, as well as for anybody else on the committee that may have any questions or concerns about that issue.
Okay, I appreciate that. And I don't mean to put you on the spot, but are you aware of any of these states where the law has been struck down for this reason or any other reason?
Sure. So in doing research, I did not come to, I didn't find anything suggesting that there was any legislation that had been struck down or even necessarily any significant strong opposition. The reason that this was introduced in other states, for the most part, was because there was a pressing need that was noted. For instance, in New York, this came in the wake of the Harvey Weinstein case and a lot of questions around consent that came up during those court proceedings, including Harvey Weinstein stating that he was confused about what consent was. And that most men would be confused about what consent was. So the state of New York felt that there was a need to clarify following that. And so advocates have been pursuing this with strong support. There's also been bipartisan support, in other states where this has already passed. But we have not seen any strong resistance in other states, I would, again, be glad I did provide links for more information in my testimony to those other states in their language, as well as some information about that process.
Thank you. I appreciate that answer is very helpful, and I'll be sure to look through your testimony. Additionally, I had a question about the term informed in subsection 14. I think that there are cases where we would absolutely all agree that a deception essentially on certain matters like the identity of the person or whether they're wearing a condom should make someone criminally liable. And I guess the question is, how broadly do you see that term defined? And what kind of, is there a materiality requirement? How is there any precedent in other states or here where we would see what that term means and what the limits of it are?
Sure. So this was included for essentially to encompass three different issues that we've seen, here in Connecticut. One being, as you stated, and as I mentioned earlier, the issue of stealthing and non-consensual condom removal. We see cases where somebody will, essentially impersonate another party. And then we'll see cases where an individual will completely misrepresent themselves. They'll lie about what their name is. They'll lie about some important information that may change as to whether or not somebody would like to engage in a romantic or sexual relationship. So for instance, somebody who has committed multiple instances of sexual violence against a child, maybe in a relationship with somebody who has multiple children. This is somebody they allow in their home and will continuously have a romantic and sexual relationship with. But then it comes, it will eventually, unfortunately, individuals will find out that the person who has been essentially living with them was lying about their name, lying about their background, lying about their job, and lying about a lot of different aspects of their life, including what they had previously done, what they may have been doing in their home. And so they might essentially create an entire alternate personality. So essentially what we're concerned about is a rather high standard, which is a condition that is so significant that it would essentially be inarguable that it is something that somebody would have a right to know before consenting to a sexual act with a person, which is essentially just that person's identity, generally being shared or not misrepresented, right? As well as, somebody who is or is not using something that will impact a person's physical health and well-being, such as condom use. So it is rather specific in how it would be applied, rather than it being something more general. Because again, we understand that we want to ensure that this is something that is according to social norms. And I think the situations that I just shared, most of us could agree would be something that would be inappropriate in our social norms and something that any person would want to know before engaging in a sexual act.
Appreciate that answer. And that was how I understood it as well. If people had concerns about the scope of what informed meant, would you have any objection to us defining it? I don't see it being defined here in the statutory language that we see today. But would you have any objection to us defining it in terms that are roughly what you just listed?
Personally, I would be happy to provide any input that I could to ensure that the definition would align with what our concerns are. So I would definitely be happy to engage in further conversation and find a compromise if need be.
Thank you very much for your answers and your testimony. And thank you, Mr. Chair.
Thank you very much.
Thank you, Representative Fishbein, for the second time.
Yes, thank you, Mr. Chairman. The questions and answers open up other questions and answers. Am I to understand the intent of this? Two adults engage in whatever this informed consent means. They say they're going to have intercourse, and during the course of the sexual act, let's say the male has an intention of getting the woman pregnant, removes his condom. That is bad acts, all that stuff. It is the intent of this language to prevent or to make that action criminal. Is that what I heard?
Correct. So if somebody were to remove a condom without the knowledge and consent of the other party, that's something that we see happen, and it's called stealthing, and it's done in a way to ensure that the party doesn't know that it is happening. So it is purposefully attempting to deceive them after they had agreed to that sexual act under the impression and understanding that a condom would indeed be used through the entire act.
Okay, so can you just point me, because it seems in line 67 that they're agreeing to the sexual act in its advent was appropriate and not actionable. But at the time that the condom is removed, it changes the nature of the sexual act into something criminal. Right, and I don't see that in the language. It doesn't appear to change. Where is the connect with this language as far as meeting that intent?
Well, essentially, when we talk about on line 69, talking about a withdrawal from such agreement to engage in a sexual act, right? So if there is a condition that were to change it so significantly, somebody consenting to having sexual intercourse with or without a condom are two very different actions, especially considering, again, in knowing these cases from the survivors that we speak to, this is an act that is done very intentionally in a way to deceive the victim in that case. So if there is a condition that changes so substantially, that is really going to change whether or not somebody would have consented at the advent, of that act, then we believe that somebody should have a right to have input as to whether or not they would like to continue to engage. If somebody were to ask whether or not they could remove the condom and that party to say that it would be all right, then that would be one thing. However, we're talking about cases where this is done without even notification that this is happening.
So then utilization of a condom is a physical act that one can ascertain right then and there. I guess under the language here, if a woman told a man that she was taking a contraceptive and she was not, that also would be a criminal act for the same reason.
That's not a problem that we've seen as much in the state, but I would be happy to look at the way that the language would apply to other situations.
Well, I'm troubled by that. So you would only have this apply to males that remove condoms, but not women who don't tell the truth about their contraception.
We created this legislation in mind with the issues that survivors come to us with, the issues that we see victims reporting about. This is the situation that you've explained is not necessarily one that we've have had concern about to the extent that we have the issue of non-consensual condom removal being something that's frequently reported, but there's no recourse for. Again, I would be glad to discuss different ways that this could apply. However, we are definitely most concerned with the ways that this actually plays out in encounters, between individuals as it stands.
Well, I understand, and I'm here to protect all individuals. I just point out that, whether one has a condom on or not, one can physically tell for the most part, but whether one's on the pill, one cannot tell. So if anything, it's easier to hide that. So, but the other thing is, in answer to Representative Blumenthal's question, am I to understand that unless both parties share their resumes, credit scores, those kinds of things, that is not informed consent for the purposes of this legislation?
No, that is not what we would be saying at all. It would not require that sort of level of understanding another person's identity. The issues that we're talking about are ones that would substantially change whether or not somebody wants to engage in a sexual act. This also we would want to include ensuring that individuals are able to consent to one type of sexual act, but still have boundaries against what other type of sexual act that they would like to engage in. So if somebody says that they would like to have oral sex, but not penetrative sex, that there's something that there is space for some nuance for. So between that nuance, as well as understanding that, again, I think it is socially acceptable, for most of us to imagine we would want to know whether or not, if a partner were to remove a condom, if a partner were completely lying about, who they were as a person, right, and their identity. I think that that's something that a reasonable person, right, would want to know and understand about their partner. Again, we see these as tools that are purposefully utilized to, to get somebody to engage in a sexual activity that they would not have consented to had that information not been misrepresented. So we're not talking about, understanding everybody's aspects of their lives to that extent, so much as the information that anybody would want to know and not want to be misrepresented before engaging in an activity.
I understand. I'm just trying to figure out where that line is on informed, and I will not continue. So thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Senator Flexer.
Thank you, Mr. Chair. Good morning, and thank you for your testimony today. I just wondered if you could step back for a minute and talk about the victims that you work with and advocate for, and your colleagues. If you could talk about, what their experience is when they come forward and they know that something wrong has happened to them, and yet they look at the law and they see something that doesn't fit their circumstances. Could you just talk with us a little bit about that?
Absolutely. It's definitely a challenge that we find that survivors have. Unfortunately, I think a lot of the ways that the statutes have been interpreted, because there is no definition for consent, the way that we often see it interpreted is that that person did not fight back, right? But unfortunately, we know that the majority of survivors of sexual violence are actually physically unable to fight back due to the way that their neurobiology responds to the trauma that is currently occurring to their body. It's a way that their body is protecting itself from this trauma that it's experiencing. And it's a normal biological response. However, when survivors then maybe attempt to, report and aren't having the response that they need, or they are, cross-examined on the stand in conversation with individuals in the criminal justice system, they find that they're instead asked about what level of resistance they showed and have to essentially prove that they showed a significant level of resistance, when realistically, that's just not how this works. But unfortunately, it leaves them often believing that what happened was their fault, that they should have fought back even though they were physically unable to. And unfortunately, that doesn't protect, the majority of victims, including individuals, right, who might have been incapacitated by drugs or alcohol, or individuals who do not have the physical ability to physically fight back against the person who is harming them. So we definitely find that it creates a great deal of trauma for survivors to feel blamed in this way. They already unfortunately go through so much victim blaming through society as it is. And then to experience it when they are attempting to reach out for help, protection, reprieve from what has occurred. It's just, quite frankly, further re-traumatizing to them. So we are definitely hopeful that this language would create a standard that speaks to their experiences more accurately, and therefore would not be as re-traumatizing as they're engaging in the system for that sort of assistance.
Thank you. I appreciate that. And when we have these conversations in the legislature on when we're talking about sexual violence, there's often some frustration by people that victims don't report to law enforcement faster. So can you talk? I think you've already explained this a little bit, but can you talk a little bit more about why this change might actually give people an avenue to report that they clearly, given what you just said, don't feel like they have right now?
Definitely. So hopefully in seeing this definition, this would be something that survivors can definitely identify with and say, okay, this standard was not met in my sexual experience. But of course, if somebody is going to the extent that they're looking for that type of definition, right, it is likely going to be because this did occur to them and they're attempting to see if they can achieve help. Realistically, somebody who identifies with this or does not can still go to the criminal justice system for assistance, but being able to explain that the standard of consent was not met when they came forward versus attempting to explain why they did or did not fight back will definitely change whether or not somebody wants to continue to engage in that system, depending on who they're speaking to and how much support that they have. We'll see individuals come forward to, a police department to report and then choose never to engage again because of the way that they were asked about their experience. So I think ensuring that there is, language that they can use to describe it, as well as a common language, right, that they can kind of engage in that dialogue about with other parties that are involved in the interest of protecting them, such as law enforcement, prosecutors, folks like that. It ensures that they sort of have the ability to share what happened without having to explain why they didn't fight back. So I think in that respect, they would definitely feel more comfortable continuing to engage. We're also really hopeful and genuinely do think that creating this standard and kind of taking away some of the politicization we've seen around consent it being up to interpretation to such an extent that it can be misinterpreted and then be utilized in a way that's harmful, we're hoping can really inform prevention efforts and our community education efforts so that this definition and this understanding will really become, even though, again, it's something that I think many of us here would understand as the social norm, will in clear language be shared with youth and with individuals in different communities as a social norm, so that we do begin to understand that it is never a survivor's fault when they experience sexual violence, and we cannot put the expectation on survivors to physically fight back or verbally resist, and that is instead the responsibility of others to ensure that they are always obtaining consent.
That's great, and I really do think that's the goal, is how do we change these social norms so we don't have as many victims, we don't have as many people enduring this pain and running into a system that isn't built to respond to what they've just experienced. So thank you very much for your time and your testimony this morning and your advocacy. Thank you, Mr. Chair.
Thank you.
Thank you, Senator. Comment or question from other members of the committee? Comment or question? Do you think I'd be better at letting them say thank you first? I don't see any. Thank you very much for your work and for joining us this morning.
Thank you so much for your time.
Next, we'll hear from Tonya Hughes, then Cheryl Sharp, and then C. Marcella Karowski. Ms. Hughes.
Good morning, Senator Winfield,
morning.
Representative. Good morning, Representative Staffstrom, Representative Fishbein, Senator Kissel, and members of the Judiciary Committee. I'm Tonya Hughes. I'm the Executive Director here at the Commission on Human Rights and Opportunities, and I'll be combining our testimony, and both Cheryl Sharp and I will be available for questioning following my edited and summarized version of our testimony. Okay, thank you. As the state agency, we're testifying on SB 5, an act concerning AAC online dating operators, online child grooming and harassment, domestic violence training and protections for victims of family violence and domestic violence. As the state agency responsible for eliminating discrimination, we believe this bill is crucial for fulfilling that mission. It essentially serves to protect victims of domestic and family violence from being fired, evicted, or denied credit just because of their status as a victim of domestic or family violence. This bill permits victims to obtain a reasonable accommodation at their jobs, to address consequences of the violence, such as time needed to relocate, attend court hearings or medical appointments, while also educating on how to spot domestic and family violence and the assistance that is available. It eliminates loopholes that perpetuate discrimination against domestic employees who are primarily lower income women of color who work as domestic employees for very small employers. This bill covers them under the anti-discrimination laws and provides them with necessary and critical sexual harassment and domestic and family violence training. And currently they have zero protection under our statutes. Because elected officials or members of boards or commissions are not currently considered employees and therefore not required to receive training about sexual harassment or subjected to discipline for harassing other employees, this bill eliminates the loophole that ties governmental employers' hands and requires accountability. It increases safety in the workplace by eliminating the requirement that sexual harassment be severe and pervasive and substantially interfere with an individual's job because it is actionable. Courts have interpreted the existing law in a way that leaves many victims of harassing conduct without protection. We believe any degree of harassment is unacceptable. And finally, it reminds employees that they retain the right to file complaints of discrimination with the state or federal agencies, CHRO and EEOC, if they are subjected to discrimination, even if they resolve those complaints with the employer. And so I'll end here, and I see the timer is on, and we'll take any questions that you have.
You ended and the timer's hand went up. Perfect. Comment or question from members of the committee. Representative Fishbein.
Thank you, Mr. Chairman. Good morning.
Good morning.
So in this language, what is the definition of status as a victim of domestic violence? What is that?
I'm going to allow Director Sharp to answer that. And she needs to turn her mic on. We have discussed the distinctions between domestic and family violence, and that's what she's providing me with.
Good morning. So in response to that question, I'm trying to, there's a distinction between a domestic violence survivor and then the family of that survivor, including the children. So family violence would be against the individual and the children, and the domestic violence would be violence against the individual adult who is being subjected to the violence from their partner or their spouse.
Okay, I'm just looking for the definition of family violence, though.
Go to line 375. I think that's where it is. Family violence has the same meaning as provided in section 46B 38.
38A. So, which I think something is domestic violence. So, but I'm just okay. So 46B 38A. Family violence means an incident resulting in physical harm, bodily injury, constitutes fear of imminent, but not stalking or pattern of threatening between family or household members. Verbal abuse or argument does not constitute family violence unless there is a present danger and the likelihood that physical violence will occur. Okay. So in order, does one have to file for some sort of protection from our courts to be and I just want to use the same language that's in here, to maintain a status as a victim of family violence? How does one prove that they have a status of family violence?
One could prove that they have a status of family violence by police reports, by their notification to the police by contacting them. They could have a police report. There may be something related to their trying to get protection, but also the definition is broad as well, because some individuals fear going forward to the police will create even more harm for them. So in looking at victims of family violence or domestic violence, if we look at the black letter law of the definition that is provided, I think that is instructional as to how it's defined and how a person could establish their status as a victim of family violence.
Okay, well, I don't think anybody, based upon, so a police report might work, but it might not work because some people are fearful of going to the police. So a police report is not a determination that a bad act has happened. It is merely a report of some sort of contact with the police. So the question is, how can one who is potentially given credit, one who is potentially given housing, be held to a standard without some sort of document, right? And people apply for restraining orders, people apply for, complain, and cases are investigated and they are found to be unfounded. So I'm just trying to, we have this term, status as a victim of family violence. How does one prove that so they can say to the one who is, potentially giving them credit, potentially giving them housing, I have a status, you need to do this, otherwise CHRO is going to be on my neck. I mean, how do we prove that?
Well, thank you for your question. I don't feel like the CHRO is on anyone's neck. We, take the cases that come before us and we, investigate them. And I would like to, it's not just going to the police. There could be medical documentation of physical abuse. I'm saying that there's more than one way to show that an individual is the victim of family violence. But I think if I draw your attention to lines 571 to 579, that may be the most instructive, because there is a list of items that can be provided to an employer when an individual is claiming that they're a victim of family violence. So it's a police report, it could be a court order of protection, it could be documentation regarding, from a medical provider, It could be the police report. It could be other evidence. It's had some broadness to it because not every victim of violence is going to report the conduct in the same way. Some people may feel more comfortable reporting what's happening to their medical provider as opposed to the police and getting a police report, which is what I was trying to express earlier. But I think that this expresses it more broadly in a way that maybe is more instructive.
Okay. So are you aware of the procedure to get a police report for a domestic violence case that is currently in court?
I am not a criminal, lawyer. I have a basic knowledge of what you need to do in order to get a police, that you would contact the police and let them know what's going on as a citizen, but not as a criminal attorney, because that is not what I do. What I am is a civil rights attorney, and so these cases are brought to our attention, and this documentation is provided. It would be evaluated, analyzed, and in the whole scheme of the case that is presented to us.
Okay, so my experience has been that cases that are not closed, that are open, they will not release the police report other than to, even the police report, the arrest warrant you could get if you have an appearance in the case as a victim, but that you can't get the police report, especially in these cases. I would expect that this is at the advent of a case. Arrest has just occurred. Somebody doesn't have the ability to, let's say they don't have access to money. They need to get some credit or something like that. That it would be extremely difficult to get a police report, most especially if the person, first time incident, and the person's going through the family violence education program. A court order protecting or separating the employee or their child from the perpetrator. So if the child of the employee is the victim of family violence, and not the employee, these protections would extend also. Am I reading that correctly?
Yes, in the same way that if a child has COVID and the parent doesn't, that the parent would get leave from work to take care of their child if they are a state employee. So this is not a unique protection. We have it in other contexts as well, where a parent has to take care of their child who is suffering some, whether it's physical harm because they got hurt, whether it's a medical condition, or whether it is, part of the pandemic and they end up with COVID. We offer opportunities for that parent to take care of their child. And that is what this language is attempting to do here, is offer that same type of latitude to parents to take care of their child if the parent is not the one who caused the injury, because they are the actual abuser. So I think that it is a thoughtful approach to dealing with children who are the victims of family violence.
Well, that statement would lead me to believe that you need some sort of full adjudication to rely upon this, because sometimes there's allegations against both parents in the context of a DCF investigation. So that would mean many things, but under the present program that individuals are allowed time off if their child has COVID, that's not by virtue of something like this, right? That's by virtue of the family medical leave, the paid family medical leave, those regulations and statutes, correct?
It's not the same statute. What I am doing is drawing a juxtaposition to situations where parents need to take care of their children because their children have some physical, it could be mental, it could be viral condition, and the parent needs to take care of their child. Here, we're talking about family violence. We've already heard from advocates about the debilitating nature of family violence on children and how it impacts and affects the family. And so this language is to provide the latitude necessary for a parent to take care of their child who is the victim of or alleged victim of family violence by a parent who is not the perpetrator. And so that is the intent of the language.
Yeah, I understand domestic violence, family violence impacts families, but we're just talking about this language, and the question had to do with under that current leave for COVID is taken under family medical leave and those similar programs, correct?
That is correct.
Okay, so why wouldn't that individual be able to avail themselves of family medical leave for the purposes similar to what is done for COVID?
There could be an instance where they could do that, but all of the time we have statutes that are proposed to shore up in a particular area protection, and that is what is being done here. Family violence, domestic violence is a unique circumstance and a unique type of exposure that kids have to that adversely affect them physically and mentally, and so this language is to address that. I just gave that as an example to show there are other instances. I'm not saying that it is within this statute where we are giving latitude so that families can take care of their children, so that parents can take care of their children who are exposed to some type of medical, physical, or mental harm. And this is a similar, approach.
And this is in addition to any time that they would be available to them under the family medical leave program, right?
Potentially.
Well, what is it? I mean, would they have to exhaust their family medical leave days and time before they avail themselves of the reasonable accommodations that are outlined in this bill?
Presumably not.
All right, Mr. Chairman, I have no other questions. Thank you.
Thank you, Representative Fishbein. Comment or question from other members of the committee? Comment or question? If not, thank you for joining us to explain. It's really important that in a timely way, the things that are needed for the victims, they can avail themselves of. And my hope is that as we move forward, if we don't have it quite right, we figure it out before the end of the session. Thank you.
I agree. When we're able to avail ourselves to you if you need us.
Absolutely. Thank you.
Thank you.
Next, we will hear from C. Marcella Karowski, followed by Lindsey Jones and Rhonda Mora. C. Marcella Karowski.
Good morning, members of the committee. I'm Marcella Karowski. The first initial is not necessary. It's just to distinguish myself from other family members with the same name. Thank you for the opportunity to speak today. I support Race Bill 5468 because inappropriate communication from an adult to a minor must be illegal. I pray that upon the passage of this bill that sexual grooming and abuse will be prevented. Thank you for your time and consideration.
You caught me off guard. That was quick. Comment or question from members of the committee? Comment or question? Representative Fishbein.
Thank you, Mr. Chairman. Nice to see you again, Christine.
Thank you.
I do once again apologize. You did sign on Friday.
Oh, no. No fretting.
My fault.
No.
I know you're my constituent, and I thank you for being very active on these issues that are very important to you and to us. And have a good day. Thank you.
All right. Thank you, Representative Fishbein.
Thank you, Representative Fishbein. Comment or question from other members of the committee? Comment or question? Seeing none, I almost feel bad about telling you to come back today as quick as your testimony was.
No fretting, Senator Winfield. Thank you so much.
All right. You enjoy the rest of your day.
You too. Thank you, sir. Bye-bye.
Lindsey Jones, followed by Rhonda Mora, and then Andre Mcguire. Lindsey Jones, you may testify.
Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. My name is Lindsey Jones. I am the Advocacy Coordinator at the YWCA New Britain Sexual Assault Crisis Service, or SACS. I am also a survivor of sexual violence, and I am here to speak in support of HB 5472, an act concerning sexual assault in the absence of consent. SACS is a member center of the Connecticut Alliance to End Sexual Violence, and our role is to provide free counseling and advocacy services to survivors of sexual violence, including prevention education, and I appreciate the opportunity to share my perspective as a direct service provider. In our prevention work with high school and college students, we use an acronym to explain affirmative consent, FRIES. This acronym empowers everyone who participates in a sexual encounter of any kind with all the information they need to know about consent, and it goes as follows. F, consent is freely given, which means a choice made without pressure, manipulation, or the influence of drugs or alcohol. R, reversible. Anyone can change their mind at any time, regardless of whether they had previously consented or engaged in a sexual act. I, informed. If, for example, someone promises to wear a condom, the moment they remove that condom without permission, they are violating consent. E, enthusiastic. Everyone should be excited about what they are doing, and sex should only happen when that enthusiasm has been communicated between partners. And finally, S, specific. Saying yes to one thing, like for instance, kissing with no clothes on, does not imply consent for another thing, like penetrative sex. The definition of consent proposed in this bill would codify in more specific legal language the definition of consent that we teach children across the state. As the law stands now, consent is subjective. For survivors, that means that law enforcement and prosecutors may fall anywhere along any spectrum of what they believe to be consensual sex. This range of understanding can be affected by myths and a lack of understanding of how trauma affects the brain and body. A lack of consistent definition continues to perpetuate rape culture and prevent survivors from equal, consistent access to the criminal legal system. In my time providing advocacy and counseling to survivors of sexual assault, I cannot begin to count the number of survivors who have, while sitting in a hospital bed, only hours after experiencing a horrific, traumatizing assault, tried to convince me that they were really to blame because their bodies had frozen during the assault, thus rendering them unable to physically fight back. This trauma and self-doubt is only compounded when they report an assault to the police and are dismissed or even explicitly blamed for allowing an assault to take place. Existing systemic inequalities of race, class, sexual orientation, and gender add to the inconsistent treatment faced by survivors who cannot provide evidence beyond a reasonable doubt that they physically fought back. The reasonable person standard currently used in Connecticut leads to victim blaming and further traumatization of survivors who choose to engage in the criminal legal system. In addition to providing clarification for law enforcement and prosecutors, a definition would make the process less traumatizing to survivors whose cases do make it to court, precluding them from having to argue over whether they truly fought back or being questioned as to how they could have tried harder not to be raped. I urge you to please support HB 5472. Victims and survivors deserve to be believed, and they deserve the clarity afforded other victims of crime. Thank you for your time and consideration.
Thank you. Very good on the timing. Comments or questions from members of the committee? Comments or question? Seeing, I want to thank you for your work and for joining us to testify on the bill today.
Thank you.
Enjoy the rest of your day.
You too.
Rhonda Mora, Andre Mcguire, Catherine Vareno. Rhonda Mora.
Good morning. Morning, Senators Winfield, Flexer, Kissel, Representatives Staffstrom, Blumenthal, and Fishbein, and members of the committee. I am Rhonda Mora, the Director of Legal Advocacy at the Connecticut Coalition Against Domestic Violence. We are a member organization comprised of the state's 18 domestic violence agencies. I am testifying today in opposition to Section 1 of House Bill 5467. You have my written testimony, so I will summarize quickly. We have concerns with a provision that would require family relations to disclose confidential information to a defendant and defendant's counsel, information which is currently protected by statute. This proposal will have a chilling effect on victims of domestic violence and set victims' rights back decades. The practical impact of the proposal is that victims will either elect not to share information or be cautioned against sharing information to those making recommendations and decisions about the abuse they suffered, as the information they believe to be privileged under 52-146A, in fact, under this proposal, be subject to being disclosed to the defendant and defendant's counsel. The most dangerous time in an abusive relationship is when the relationship changes, whether this is by choice to leave the relationship, divorce, or arrest. A victim's fear is also high at this point. Fear of retribution, fear of the consequences of having finally disclosed personal information, and fear that the abuser will blame the victim or the arrest, and the consequences will be much more significant. The proposal will impact arraignment, which takes place the day of or the day after an arrest, one of the most potentially volatile times. Emotions are high. There may be physical injuries to overcome. The victim may or may not be able to attend court. The process allows for an FDBA to obtain information to relay to family relations with authorization for the purpose of consideration by the judge. Under this proposal, the information will now be turned over to the defendant. Is it a balancing test of rights? It certainly is. Our own state constitution recognizes the rights of both victims and the accused in criminal prosecution. Victims have the right, among other rights, to be reasonably protected from the accused during the criminal justice process. Section 1 of House Bill 5467 negates that right, because they will only be reasonably protected if they remain silent and refuse to provide information that is statutorily protected. Victims will be placed in a no-win situation, refuse to provide information and suffer the abuse in silence, or disclose and suffer the repercussions when those statements are put into the hands of their abusers hours after their arrest. The court will also be at a disadvantage, as judges will also have little information beyond what is in a police report. They will not have the information on the relationship history or past abuse information. We urge you to prioritize victim safety and safeguard the critical protections that this body has put in place over the years for victims of domestic violence.
Thank you very much. Representative Fishbaum.
Thank you, Mr. Chairman. Good morning, Rhonda. Nice to see you. Rhonda, you referenced 52146A. And that actually doesn't, that's been moved. It's 146D, just to orient here.
I'm sorry, I pressed 146K.
Oh, K. Okay, yeah, you're getting a little static on your, okay.
My apologies.
No problem at all. And I'm trying to figure out what portion of that intake would be privileged. So can you just give me an example, because I've done these cases in, representation of victims, not as a prosecutor, but, hand holding through the process as well as defending. And I'm trying to figure out, can you give me a scenario of information in one of these reports that you would claim to be harmful if released and is therefore privileged as contemplated by the statute?
So the ICR, or the individual case report, as well as the SRI, supplemental risk indicator, both have information that would be either personally identifying information, releasing a victim's current whereabouts, specific statements about the relationship history and past abuse, information on the services that the victim has received from the domestic violence organization, or mental health services or medical services, and the victim's specific safety requests related to any restrictions that may be placed on the defendant via protective order. I think that the protection statute actually calls for any information shared with the FBVA in the course of doing their job as confidential.
So, yeah, I can understand the address issue, right? Because you run into that with restraining orders, is that there's a process to seal one's address. But I would think that the other information, while privileged in the HIPAA context, may be helpful to both sides and disclosable. For instance, victim has seen psychiatrists for the last 10 years and has complained about domestic violence, right? That testimony may be helpful to the prosecution in that case. On the other hand, lack of treatment, seeking some sort of help may be helpful to the defense. So I'm just trying to get through the privileged aspect and balance that with the due process also, right? Because ultimately, in some of these cases, there's a trial, and one would want to know and be able to prepare. So why is it fair to the prosecution? And these reports are seen by the judge also, without the accused seeing this. Why is it fair for the prosecution to have access and the court to have access to information that may be testified about at a trial and not the accused?
I think it is a balancing test, as are a lot of these things. And as a zealous advocate of the victims of domestic violence, I am asking that those scales, when there is an existing privilege protected by the statute, that those scales tip in favor of a victim. They have a right under the statute to keep that information confidential, and they have a right to be reasonably protected in the criminal justice process. I understand it's a balancing of rights.
So when we balance those rights, as I said before, I can understand the address thing, right? Because we need to balance the ongoing protection of the alleged victim, because innocent until proven guilty and all that stuff, right? It's during the adjudication of this case that's going on. So if we had a procedure to redact the address of the individual, I'm sure that would be of solace to you, but you're asking us to go further and just not disclose anything that's in that report, no matter what.
I'm asking that the privilege that's statutorily provided to victims is honored.
Understood. Okay, thank you. Thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Representative Palm.
Thank you, Mr. Chair. Good morning, Ms. Mora. I have a quick question about something interesting in your testimony on the second page. You said that information that the defendant is also aware of and should disclose to their attorney, and that this shouldn't obviate the need for the victim, to have to disclose things in the past, given that there is usually a history of this before the actual incident is brought to the court. Can you expand on that a little bit, please?
I'm sorry, I'm having a difficult time hearing you.
Oh yeah, same back at you. Well, I was asking if you could explain in your testimony the part where you said that the history of abuse often precedes the incident that brought the action in court. Could you hear that?
Most victims of domestic violence do not report every incident of domestic violence for a myriad of reasons, whether it's systemic bias, whether it's fear of retribution, whether it's embarrassment. So there generally is significant domestic violence and incidents of abuse before the police are ever called. And those incidents are well known to the defendant, and the defendant can certainly make them known to his or her counsel. So it's not as if that information is not available from another source, being the defendant, him or herself.
Right. Okay. Thank you. Thank you for that clarification. And you also talked a lot about, in your testimony, the importance of building trust with the victim's advocates and the victim. How would such a disclosure of these reports change that?
Well, there would be no trust It's very difficult to say to a victim or any person, what you tell me is confidential, whether that's as a lawyer, whether it's as a doctor, whether it's as a psychiatrist or an FBBA. The information you provide me is confidential. I will protect it. I am obligated to protect it unless you tell me I can release it. And then you said, but I have to turn it over to the defendant. I have to turn it over to the defendant's counsel. So that creates a situation where the victim is placed in the position of either disclosing and risking that being shared with the defendant, or keeping that information to themselves so that it isn't disclosed.
I see. Thank you. Thank you very much for your testimony. I appreciate it.
Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? If not, Ms. Moore, thank you for joining us today and providing us with your testimony. Thank you. I'll now turn it over to Representative Stafstrom.
Thank you, Mr. Chair. Next up will be Andre Mcguire. Andre Mcguire with us. Oh, Catherine Vareno. Ms. Vareno, whenever you're
Good
ready.
morning. Hello, good morning, Senator Winfield, Flexer, and Kissel, and Representative Stafstrom, Blumenthal, Fishbein, and other members of the committee. I'm Catherine Vareno, the Chief Executive Officer of Safe Futures, serving the 21 towns of all of southeastern Connecticut, and a member agency of the Connecticut Coalition Against Domestic Violence. In my 30 years with Safe Futures, I spent 20 of those years in the Family Violence Intervention Unit of the Criminal Court as a family violence victim advocate. In that capacity, I interviewed thousands of victims immediately after an arrest and throughout the court case. I have serious concerns with Section 1 of House Bill 5467. Provide a copy of any written report that has been prepared for presentation by the family relations of the court at any stage of a criminal proceeding. This proposal will impact the victim participation in the criminal justice system, as well as victim safety, or even worse, silence victims from speaking with or trusting any of the agency's program advocates. While information in the possession of the advocate is privileged, information currently shared between the advocate, victim, and the family relations counselor may become the subject of disclosure under this proposal. The advocates provide a range of services to victims involved in the criminal justice system, and my concern is privileged communication between the victim and the advocate. This requires advocates to explain to victims that the only way they can share information with court on behalf of the victim is through informed, short-term, topic-specific, time-limited consent. When a victim does provide informed consent to the advocate provides information to the family relations counselor the specific purpose of enhancing safety to the victim and the family. Disclosing victim information to the defendant and the defendant's counsel would substantially increase a victim's risk of further violence immediately following an arraignment. It is rarely easy for victims to trust individuals or systems, and often it is not even the victim who called the police. It may have been a neighbor, maybe a child in the home called, which would also put the child at risk of retaliation. Research tells us there are multiple incidents of violence in the home before police are ever involved. Victims are often threatened by an abuser that if they call the police or talk to the court, they will kill their family pets, harm or take the children, burn down the home, threats of suicide, and other manipulative tactics to keep a victim under their control. I can tell you in my 30 years in this field, I have seen abusers carry out these threats too many times. When a victim can finally speak to an advocate following an arrest, we ask them to trust us to provide all the information that the court will need at that arraignment to keep them safer and their family, including a history of abuse that, as I said, in most cases far precede the event from the previous day. If this bill is passed, it will be detrimental to victims. Thank you for your consideration.
Representative Fishbein.
Thank you, Mr. Chairman. I'm just I've heard about this further violence immediately following arraignment. can you just give me some sort of situation where this has occurred?
Yes. So many times, we know, research tells us and history has told us that the most critical time for a victim is when an abuser feels they're losing control in a relationship. Other agencies being involved, law enforcement, courts, are at risk of the victim sharing information, maybe leaving the abuser. So it puts that victim at risk of a higher risk of homicide, further injury. And that's really where it comes from. It is very research-based.
Okay, so are you an attorney who practices in this area, or?
No, I'm not an attorney. I'm a chief executive officer. I've worked in this field for 30 years. I am not an attorney, no.
Okay, so I was specifically focusing on this allegation that releasing this information will be cause for further violence immediately following arraignment. Now, I don't know if you know or don't know, but at arraignment, or even before arraignment, a criminal protective order has been put in place. Initially, many times in domestic violence case, it happens at the scene by the police. Case is arraigned the next day, or if it happens over the weekend, the Monday. In a domestic violence case, the judge is going to reissue a criminal protective order. When has, I'm just trying to identify
I think I can.
fear.
Okay, I think I can help you there.
Ma'am, I gotta cut you off. You gotta let the representative finish his question.
Sorry, thank you.
I'm just trying to identify the fear of further violence immediately following the arraignment as a result of this report being shared.
Okay, I think I can help with that answer. Being a victim advocate in the court for many years, my task was to talk to victims prior to the arraignment. So there was an arrest the night before. The police put conditions of release on an offender, whatever they may be, maybe no contact, no threats of violence, not to enter the home, until the case is arraigned in court the next day. Prior to that arraignment, the court advocates are doing an intake with the victim in the family violence intervention unit. They're working with the victim, talking about maybe past history. Maybe I have access to notes in our Safe Futures database saying this victim has been working with us for some time, confidentially. And now I'm going to talk to family relations and maybe share some information that the victim authorized me to release just for safety purposes for a protective order. The victim may have shared there's been a long history of abuse. They may have shared they've been strangled multiple times, which raises the risk of a victim being murdered by an offender by 750%. They may have shared there's been medical incidences, they've gone to the hospital, but lied about what happened to protect the offender. So now I have this information and I ask the victim, can I share this? Because I'm safety planning with the victim. And now this risk has increased tremendously from maybe what was even in the police report, what the victim shared with law enforcement. And I'm talking to family relations and sharing the victim's request for a protective order. So all of this is done before the arraignment and helps the family relations division make a recommendation to the court about a protective order or what happens next in the court case. And I hope that clarifies a little bit.
I understand procedurally what happens here.
Okay.
I know the process. Sometimes I live the process. But the issue is, you said, and others have said, that release of this information more than likely would be cause for further violence immediately following the arraignment. So the accused finding out that the victim has disclosed that they were strangled previously. Now the perpetrator, the accused, knows this. How does that increase the propensity for further violence following the arraignment?
Retaliation. An offender or abuser feels betrayed by the victim. Maybe the victim hasn't shared that information with anyone because they've been threatened in the past. And now the abuser feels, as I said, when a victim is about to leave a relationship or the abuser fears they're leaving the relationship, they're at higher risk of reoffense and also of homicide. So that information is now shared with family relations and the court, and that victim is at a higher risk of and loses trust with the advocates in the system, or maybe even our agency to work with us.
Understood what you're saying, but at this point in our scenario, the individual has already been arrested for domestic violence, right? He
Right.
more than likely has an indication that, you know, the eyes are on him. He's got a criminal protective order against him. I just don't see how release of this information, but maybe we get down to the privilege issue here, because, you know, if you tell your doctor something and then you authorize the doctor to tell other people about it, you're waiving the privilege, right? So I guess there's another way to go about this, and I just wanted to test that with you, is that you do the intake, but you're not allowed to share that information with anyone. And that way you can send that individual to services, you know, do your job, and we don't have this other problem, the due process problem, because part of the problem, the way I'm seeing it, is that this report that is privileged in one aspect is being shared with the prosecutor, it's being shared with the judge, and it's being hidden from the accused. So maybe you just say, nobody gets it. How would you feel about that?
Well, on the base of the arraignment, I don't know that all that information is shared with the prosecutor. It's shared with the family relations officer to make their determination on a protective order for that day, to continue a protective order, the recommendation to the court. My concern is not being able to share that information, is I now have, working with this victim, and maybe the victim shared some more information with us, because we do know on strangulation or head injuries, many victims suffer post-traumatic amnesia, which could last for hours, days, or weeks. So if an incident happens on Friday and now we're working with the victim Monday morning, more things may come to their memory of sharing what happened in the incident. So now I have all this information, but maybe it was just a breach of peace or an unlawful restraint, misdemeanor charge. And how do I share that information to safety plan through the court for the victim? So there's concerns. Maybe it is more of a communication. How do we relay information without disclosing? I think that's conversations we would have to have, but I do have concerns if we're limited to share what we know, which is always going to be more than the court knows that the law enforcement would know.
Understood. Thank you. Thank you, Mr. Chairman.
Thank you.
Further questions or comments? Thanks for being on this, ma'am. Oh, Senator Flexer.
Sorry, Mr. Chair. Thank you. Thank you for recognizing me. Good afternoon. Thank you for your testimony. I just wanted to just clarify a little bit about the discussion you were just having. So, you know, and first of all, I just want to take a moment to thank you for the work that you do, the work that all of the people at your organization have done, especially over the course of the last 2 years in the most incredibly challenging times.
Thank you.
Being able to support victims and survivors in this incredibly difficult moment. I can't thank you enough and clearly enough for that. But I just wanted to talk with you about, you know, that moment when the family violence victim advocate is getting information from a victim who's reporting for the first time, and they do reference things that have happened in the past to help inform the advocate of the overall dynamic. And to your point, they may be talking to you because of a call that was initiated by someone other than themselves. And so they're already reluctant to be there, and you're trying to get them to open up and give you the full assessment of what they've been enduring, often for weeks and months, maybe even years. So can you just talk a little bit about how the trust could be broken there?
Absolutely. The trust, victims who come in through the court system are some of the times it's the very first time they even realize there's someone there to help them, or there's agencies there to help them. Isolation in family relations, in abusive relationships, really control the victim to a point of they don't even realize there's help out there. So now I'm working with a victim and I'm telling them, we have these services, they're confidential, they're free. We can help you. We can help you with all these different aspects. And I'm building that trust as I'm talking to them. And I'm talking the language that they don't even realize people understand about power and control and past histories and injuries and strangulation and all of these things that victims deal with prior to even working with us. And I've now built that trust. The victim has confided in me, and I have to talk to the victim, if they want a protective order. And I look at, or I see what's in the police report, and I see maybe it's the first time there's an arrest, but again, there may have been 40 incidences before. So I asked the victim to let me release the information to the family relations officer or the unit Hello? Can you hear me?
Yes, continue. That was someone who wasn't on mute.
Okay, I'm sorry. Okay. With the purpose of being to help keep you and your family safe. And this is a very short-term release. It's only for this purpose. And for all these years, we have always felt confident that that's where that would stay, for the purpose of a protective order, keeping the family safe, until the Family Relations Division could do a whole assessment. And that takes time, interviews with the victim, interviews with the family relations officer, collecting all the other data before they make another recommendation to the court after the arraignment. So if I talk to that victim and now I try to refer them, if things change and I try to refer them to our agency, oh, all right, well, I have confidentiality, but this could be discoverable. But our advocate at our shelter, advocate at our counseling offices, or a law enforcement advocate can help you, and they have confidentiality. I've lost that trust totally. So the likelihood that that victim will even seek services in our agency go down tremendously.
Thank you for that. I think it's important for members of the committee to understand the chilling effect that this could have, because too often, and you know this from your work at Safe Futures and CCADV and all of your member organizations, you look carefully every year at the domestic violence homicides that take place in the state. And, one of the reoccurring aspects of those reports that you do on an annual basis is that people don't know where to get services, as you just spoke to. And so when someone is presented in front of you for that first time, the chilling effect that this change could cause, and that one avenue that person has to get help that's preventing potential future violence from occurring would be closed potentially, would it not?
Absolutely, it would be closed. We have many, many examples of that happening, or pets or children being injured because a victim spoke to us, and 30 years worth. So I can help in any way to explain this better, to have conversations with anyone. I am more than willing to.
Well, thank you. I appreciate that. I think we're trying to have a conversation this morning about ensuring our criminal justice system is open and accessible to victims that are looking for justice, and this would be going in the opposite direction. So thank you. I appreciate your testimony. Thank you, Mr. Chair.
Thank you.
Thank you. Further questions or comments? Further questions or comments? If not, thanks for being with us, man.
Thank you.
Karen Foley O'Connor.
Hi, thank you. Good afternoon, Senator Winfield, Representative Safstrom, Senator Kissel, Representative Fishbein, and all the members of the Judiciary Committee. My name is Karen Foley O'Connor, and I'm the Executive Director and CEO of the Network Against Domestic Abuse in Enfield. We are one of the 18 CCADV member agencies across the state. The network provides free and confidential advocacy services to families of domestic abuse for North Central Connecticut. I would like to thank and recognize Senators Kissel, Champagne, and Anwar for their continued support to the communities within our catchment. I am here today to emphatically oppose House Bill 5467, Section 1. At the network, we have Family Violence Victims Advocate, FVVAs, working at GA 19 and 13, Rockville and Enfield, respectively. Prior to the arraignment of a defendant after a domestic violence arrest, an FVVA will meet with the victim in that case. After prioritizing an immediate safety plan with the victim, the advocate completes an individual case report and a supplemental risk indicator. Upon the consent of the victim, this information is turned over to Family Relations Officer and subsequently the judge in the interest of decisions regarding that victim's safety. House Bill 5467 seeks to require that this information be made available to the defendant and their counsel at the time of arraignment. Prior to taking leadership of the network in February of 2020, I served for 26 years as a Connecticut State Trooper. I dedicated my career to training officers to understand both acute and long-term trauma of victims while gathering evidence. As a police officer who has responded to many domestic violence crimes, I understand that both the abuse and the police involvement is extremely traumatic to survivors of abuse. They are often mistrustful of the police and do not share years of abuse and control that they may have endured. Also, most police officers at the scene are just seeking to get the information that is necessary to establish probable cause. In a trauma-informed and confidential environment, the FVVA obtains more. Victims often disclose terrifying details of years of control and abuse. This is because this arrest and subsequent meeting with the FVVA is their first opportunity to tell anyone, and now they feel safe to do so. If this confidentiality is lost and statements made by the victim to the FVVA wind up in the hands of the abuser, there would be significant danger to the victim, which quite honestly could be fatal. If this information is not kept confidential, victims would not disclose. They are terrified of their abusers. And quite honestly, defendants are aware of what transpired in the relationship and should share that with their defense attorney. Thanks to you, this state has taken amazing strides toward protecting victims of domestic abuse. This bill will push victims back under the shroud of secrecy because they are afraid. This bill would be a step backwards from the progressive strides this state has taken. Thank you for allowing me to speak today, and I will answer any questions that you may have.
Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Karen.
Good afternoon.
So looking at this language, and I thank you for your testimony here today. So I keep on going back and forth about this language. I guess the portion that I have a problem with is the court seeing the report. And in looking at this section of the statutes, is it that this report, is there a way to open up the door that if the judge is going to see the report, then the accused sees it, but not to, maybe to put a wall there or some sort of a gate that the prosecutor can see it, but that if the judge sees it, then the accused also gets it? Is that something that you could agree with, or just thinking out loud?
Sir, I believe that the judge, that information is given to the judge solely so that the judge can make appropriate decisions regarding the safety of that victim when designing the protective order. I can tell you this, as a police officer, the reason I have seen countless violation of protective orders the moment the defendant is released. That is why I believe the state recognizes that, why they are not allowed to have guns be in possession of firearms because it's a dangerous time. An impending arrest or post-arrest is a dangerous time. And if that defendant does in fact see disclosures of abuse that are not related maybe specifically to what the arrest was for, we're looking at increased anger, increase in the feeling that they're losing control. And quite honestly, we're looking at lethality in certain cases. As a police officer, that was our biggest concern, is lethality. So it's really about not arming the defendant with information to get them more angry and possibly retaliate the moment that they're released. That's why we're talking about arraignment time, that defendant may be released hours after they have access to that. Prior to becoming a Connecticut State Trooper, I actually worked as a public defender investigator for 4.5 years. And that would be a time where an investigator would maybe want to ask the defendant about the history that may have occurred in the relationship to help defend them in that case. But it really is about the prevention of lethality or someone being seriously injured post-release.
No, I understand the intent, and I mean, taking away the guns doesn't do anything because they just resort to knives when they really want to, right? I mean, that's what the statistics show, and we don't take away knives. So that's a political thing. But anyway, I'm looking at protect victims here. But procedurally, the victim is contacted by family relations on these cases. Many times the victim, it's a next day arraignment. You got a mom who's home taking care of kids, or she's at work. Family relations will call them on the phone and do an intake, right? That's how, and then family relations makes a recommendation to the judge on what level of protective order, a full no contact, limited no contact, is he coming back into the house, that kind of stuff. So, and that's what the judge looks at in conjunction with this report that may be in the file. And it's that report that we're focusing on here today. So I don't know that the judge is hamstrung if we don't permit them to look at that report. In the cases that I've handled, usually what family relations recommends is what happens, right? And family relations very rarely, in my experience, has access to those reports, for the purposes of an arraignment. They usually call the victim on the phone. They many times meet with the accused and maybe, break the story to them. So my question had to do with maybe we meet everybody's needs if we say that the judge will not see that report. And that's where you took off with the judge relies on that report. And I have to dicker with you a little bit procedurally. So I come back to the question, can we protect victims and protect due process by making these reports non-disclosable? And if they are disclosed, then it would go to the accused as well.
I think that it's not, the Family Relations Office does provide information to the judge, but I think what I'm trying to say is that the FPVA creates a confidential and trauma-informed environment, whereas they get more information from the victims. And sometimes that more information is important enough that a judge needs to know so that certain steps can be taken as far as an order of protection. It's more, it can be much more than the conversation that victim would have with the family relations officer. And if we lose, if it's going to go to, I'm sorry, I didn't mean to interrupt you, sir.
No, I didn't know if you were done. So why don't you finish?
If they know it's going to go to the defendant, they're not going to tell. They're terrified of their abusers. They're not going to talk. Yeah.
Right. I understand. I mean, I've been on both sides of these, but family relations calling up the victim and asking, are you seeing someone? you know, not romantically, you know, a mental health treater. You know, how often do you see that individual? Has this happened before? All of that stuff is many times communicated to the judge. So what prevents a judge from saying in open court, you know, your wife shared with family relations the fact that, you know, you've seen yada yada and this has happened before and all that stuff. I mean, I don't understand how we don't get to the same place under the current system, but I understand, and it's a big weighty issue. Well, I got you here. Section 2 of 5467. Any objection to that? Heard a lot of testimony objecting to Section 1. Any objection to Section 2?
Sorry, just taking a look.
Sure.
I'd want to, I am looking at a Reader's Digest regurgitation of that. I'd rather look at it in its entirety before making a stance on that.
No problem. I just didn't, you know, everybody's been attacking Section 1 and Section 2 sits there. So just want to throw it out there. So thank you. And thank you, Mr. Chairman.
Thank you, sir.
Representative Palm.
Thank you, Mr. Chair. Good afternoon, Ms. Folio Counter. Thank you for being here. I think your experience as a police officer, as trooper, you know, informs this whole conversation really profoundly, and I'm glad you're here. Can you explain a little bit more about how children are affected specifically in the Section 1? If this were to go through and these reports were to be made available to the defendant, what would that do for kids specifically?
Well, I mean, I think that you're going to see the children of domestic abuse are used as pawns in the control. So information that may come out about maybe the child disclosed something to mom, and now the child's betrayed, that the abuser didn't want to be put out. Now the child's betrayed the abuser as well. I mean, we could talk all day about domestic abuse and its impact on children. I mean, it's a big power dynamic. It's power and control. And that exists in any family, even if there is no abuse, anyone who has kids. But truly, we want, there may be threats against the children that are not in the probable cause of the arrest that's made. And sometimes decisions by a judge about orders of protection, should they involve protecting the children as well, which may not be represented in a police report and may come out in a conversation with an FEVA. Just one example.
Yeah, thank you. I think it's a really important perspective, and thank you very much for your work. Appreciate
Thank you.
Senator Flexer.
Thank you, Mr. Chair. Good afternoon, Karen. And same as I said to Kathy, I just want to thank you and all the folks who work at the network for your incredible work. And particularly you referenced, you started right before the pandemic commenced. And so an incredibly challenging time to be leading the way that you have at the network. And thanks for being here today. I do just want to also clarify that I think there's only one brave person on this committee who's disclosed they've been on both sides of a domestic violence issue. And that's someone who's stood up and said that they're a survivor of domestic violence. And so I don't think many legislators really understand what it's like to be in the scenarios that you've been describing in your testimony this morning. Karen, can you just talk a little bit? I do think, as has been highlighted by some of my colleagues, that it's very unique and informative to have you here talking with us, both in the work that you're doing now and your experience in law enforcement, working in this area for such a long period of time. Can you talk about the challenges that you've seen, both working at the network, but in your previous professional experience with getting victims to trust and to come forward and to really talk about what they've been enduring?
So I really think that trust is the most important word that you just used there. And then on top of it, there's been a mistrust of police in general in the past couple of years. I think that the big challenge is being trauma informed and having a trauma informed approach. More often than not, as mentioned in some of the previous speakers, that they may not even call the police. It may have been someone else. And now you're there as a police officer trying to gather information, and you have mandates that if you have probable cause, you have to make the arrest. Your hands are tied in that respect, okay? So the police can become frustrated with trying to get that information out to make sure they're not walking away from a potentially dangerous situation, or could be dangerous once they leave, in ensuring that they're following that mandate. So sometimes the way that they go about with their questioning isn't as trauma informed as it could be. And as the work that I've done with you on the Family Violence Governing Council of a model policy for police response, we've worked really hard in the state to ensure that law enforcement is very educated about victims' rights, and what a trauma-informed environment is. And I think that the law enforcement in the state's taken great strides with the LAP. 100% compliance with the lethality assessment. They're there trying to get the information that they need to keep them safe, but they also, victims know that whatever a police officer gets from them is not confidential. So I can tell you from both sides, it looks different when you're talking to someone and they know that you are going to be writing down and submitting what it is they're saying, than a trauma-informed environment that is confidential, that leads them and guides them to a place where they feel comfortable to talk about, most often, years of abuse and control. So I hope that answered your question.
It does. And so when that resource would potentially no longer be available, what's the ramifications?
I feel that the victims will stop talking. They're in survival mode. They want to not be hurt. They're going to stop talking. They're going to do what they need to do to be safe. And instead of working with these agencies like the network and Safe Futures, which is from Kathy, working to get them out of that relationship into a sustainable life, self-sustainable life. Because it's more, the first thing we do is work with them at court. The next thing we do is continue working to get them out and start a self-sustainable life.
Thank you. Thank you very much for your time and your testimony this morning. Thank you, Mr. Chair.
Thank you. Ms. Fuller, just so I'm clear, these reports, are they always shared with the judge, just with family relations? How often do the judges actually see these reports?
First of all, they're only shared if the victim gives consent to be shared. Okay. So it would depend on the victim wanting the judge to know that. And most often we do encourage them to do what's best for their safety plan.
And when the reports are shared, is it only when there's an ex parte application for TRO, or is it in other instances as well?
This is actually in criminal court. So it would be post an arrest, prior to arraignment, and would go to a judge in determining a protective order. See, it's interesting, a protective order.
Protective order or no?
No, ex parte applies to restraining orders, and that's in family court. And restraining orders are sought out by the victim. A protective order, a victim does not. It's up to a judge to make the decision if there's an order of protection.
Right, I understand. So I guess that's my point. Is there a subsequent hearing after these reports are shared with the judge or not?
This is all done prior to arraignment. So arraignment would be when the defendant would be heard.
Understand, but when does the actual protective order issue? Does it issue prior to arraignment, before there's a hearing, or after the hearing?
At arraignment, the judge will give the order of protection. Okay. Typically take a look at the police report, establish probable cause, and then consider, if available, information that will allow that judge to give an order of protection and specify the conditions of that.
Okay, all right. Representative Fishbein?
Thank you, Mr. Chairman. Karen, just your experience of judges seeing these reports in criminal court is based upon all jurisdictions around the state or one particular courthouse?
First of all, the network covers Rockville Court and Enfield Court. So I can only speak to what occurs with the FBVAs that work in that court, those courthouses.
Okay, and I think that's part of the problem here is there's inconsistency amongst our courts. And I think that's part of the intention of Section 1, not that I am a proponent or a drafter thereof. That's just my understanding. And then you were just asked some questions by Representative Staffstrom. In the context that you're talking about, that you're here testifying about, is the criminal proceeding where one is accused of domestic violence at the scene. Police have issued a criminal protective order. They're arraigned the next day. They meet with family relations. Family relations creates a report. Ultimately, the accused is going to go before the judge. At that time, the judge many times, well, almost every time, I think, issues some level of criminal protective order. And under our statutes, the accused has no right to a hearing at that time. Are you aware of that, or do you concur?
Yes, I concur.
Okay.
Just to clarify, it's a conditions of release that law enforcement gives to the defendant at the time of arrest. If they're being released, that conditions of release is not valid once they stand before a judge. So once they're in front of a judge and arraigned, the conditions of release is done, and the judge comes in with an order of protection.
Yeah, it's the interim period to protect the victim, and those conditions of release many times are the same thing as a criminal protective order. Shall not threaten, harass, assault, molest, sexually assault, those kinds of things. Maybe remove from the dwelling, stay 100 feet away, that kind of stuff. The same stuff is in a criminal protective order. But the issue here is the due process issue. At the time of arraignment, the defendant has no ability to be heard as to their defenses, or anything with regard to the criminal protective order. And that's the underlying concern. The ex parte restraining order situation, different. But anything I said you disagree with?
No.
Okay, no problem. Thank you. Thank you, Mr. Chairman.
Senator Kissel?
Thank you very much, Chairman Staffstrom. Ms. Foley O'Connor, thank you so much for taking the time to come out and testify. And I want to thank you for all the hard work that you do out there in the field. I'd also like to be associated with the remarks and concerns raised by Senator Flexer. I did have an opportunity to speak to representatives of the Public Defender's Office, Ms. Delpret Sullivan, and the Chief Public Defender, who's now nominated to become a judge. So we should have her before us on Thursday. And I guess I had indicated to them that I agree wholeheartedly that people will, and it's predominantly women, but it doesn't have to be, but people will be very hesitant to be completely, I wouldn't necessarily call it forthright, but revealing in this process if they feel that any of this information could end up endangering them down the road. And obviously, this is a situation that has deteriorated so much that someone's health and safety are at risk, and the health and safety of their children may be at risk as well. And I'm just wondering, the current system seems to have worked. I mean, nothing's ever perfect, and we can always revisit the current statutory construct. But do you see any pressing need right now to move forward with essentially this public defender's request? And I was a special public defender back in the day, and I very much respect and feel that we must zealously protect the rights of defendants. and they are innocent until proven guilty. But I just think that the current system isn't broken. There's no need to fix it. And I'm just wondering why this is happening at this time, if you have any insights to that.
I don't have any insights to that. I think I agree with you. And I think that defendants have the ability to share their history with their attorneys.
Yeah. And unfortunately, when you said Rockville and Enfield's sort of in this sort of limbo right now, the courthouse there, GA 13. I have been in very close contact with the chief court administrator, Judge Patrick Carroll III. And I'm hoping that eventually it gets reopened for business, but given the huge amount of retirements that will, the first wave, or there have been waves thus far, but I think the next high water mark will be April 1st because it's the benefit impacts are quarterly. And then the huge one will be at the end of June. So all the efforts may be over there in Rockville, but certainly some excellent judges over there, I'm sure you're aware of. But thank you for your testimony, because I think that the reality is that the health and safety of someone that finds themselves, no one wants to be in this situation. No one wants to have to depend on someone else for the health and safety of themselves or their children. And to that extent, I don't think that the defendants are adversely harmed by keeping the status quo. And I just haven't seen any overriding reason why we should change what heretofore I think has been a good balance between the two parties. So thank you for your time, and thank you very much, Chairman Staffstrom.
Thank you, sir. Thank you for your support.
Further questions or comments from the committee? Further questions or comments? If not, thanks for being with us, ma'am. Next up will be Angela Schlingheit.
Yes, good morning, Senator Winfield, Representative Sasham, Senator Kissel, and Representative Fishbein. My name is Angela Schlingheit, and I am the Director of Legal and Court Advocacy Services at the Center for Family Justice. We are a member agency of CCADV, and we provide services in Bridgeport, Stratford, Fairfield, Trumbull, Monroe, and Easton. I'm here today to speak in opposition to Section 1 of HB 5467. We have very serious concerns regarding this section of HB 5467, which seeks to require that the local family violence intervention unit provide the defendant and defendant's counsel with its written report, which contains privileged information. As a former prosecutor, I am extremely aware of due process issues, and I also have great respect for our system. But I think it's very important for us to remember that these reports that we're talking about are being prepared for the sole purpose of addressing victim safety at the time of arraignment. It's well documented that when a victim is trying to separate herself or himself from an abuser, it is the most dangerous time for that person. The reason for that is because the abuser feels a tremendous loss of control, and it causes their behaviors to escalate. As a member of the Domestic Violence Fatality Review Task Force, I cannot tell you the number of cases that we have reviewed where victims have ultimately been murdered as a result of trying to leave their relationship. This is a very, very real fear and very real concern for victims of domestic violence. Recently, in 2017, Judge Keegan in New Britain under Fate versus Avery released a decision in that case, which specifically said that this waiver of the privilege for the purpose of safety planning was not an implied waiver of the confidentiality moving forward. As the case moves forward, a criminal case, and if it ends up going to trial, anything that the prosecutor is going to use in the course of that trial will be revealed to the defense for purposes of trial under the discovery process. So I think it's just very important for us to remember that this is a very limited scope for a very specific purpose. We are talking about victim safety. And I agree with Senator Kissel that there has been nothing shown to indicate that we need to change this process that has been working very well in trying to protect the victims that come forward. If we move forward with this bill, we will silence victims. And we have worked too hard and come too far to allow that to happen. So thank you for your consideration, and we hope that you will also oppose Section 1 of HB 5467.
Senator Kissel.
Thank you very much, Mr. Chairman. Ms. Schlinghai, did I pronounce that correctly?
Yes, thank you.
Yeah, I just want to commend you. I know that several of our previous speakers raised this point, but you really underlined it and put a big exclamation point. I forgot the exact play by Shakespeare, but he talked about drowning swimmers and that they grasp as they're in peril. You know, they will harm the people that actually are close to them and want to save them. And, you know, Senator Flexer has been such a champion in fighting domestic violence. And I've been so lucky to be working with her on so many of these initiatives, as well as Senator Winfield and Chairman Staffstrom and others on this committee. And, you know, we passed some good reforms last year, some excellent ones. Domestic violence, while we commonly think about physical abuse, to my mind is as much, if not more, about power and the interrelationship between two people, generally, not always. And a lot of times the children get caught in the crossfire and they can be used as pawns. Even pets can be used as pawns. And so, yeah, we're talking about people that are in danger and fear for the quality of life and their safety. And the point that you raised, which I think is so important, is as the perpetrator, man, woman, whomever, enters into the justice system, their power is threatened now, and their propensity to cause more harm or be more devious. And I'm not saying it's all necessarily point A to point B, mens rea, malice aforethought, but the craziness in the head of trying to maintain that imbalance of power between the purported victim, granted everybody's innocent until proven guilty, but the alleged individual that is exercising these bad behaviors, they're going to grasp at straws and it could ratchet up. And that's why I think that the system that we have right now serves an extremely important purpose. And it's been designed that way for a reason. And I do respect the public defender's office, but it's not like, hey, fair game, free information. That information, if there's valuable information for the defense of the accused, there's lots of other methodologies, in my opinion, that the defense counsel can use. So that is sort of my segue into the question. As a former prosecutor, wouldn't you say that even absent providing this report, there's plenty of other avenues where the defense counsel, if there is a counsel involved, it might just be the individual themselves, can gather information to maintain or to create a valid defense for him or herself, and that this is not something that, absent it, a sound defense cannot be made. In other words, let's leave this alone, and it will not harm the defendant in any way to proceed as we have been for several years thus far.
Yes, I would agree that the defense has ample opportunity in working, either, the defendant working with their attorney, gathering information to present a defense that doesn't necessarily include information that was received at the time of arraignment in this specific report. As I mentioned, the prosecutor is still under the rules of discovery. They have to provide any information they're going to be using at trial to the defense. So any specific information that may be included in that report that the prosecutor then feels is important to address at trial will be provided to the defense.
Thank you very much, and I appreciate your insights regarding this. And as I sort of cited off the litany of those that have been fighting domestic violence, I don't want to leave out my friend and colleague, Representative Fishbein and Representative Rabimbis, and so many, House and Senate Republicans, Democrats, everybody. This is just a horrible situation, and it has only gotten worse, I believe, during the pandemic. If for no other reason than people are just on top of each other far more than they had been over 2 years ago. And proximity can cause mischief in so many situations. So thank you for those insights. I think, I hate to just boil this down to, if it ain't broke, don't fix it. But I just don't think that we need this particular provision at this time. And certainly it would do a disservice to folks that are really looking to the judicial system for help, not to be undermined. So thank you for your time, and thank you very much for your indulgence, Mr. Chairman.
Thank you. Thank you for your support.
Further questions or comments from the committee? Further questions or comments? If not, Angela, always good seeing you. Thanks for being with
You
us
as
today.
well. Thank you.
All right, next up will be Alicia Donovan.
Good afternoon, Senator Winfield, Representative Stastrom, Senator Kissel, Representative Fishbein, and other distinguished members of the committee. My name is Alicia Donovan, and I'm the program director at Susan B. Anthony Project in Torrington, Connecticut, which serves victims and survivors of domestic and sexual violence in Northwest Connecticut. I'm here in support of SB 5 and to specifically speak to sections 26-27, which looks to secure $1.4 million in funding to support full-time child advocates at all 18 of CCD's member programs across the state. As was mentioned previously, Connecticut currently does not provide any state funding to support this critical role within the domestic violence service system. With disrupted and intermittent access to in-person schooling, school-related activities, and service providers over the past 2 years, children who've witnessed violence in their home or have been a victim of family violence have not had access to the resources and support services needed to increase their safety. Children who experience violence in the home often rely on these opportunities to escape what they're experiencing and to provide an outlet for their emotions. The isolation children have experienced over the past couple of years has increased their anxiety and depression and negatively impacted their overall sense of well-being. The role of the child advocate is critical in helping to restore a sense of safety and wellness in the children we serve. Our child advocate provides necessary support services and referrals to children and non-offending parents who have been victims of domestic violence. In addition to services specific to domestic violence, our child advocate provides opportunities for normal family experiences. For example, we've had events for pumpkin picking in the fall, cookie decorating parties around the holidays, and backyard barbecues in the summer. Taking the time to create these moments with the children we work with is equally as important as providing services specific to the trauma they've experienced. Rewarding experiences of our child advocate include visits from children who remark that their Christmas with us was their favorite, that they've never been to a zoo prior to their stay with us, that they remember a safety tip that was shared in a kids support group. From working with families that are entering shelter to help them feel welcome and safe, getting the children set up with new bus stops and help them acclimate to living in a new undisclosed location with other families, to advocating on the front lines with children and their non-offending parents in the school systems and with other service providers to help them understand what the family is going through. The role of the child advocate is essential when working to support families who have been victims of domestic violence. With the current funding of $11,500 in federal pass-through money, our child advocate position is only funded for a quarter of their time. Our agency works hard to secure private grant money, which gets spread among multiple positions that are not fully funded. This money is contingent upon the focus of the funder, sometimes sees a break in service, and most importantly, is not guaranteed. We currently have 16 children and 9 adults living in our residential programs. Our current federal funding supports 8.2 hours per week of our child advocate position. That's approximately 30 minutes per week per child that is living with us. That's not nearly enough time to support the needs of our residential children, never mind supporting the needs of the children in our community at large. Sharing annual state funding to support a full-time child advocate or organization is vital to being able to meet the needs of the children we serve in our area. Thank you.
Thank you. Questions or comments from the committee? Questions or comments? If not, thanks for being with us today.
Thank you.
Yasmin Halmain. Yasmin Halmain. I believe Senator Looney is with us.
Thank you, Mr. Chairman.
Good afternoon, Senator. Yes, we can. How are you, Senator?
Yes, great to be with you, Mr. Chairman. And I know that this committee has been its practice, has had many marathon hearings already and will continue to do so until the end of its charge for the session. Mr. Chairman, Senator Winfield, Representative Sastrom, Senator Kissel, Representative Fishbein, members of the Judiciary Committee. I'm Martin Looney, Senator for the 11th District, and here in support of Senate Bill number 5. And one of the main priorities of this, of course, is to focus on the victims of domestic violence, and especially the younger victims of domestic violence. To protect children from abusive homes is something which is a very significant responsibility for the state. But to meet those needs, the state must often partner with nonprofit actors in the private sector. After an incident or a series of violence, a child may seek assistance from organizations around the state, but too often that assistance is limited in the kinds of services that it can provide to emergency shelter, and in some cases, and social support that is given on an emergency basis, but is not sometimes sustained. And it's also limited by resources as well. So Senate Bill 5 would appropriate a total of $1.44 million in fiscal year 23 to cover the salary and benefit costs of one advocate in each of the 18 local organizations that assist children in homes with domestic violence. And the intent is also to create a regular appropriation that the legislature would continue in future years. We know that it is a terrifying situation for children to be living in a home where domestic violence occurs. It's a challenge when the child is traumatized, when seeing the violence between their parents, and also traumatized when the police come to the scene and take mom and or dad out in handcuffs. And that is a tragedy for the children as well. Too often, the victims of domestic violence are forced the adult victims are forced to miss work or to address the physical and mental health demands, divorce implications, temporary homelessness, financial fallout. And these already suffering people should not lose their jobs as a second injustice. And the bill specifies how employers must provide reasonable accommodations to victims of family violences, especially time off with job protection. And also requires all state employees to complete 1 hour of training and education in domestic violence to sensitize the state workforce on this and on the resources available for victims, and also requires all employers with 3 or more employees to post information concerning resources for victims of domestic violence. So it's a way to reach out, to try to educate, to make people aware of the sources that are available, so they might not feel so terribly alone in a crisis of this kind. We all know that the internet often brings out the worst in people. And this great tool that connects us all offers opportunities as well for online abuse. And too often it also leads to isolation of people who consume more falsehoods, select their own truths, and live in echo chambers. And the online environment creates much harassment, and the severity of that harassment has escalated in recent years. One study indicated that from 2014 to 20, the share of Americans reporting online experience with threats, stalking, sexual harassment, or sustained harassment has risen from 14 to 25%. And Senate Bill 5 seeks to address the toxicity of online forums with 3 provisions. First, sections 1 through 4 of the bill would require dating apps to verify the identity of each user, collect personal information that would be disclosed only upon a warrant, subpoena, or court order. It will also help victims find their offenders who use fake names and assist law enforcement to arrest criminals and deter crimes before they occur. Section 6 would create a new education and training program to help identify, report, and prevent online abuse. And Section 5 would create a new crime of child grooming to address this practice of befriending minors for the purpose of later sexually assaulting them, creating child pornography, or placing the child in prostitution. Practice of enticing a minor to later commit a crime has been prosecuted under federal law. This now creates a parallel state statute that would be punishable as a Class B or C felony. Also, the bill adds a number of additional workplace protections, which are an expansion upon Public Act 19-6, the Time's Up bill that we passed 3 years ago. So, Mr. Chairman, this is an important initiative. I think this year the committee is undertaking much important work, and I think this bill is among the most important undertakings of the session. Thank you, Mr. Chairman.
Thank you, Senator. I got some questions for you. Senator Kissel.
Thank you very much, Chairman Staffstrom. You know, it's funny, Senator, earlier today, I had asked one of the first speakers, if not the first speaker, about the allocation of funding. She called it $1.5 million, but you said it's 1.44. And also you indicated that it would be a recurring cost going forward, but I think it's laudable that we would have someone in all the courts specifically to address issues regarding the children. And so I applaud you for that. I indicated to her we're Judiciary Committee, not Appropriations. So that particular portion of the proposal, Senate Bill 5, you'll have to win over Senator Austin and Representative Walker and the rest of the members of the Appropriations Committee. But if anybody can do it, you can. I also want to applaud you, Senator Looney, for you're like one of the regulars before our committee. I know that you really respect our committee. I personally, and I'm sure the leadership as well, are thankful that you actually take the time, no matter how long in the day, to come and testify on the bills that are important to you. And I, not everybody does that. So thank you very much for doing that. On the CHRO stuff, I have to say right now, at least as far as I'm concerned, the jury's out. I think Representative Fishbein asked some really good questions earlier. It's not a criticism of the CHRO. I think they've done some really good stuff in the last few years in outreach and not being necessarily quote unquote unfriendly to business. But I think there is some due process sort of notification things that I need to puzzle my way through regarding Senate Bill 5. And those other issues that you raised towards the end of your testimony, the internet and predators, as much as we come up with great new technologies, there's somebody out there using their God-given talents for ill will and evil, and they'll flip it on its head and just do harm. And it's always tough staying one step ahead of them, but I appreciate your thoughtfulness regarding that. So I don't know if I can support everything in Senate Bill 5 right now, not that you need my entire support, but I think there's a lot of good thoughtfulness in there. And when you say children witnessing their parents or their mom in particular getting arrested, we made coming together in a bipartisan fashion. I think we made great strides regarding the dual arrest conundrum that we were facing and getting rid of that because we were an outlier amongst other states. And I think that we can make great strides again regarding domestic violence issues and continue to be a leader in the United States. So thank you, Senator. And I don't know if you want to respond to any of those concerns, but I just wanted to thank you. And thank you, Chairman Staffstrom, again for your indulgence.
Well, thank you, Senator Kissel. As a long-term member of this committee, you have dealt, I think, thoughtfully and responsibly with so much legislation over the last 30 years. Come through this committee, it was always one of my favorite committees to serve on. I actually was the ranking Senate member the term that we were in the minority back in 1995 and 96, and served on it both as a House member and as a Senate member for many years. And the committee is, I think, one of the most interesting because of the range of issues related to both civil and criminal law, and just grappling with issues related to values in our society. And I appreciate all of the goodwill and hard work that you put into it over the years.
Well, thank you. And you're bringing me back to the days when we were on this committee together. So, and of course, you've been in the Senate for 30 years, plus on top of that, all those years in the House. So I can't catch up to you. No way, no how. Thank you, Mr. Chair. Thank you, Senator.
Representative Fishman.
Thank you, Mr. Chairman. I can assure you, Senator Looney, that if the election so proceeds, I would gladly accept you as ranking or vice chair on this committee. But anyway, specifically wanted to ask you about sections 26 and 27 in the context of DAS, because, you know, I do a limited amount of stuff in this area. And well, let me give you the scenario. I recently had a case where I got a restraining order for a victim of domestic violence, and parties share a child, and the father of the child started a Husky application. And to be in a retaliatory manner, he left the file open. And what that did was it prevented my client from getting health insurance for the minor child, which I think is a way of abuse through utilization of the process. Is some of this funding going to be used at DAS itself, or is it anticipated to have some sort of a liaison contact that victims can contact at DAS so that they can navigate the system? Because DCF has an aspect of that, but I don't think the whole thing is linked together. So is that contemplated by this? It appears all this money is going out to outside groups.
I would hope that that purpose that you cite, Representative, would also be accommodated here, because we know that so many issues come up in domestic violence cases. So because often one of the parties leaves the home abruptly, and often there is a limited time available to come back and get belongings and things of that nature. I've got a case right now where the husband was forced to leave the premises, but he had a business in the family garage that he is not able now to go back there to even either work on or remove all of the equipment that he had there. He had a woodworking business that he was building up, and now he doesn't have access to that because of the protective order in place that covers all of the premises. So it's difficult. He's got to find a way to find an alternate location to remove all of that, and then also to get permission again to come back a second time to remove all of that equipment that he wasn't able to remove in the first limited visit that the police gave him, on the day when they were first called to the scene. So there are all kinds of issues, as you know, that come up when someone abruptly is forced out of a house, and often there's no clear way to know who you should ask to try to get those resolved.
Yeah, and I hope that we're able to put something in place with regard to, there's a lot of money here, that would sort of a go-between to give some guidance to these individuals. My other question is, the amount is an odd amount, 1,440,000. How is that amount derived?
I'm not sure exactly, although I think it was some based upon some amount anticipated for the recipients of the various amounts multiplied by whatever number they were that would come to that number. But I'm not sure of how it came out to be precisely that number.
Okay, thank you. That's all I had. Thank you, Mr. Chairman.
Thank you, Representative.
Further questions or comments? Further questions or comments? If not, Senator Looney, always good to see you. Thanks for joining us today.
Great to see you, Mr. Chairman. Thank you so much for all the good work that you do.
See you soon. All right, next up, I have Maya Gardos.
Hi, yes, thank you. Can everyone hear me?
Yep, you good.
Great, thank you. Members of the Judiciary Committee, my name is Maya Gardas, and I'm an undergraduate student at Yale University, testifying in support of House Bill 5414, an act concerning protections for persons receiving and providing reproductive health care services in the state. 2021 was the most devastating year for reproductive rights in decades. Day after day, state after state, new anti-abortion legislation was introduced. Women across the country lost the fundamental right to control their own bodies, and I was helpless. What could I do? I didn't live in those states. I couldn't vote in those states. My representatives were not part of their legislatures, and nothing seemed too promising on the federal level. I was heartbroken for these women, deprived of their agency and personhood, and I was helpless to save them. As a young woman growing up in such a volatile time, I cannot help but feel lucky to be living here in Connecticut. I am free to choose what is best for me and my body. But with this freedom comes awareness, the upsetting, painful awareness that there are women who are no different from me, but their lives, their opportunity to succeed, are stolen from them, all because they are denied reproductive freedom. I want to share with you one of these women's stories. Daphne McCoy is a mother of two from Dallas, Texas. She went to the hospital due to an unrelated illness and found out she was pregnant, already past 6 weeks. She knew she wouldn't be able to care for another child. She scheduled an abortion to be done in Dallas, but it was canceled the last minute due to the inaction of the Texas heartbeat bill. Stressed and scared, she began to suffer from minor seizures. So she summoned her strength and traveled all the way to a clinic in Oklahoma City. All this just so she could exercise control over her own body. All this struggle just for freedom. The state of Connecticut is not helpless. With this bill, we will not only be protecting the rights of Connecticut's women and institutions, but women all around the country who come here in search of freedom. We can be a sanctuary, a beacon of light in the darkness for all women seeking agency and control. I urge you to use your power to actualize this vision, and I urge you to support this bill. Thank you.
Thank you. Representative Blumenthal.
Sorry, I hit the wrong button there, Mr. Chair. Nice to see you, Maya. I just wanted to say, first of all, thanks for coming in, for bringing your testimony. Is this your first time testifying on a bill before us?
Yes, it is.
Well, you did so with aplomb, and I think you have a very bright future in advocacy if you choose it ahead of you. Real appreciate your testimony on this bill. Thank you, Mr. Chair.
Thank you so much, Representative Blumenthal.
Further questions or comments from the committee? Further questions or comments? If not, thanks for being with us today. Next up will be Jen Lawler. Ms. Lawler, you're on mute still.
Oh, I'm sorry, Representative Staffstrom. I thought you would take me off mute. Good afternoon, everyone. My name is Jen. What's that?
Not sure I have that power, but.
Oh, okay. My name is Jen Lawler, and I am a Connecticut resident. And while there are a number of great things to discuss today, I'm going to be testifying in support of two items. The first would be HB number 5468, an act establishing the crime of harmful communication with a minor, as well as HB number 5470, which has to do with crime victims' rights. Regarding HB 5468, I'm testifying today both as a parent and a licensed clinical social worker. I have great concerns for the many dangers children and teens are exposed to each day, and in looking for current data on these dangers, I found some startling information that was recently released from the FBI. There are an estimated 500,000 online predators active every single day. Children between the ages of 12 and 15 are especially susceptible to being groomed or manipulated by the adults they meet online. Over 50% of the victims of online sexual exploitation are between the ages of 12 and 15. 89% of sexual advances directed at children occur in internet chat rooms and through instant messaging. In more than 25% of all reported exploitation incidents, the online predator will ask a child for sexually explicit photos of themselves. 4% of children receive aggressive solicitations from adults online, including attempts to contact the child in person or over the telephone. 58% of parents report being concerned about the threats online, yet while using social media, 40% of children remove privacy settings in order to attract more friends or followers. It is well documented that adult predators looking to groom children online often visit social media websites that are popular with young people, and they pretend to be their age. Adults may try to secure their trust with fake profile pictures, pretending to share similar interests, offering gifts, etc. Once an online relationship has been established, the groomer will more often than not steer the conversation towards sex. The child may be pressured to take explicit photos or videos of themselves and send them to the groomer. In the most extreme cases, the groomer will pressure the child to meet in person, and the groomer may also blackmail the child by threatening to release the private photos or videos and share them with the child's friend or family. While adults who groom children online are often strangers, this is not always the case. In many circumstances, the child may have met a groomer through family or other connections, and the adult builds a relationship online. The child might not even realize they're being groomed, and they might consider the person grooming to be a boyfriend or girlfriend. In closing, Many states have laws preventing adults from corrupting minors or engaging in sexually explicit conversations with those under the age of 18. In these states, adults who are convicted of this type of conduct can be sentenced to prison and may be required to register as a sex offender once convicted. While I'm not fully aware of what legislation you all might already have in place here, I am confident in talking to Representative Callahan, who raised this bill, that he did it with good reason, and I hope that further consideration is given that would add Connecticut to the list of states who pursue felony charges for offenders conducting themselves this way. I have more on the next bill, but I know I'm out of time. It's just very hard with so many things on the agenda at once.
Understood. Questions from Representative Callahan. Representative Callahan.
Thank you, Chairman Staffstrom. Jen, it seems like I know we have short time. If you could finish your little bit of your testimony, I'd appreciate it.
Thank you. I just had a little bit to share on HB 5470. On that, I'm testifying as a co-victim of violent crime in Connecticut. Many of you are aware, in 2018, my 25-year-old daughter, Emily, was killed by a dating partner, ironically, that she met online, that she knew for 3 weeks. And I can speak with certainty that the very few rights victims and co-victims are given cause tremendous emotional and psychological duress. The gap between the rights of the accused and the rights of the victims and their families create immediate as well as both lasting and permanent effects, making healing from the crimes committed against them indescribably harder. I support any and all opportunities to expand and specify ways that victims and co-victims of crime can be further included in the legal process. It is my opinion that doing this and maintaining the rights of the accused do not need to be mutually exclusive. While it will take effort to reform, it is entirely possible to create a much broader system of rights for victims. And due to my lived experience, I am confident that the reform is needed. That's all I wanted to say on that. Thank you.
Thank you, Jen. I appreciate you coming in to testify today. And as you and I speak often, my heart always breaks for the loss of your daughter. And I appreciate you coming in to testify in support of a bill that would further put constraints on adults who are seeking to corrupt the minds of minors online, and which they then often use to blackmail these children to meet and otherwise corrupt them in person. So having supervised sex offender units for almost 20 years, many of these people know exactly the lines to cross. And we've left that line a little bit too wide open at this point, and hopefully we can move forward and tighten up the constraints. So I know it's very difficult for you to come and testify, and I certainly appreciate you coming in today. It's always a pleasure to see you.
Thank you, too.
Representative Blumenthal.
Thank you, Mr. Chair. And I don't have any questions, Jen, but I just want to say it's nice to see you. Thanks for being here and sharing your testimony today. And thanks for all your work on behalf of victims across our state.
Thank you,
Mr. Chair.
Thank you.
Further questions or comments? If not, Ms. Lawler, thanks as always for being with us today.
Thank you.
Next, I have Leah Bromayer. Leah Bromayer with us? If not, Mayor Wielander.
Good afternoon. Co-chairs Winfield and Staffstrom, ranking members Kissel and Fishbein, and vice chairs Flexer and Blumenthal. Thank you for having me today, as well as all the distinguished members of the Judiciary Committee. My name is Mary Wielander, and I have the honor of representing the 114th District, serving Orange, Derby, and Woodbridge. And I do appreciate this opportunity to testify. I'm here in strong support of HB 5468, an act establishing the crime of harmful communication with a minor. The intent of this bill is to provide protection for children as they navigate the changing landscape of online activity. Through discussions with advocates and law enforcement, some of whom will hopefully be testifying later, it was made very clear that there are certain online acts that target minors that are not captured by current statutes. The way that children are targeted has changed and continues to change, especially through online communication. Online exploitation and abuse of children has become more and more prevalent and subversive. It is no longer just a stereotype of the stranger in the van that we have to worry about. It is a stranger across the state or the country who sends your child a message when they are sitting right next to you. Oftentimes, perpetrators will target minors with early acts of grooming that may seem innocent or innocuous, like a morning greeting or check-in that starts off as a simple gesture, but soon becomes required. These acts of grooming are done to establish an inappropriate relationship with the intent to control the minor to the point where they believe that they must do or say certain things and are less likely to challenge the adult perpetrator. It is in this way that these early actions can lead to lifelong trauma and can escalate to assault, blackmail, or human trafficking. I submitted this language in collaboration with Representative Callahan with the goal of closing some of the existing gaps that allow for clearly harmful and exploitive acts to go unchallenged by law enforcement. These are not easy conversations to have, and I would like to thank the committee for continuing this discussion and for their commitment to keeping our children safe. And I am happy to answer any questions at this time.
Thank you, Representative Waylander. Representative Godfrey.
Thank you, Mr. Chairman. Representative, how are you this afternoon? I'm so glad you're here and working with our colleague, Pat Callahan, who's represents New Fairfield. I'm in Danbury. I was aware back in the old days, 80% of sexual assaults against minors were committed by a family member or friend that they knew. And that practice, that statistic actually held for many years. And then came the internet, as you observed. And for good or ill, governments in general, legislatures more specifically, have a hard time keeping up with technology. We had strong laws dealing with sexual assault against minors, and here comes this new thing. We had to come up with a new word for it, grooming. And basically it's using the internet to create that friendship, that familiarity with a minor who most definitely is over his or her head when dealing with these approaches. And so we need to have the laws catch up with practice. And I think that's what's going on here. I appreciate both your and Representative Callahan's advocacy and your recognition that the internet has changed things. And we need desperately to catch up to the predators, to protect their prey. It bothers me. It bothers my heart as well as my head. And I just, I wanted to thank you for your advocacy for this. We've got to update our strong sexual violence laws to cover this new phenomenon. I really appreciate it. So thank you very much.
Thank you, Representative. And I would like to just acknowledge that you referenced the previously existing statutes, and one of the things that isn't covered is the age between 16 and 17. And that's what we're really trying to make sure we are protecting all of our kids. This is under 18, and it does take into consideration the way that the internet has changed things and the way that information is disseminated, and that these children, these are all kids, are being targeted, and they are being led into a false sense of it's a false friendship. And then by the time they may recognize that something is going on, they are perhaps in a point where they feel like they can't come forward to a trusted adult. So we're hoping we can prevent that and allow for things to move forward.
Thank you for calling that age thing, the age change to our attention. That's a very interesting part of this discussion. In my generation, we had family who protected us because they could keep an eye on us, quite literally. With the internet, not so much, and it really makes me sad. Thank you, Representative.
Thank you.
Representative Callahan.
Thank you, Mr. Chairman. Thank you, Representative Welander, for coming in, and also Representative Godfrey for your kind comments. As you and I know, Representative Welander, we've there is a gap here, as Representative Godfrey also mentioned. When these children have a lack of confidence, you know what it was like when we were in our adolescence, maybe a face full of braces and acne, and someone's online telling them how wonderful they are. They've got an instant friend. So the vulnerability is there. And working with you has been a pleasure, and working with the prosecutors and some of the police that you and I have worked with, we definitely know there's a gap there. So your help has been much appreciated. So I just want to let you know, I appreciate it.
Thank you. I've enjoyed working with you as well. And I think it's great that we can come together and find a common pathway towards this. And I think just to follow up on your comment, these types of online approaches are not age specific. I think a lot of times there is that tendency for it to be a teenager who, as we all know, middle school is tough, high school is tough. Those are points where we are very vulnerable. But there's also been cases where, children's coloring books, chat rooms are being used as targeting for very young children. And this is not something that's limited to people who may, young people might not feel the most confident about themselves. It's also people who are approached by someone saying, you should be a model, or have you ever acted before? And there, those techniques of drawing someone in under false pretenses and for the clear intent and purposes of exploiting them or abusing them. So again, thank you for your work and you're on this, and hopefully we can continue to do so.
Thank you for your time, Representative Welander. Thank you, Mr. Chairman.
Thank you, Representative Palm.
Mr. Chair, Reps Callahan and Welander, thank you for your work on this. I have a couple of quick questions. You had said, Mary, that there are areas where people are falling through the cracks, figuratively speaking, and without getting into too much detail on those. So currently our human trafficking statutes and our online, I know we have a revenge porn bill. We've done a lot in this area in Connecticut, but there's still, in your opinion, areas that need tightening, or there are certain children being exempted because of age. I'm not 100% sure why this is needed. I'm saying that respectfully, not as a challenge, but where are those areas where we need to improve?
Your audio was cutting in and out just a little bit. But I think I understand your question, but please forgive me or correct me if I'm not addressing it. There are some guidelines, there are some statutes that right now, but what we are looking at is the statutes that are written do not explicitly go after online abuse, online behavior and activities. So that's one of the key things. It's the age that is covered and protected. It is the online action part. And also adapting to things in situations where, and I will try not to be too graphic or forthcoming, but just if anybody's listening with younger people around, there are moments when a perpetrator might be using coded language. So we're talking about not saying, please, take a picture and send a picture of your private parts. They are saying, please take a picture of your princess parts and send those to me. Or they are not fully exposing themselves. They're only partially exposing themselves. These are in a photograph. And I think what we're really trying to drill down to in this is establishing it's a broad net, but it's also very specific, if that makes sense. We want to make sure that we are capturing the people that know where the line is right now, especially in Connecticut, and that we are making sure that the early acts, the early intentional acts of grooming and manipulation are now capturable and punishable. I'm not a punitive person by nature, but these are, you'll hear hopefully from advocates later who really have shown that when a 45-year-old adult reaches out to a 13-year-old minor online, and it's not their coach or their pastor or anything like that. It's not with good intent. And so we really want to establish a clearer, broader picture of what this type of abuse is and make it captured under statute where there are those gaps now.
Thank you. Thank you for those really important distinctions. I appreciate it. And the discretion with which you had to describe everything. My only one final suggestion really would be if there's a way to make sure that the Trafficking in Persons Council and the National Human Trafficking Hotline are somehow looped in so that these these groomers and these practices and the techniques, just as you just described, might be made into some kind of a database. I don't know if that's what.
No, I appreciate that suggestion. That's actually a bill that I put forward in the Children's Committee, is looking at establishing a task force to identify where this is happening across the state, the method of which it's happening, and if it's being prosecuted. And if it's not, why? Because I think one of the challenges that we found in having conversations with specifically with the law enforcement and other advocates is that there are not enough personnel in law enforcement that are specifically dedicated to child sex abuse, whether it's online or not. And so when we add in the additional element and challenge of an online basis, we need more skilled technicians that are and law enforcement who are able to identify what's happening in not just in the community, but specifically with online instances. So I appreciate that suggestion, and I hope that the task force will also move forward so we can get that data that is needed so we can provide the support for our families and children.
Thank you. Thank you, Mary and Rep. Callahan. Thank you both very much. Bye.
Thank you.
Representative Howard.
Thank you, Mr. Chairman. Good afternoon. Good afternoon, Rep. Wheelander. Just also want to thank you for bringing this forward. You know, our criminal justice system, by nature of how we do things in our government, is heavily reactive. Very creative approach to take a proactive approach by being reactive to the actions. So kudos to you on that. One question. We don't define in the bill what a recorded image is. Was that a discussion? And I only bring it up because I know in other places in the country, recorded images, it's generally more in like traffic enforcement. Sometimes it's defined to include video, and sometimes recorded image is interpreted as an actual still frame. I just don't want there to be any loopholes for these predators to be able to find. Was that a discussion at any point?
It was I believe, a very short discussion. So I'd be happy to continue that. I think that falls under the parameter of what I was just mentioning to Rep. Palm of the narrow, broad but narrow approach. We wanted to make sure that we are capturing video that is video, still frame, a recording of a video. There's all of these ways that the information that a child might or a minor might share with a perpetrator. And we want to make sure that if it's disseminated in any way, shared or used in any way, that it is included.
Okay, so yeah, that would just be my only thing that perhaps we could talk about in the future. But thank you for being here. Thank you, Mr. Chairman.
Thank you, Rep. Howard.
Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Representative Wheelander. One of the aspects looking at this, and totally in support of this concept, and I have been, we talked about it last session, is the over the line, I'm talking state line aspect. So, certainly how, somebody in Massachusetts who's engaging in this activity, have you had any discussions with law enforcement? Certainly we have towns that border Massachusetts, and one could, attempt to engage in this conduct over state lines. How would that be handled, or would just be referral to the feds?
It is my understanding, and I can look into this further and get back to you on this if just to make sure, but it is my understanding that it is the state in which the perpetrator is committing the crime. Those are the standards that apply. So if someone is in Massachusetts and targeting someone in Connecticut, then the Massachusetts laws would apply to them.
Okay. So if Massachusetts did not have a law like this, that bad act would not be able to be enforceable to prevent that harm to the Connecticut child in this instance, correct?
I'm not 100% sure about that, to be honest. So before I speak out of turn, I would respectfully request to get back to you on that.
Yeah, no problem. And I see Rep. Howard keeps on flagging his hand up there. So I'm going to defer to the those boots on the ground because I don't want to, you know, ask you about something that you don't know about. So with all due respect, no problem. Thank you, Mr. Chairman.
Representative Howard.
Yeah, sorry, just to follow up to that, to the good representative, and perhaps you may not know this, are you aware of how harassing phone calls are enforced in the state at all?
No, that I'm not.
So we have statutory language in the state that when relevant to harassing phone calls, that they can be enforced where the call was made or received. Can you see that working in this particular context? So in other words, let me say it to you this way: if I'm a victim of a harassing phone call and I get that harassing phone call from somebody out of state, by Connecticut statute, it can be enforceable to that person. Or if I'm here and I make a harassing phone call to somebody in Florida, I can still be enforced here. That's the way our statutes read now. So would you be in support of taking that same concept over to this bill and say, if the solicitor or the solicitee reside in Connecticut, can be enforceable by Connecticut courts?
I'd have to look into that further before I just agree to anything with a blanket yes or no that I'm not super familiar with. That would be, I think, irresponsible of me to say that. I think that we could look at reciprocity in terms of the ability to prosecute, but I would not want to, one, speak out of turn, and two, I'm just thinking through this right off the top of my head about whether or not we have our, we're very Connecticut based. We are our own state. We have our own rules for a reason. So I wouldn't want any other state's laws to supersede ours. So I would be happy to look into that.
So that's what I'll leave you with here. In relevant to the conversation that just took place is, if you take a look at harassing phone call statute and the wording there, and we could certainly work together and see if we can carve it out to address how that interstate concern would be handled. But thank you. Thanks again.
Thank you.
Further questions or comments? If not, Representative Waylander, thank you for your work on this, and thanks for being with us today.
Thank you so much for your time, Mr. Chair.
Susan Adam.
Hi, good afternoon, Senator Winfield, Senator Flexer, and Senator Kissel, Representative Stafstrom, Representative Blumenthal, and Representative Fishbein, and members of the committee. My name is Suzanne Adam, and I'm the Executive Director of the Domestic Violence Crisis Center, DVCC. I'm here today to address the need for increased funding for advocacy for children who've been exposed to domestic violence. This funding request is part of SB 5. We are asking for your support to address this critical need. DVCC, along with CCADV, is requesting $1.44 million in annual state funding to cover the cost of 18 full-time child and family advocates at each of the state's 18 domestic violence service organizations. This amount will provide $80,000 per site to fully fund one full-time position with a salary of approximately $56,000 plus full benefits and funding to support a supervisory position. DVCC is counted as 2 sites. We have offices and safe houses in both Stamford and Norwalk. This funding would provide 2 full-time child and family advocates. There is currently no state funding to support this critical position, working with children exposed to domestic violence, something that unfortunately has only increased during COVID-19. DVCC receives $11,500 in federal pass-through money, which funds only a quarter of the current salary for this position. And we are forced to seek funding for our child advocate through private grants and our own fundraising efforts. At DVCC, this one full-time child advocate splits her time between 4 locations, our 2 offices and our 2 safe houses. Our child advocate works with children and parents to develop age-appropriate child-specific responses to trauma and violence. In fiscal year 2021, she worked with 197 clients, 116 children, and 87 parents. Recently, she worked with a teenage boy who witnessed his mother being stabbed by their father during a domestic violence incident. After the incident, he and his brother and mother were sheltered at one of DVCC's safe houses, where the boys received counseling. The older boy is an excellent student with a 4.0 GPA. He was grateful for the support of the advocate, providing him with a, quote, safe space to talk. He further told her, "I feel like a weight has been lifted from me." The advocate has provided emotional support, validated his feelings, and helped him learn the importance of emotional boundaries and to understand that what happened to his mother was not his fault. This young man told the advocate, "I feel hopeful now because I knew I needed professional help to get through this." Experiencing domestic violence in the home is a traumatic event for children, but something that does not have to define their lives. With proper clinical support provided by child and family advocates, it's something that can be overcome to create positive generational change. Our request for $1.44 million is less than 0.01% of the overall state budget. Such a small investment can have a tremendous impact. We urge you to invest in strengthening outcomes for the most vulnerable, children experiencing domestic violence. Thank you.
Thank you. Questions or comments from the committee? Questions or comments? Seeing none. Thanks for being with us today, ma'am.
Thank you. Have a good day.
All right. I think we have Leah Bromayer with us now. I think we got.
I apologize for my inadequate Zoom skills that I missed your click a while back. My name is Lee Brillmeyer. I'm a professor of law at Yale Law School, where I teach conflict of laws and various international law courses. And I want to thank the committee for giving me the opportunity to be here to comment on Bill 5414. I'm going to respond to some questions that occasionally come up about the constitutionality of this bill. As I understand it, the reason that this bill is under consideration is that there are states that want to outlaw abortion both within their own territory and outside it. For example, in Connecticut. Connecticut would like to make it clear that if states do that and try to back this up with a money damages award, the result will be unenforceable in Connecticut. That means that if your property is located in Connecticut, it will not be seizable and can't be sold to satisfy a judgment against you. In addition, the clawback provision in the bill would allow you to file suit in Connecticut against the person who sued you in Texas and recover the money you were forced to pay, plus additional damages. Most people know that there's some sort of legal rule that requires one state to recognize and enforce judgments awarded by other states. They may not know that this legal rule is the full faith and credit clause of Article 4 of the Constitution, and they probably also don't know about the exceptions to the rule. Obviously, both the precise wording of the clause and the exceptions of it are very important. These exceptions are based on the clause's wording and drafting history. The clause only applies to judicial proceedings, and it doesn't define that term. But the article just before it in the Constitution, Article 3, also refers to judicial power, and there's very substantial case law interpreting that phrase. A court is exercising judicial power, meaning that they could give a judgment that would be enforceable out of state, only if a real-world plaintiff who has actually been injured sues the person who injured him. This is not what is happening in the Texas law. In the Texas law, the identity of the person bringing suit is irrelevant. He or she is just randomly nominated as a vehicle for punishing the defendant. What this means technically is the plaintiff does not have what's called standing to sue, which is a requirement for being part of the judicial power and therefore for getting Article 4 enforcement interstate. Because the drafters of the Constitution did not have any idea of this type of case, it was only invented in the last few years by some enterprising anti-abortion activists. It violates the standing rule, and the award is not a judicial proceeding, so it should not be enforceable interstate. Also, the other consequence of having one of these non-judicial proceedings is that the attempt by Texas to enforce a judgment in Connecticut would be beyond the jurisdiction of the Texas court, and it would be defective and challengeable for that reason. There's also other exceptions that are based on the drafting history of the full faith and credit clause.
Ms. Brill,
And there, yes,
past the 3-minute mark. I need you just.
thank you. Thank you very much.
And I think there were some questions for it too. So let me jump to those. Let me start with Representative Fishman, please.
Thank you, Mr. Chairman. Good afternoon, Professor Brillmeyer. Along the lines of where you were just speaking, I guess a concern here is in the reverse, in that this language calls for, if there is a judgment in a different state, that Connecticut can get a judgment against the plaintiff in that case, in that other state, 3 times what that state had awarded. So can you unpack that? How would, if the underlying is not enforceable, how would the Connecticut action that's anticipated by this language be enforceable?
It's a concept that's sometimes called restitution in American law. The idea is that if a court without jurisdiction issued an award against you and you were forced to pay it, then you can claw back the amount that you overpaid. And that's the concept that would be used by Connecticut to recoup the money that was unlawfully, in Connecticut's view, unlawfully recovered from the defendant.
But this action would be brought by the state or by the individual or the entity against whom the judgment entered?
It's the latter. It's the entity or the person against whom the judgment was rendered.
Okay, so let's just say
It's not a judgment against the state, no.
Yeah, so let's just say judgment, Texas court awards $10,000 to Texas resident against Connecticut business. That's the underlying thing that's being attacked by this legislation. The Connecticut business would then, empowered by this language, bring their own case in Connecticut court seeking $30,000, or they could, because it's treble. How is it enforceable?
You have to keep in mind that there are other legal requirements as well. For example, there would have to be what's called personal jurisdiction, and which would mean that the prevailing plaintiff in the Texas case would be subject to the jurisdiction of the state of Connecticut and could be required to appear. In that case, you would end up with presumably a Texas judgment and a Connecticut judgment. And there's a rule called the last in time rule that says when that happens, the latter one is the one that's enforceable, that's valid.
So jurisdiction against the Texas resident happens as a result of this language, because they've never, let's say, they've never come into Connecticut. They've never done anything. I mean, their legal action was in Texas. So how does our long arm statute drag that person into Connecticut?
Oh, well, I think we're talking about people who, whether people are going to be entitled to enforce a judgment in Connecticut. And when that party shows up in Connecticut to try to enforce his first judgment, which was given by Texas, he would be served with process while in Connecticut.
Okay, so, well, one doesn't have to. So let's say they got a judgment and they sought to lien a piece of real estate that is owned. This is going back to the original $10,000 judgment, Texas resident. And they put a lien on real estate owned by the entity. They still wouldn't be setting foot in Connecticut.
Of course, you don't have to set foot in Connecticut to be subject to jurisdiction there. If you have an agent acting on your behalf in Connecticut with regard to the same case, that's going to be a minimum contacts with the Texas plaintiff as well. It's the act of trying to enforce the Texas judgment in Connecticut that has the effect of someone is asking for help from the state of Connecticut to try to enforce a judgment he got in Texas. And that gives Connecticut jurisdiction to decide the issues related to the plaintiff's request.
Okay, so if I get a call from someone who has a judgment and they say, you know, we'd like you to put together a lien based upon this judgment, then that would bring me into this dispute as well?
I take it you're thinking of yourself as being the lawyer for the plaintiff?
Yes.
So someone from Texas contacts you who are practicing law in Connecticut and says, would you put a lien on the property of so-and-so? And you do it. That subjects the Texas plaintiff to jurisdiction in Connecticut because the Texas plaintiff is directing an agent to do things in the state of Connecticut.
Understood. So then from that tie, I am being assigned to act for all purposes, or how would?
No,
is my role just limited to putting that lien on the property?
it's for things that are related to your putting the lien on the property for purposes of this case. It's not for all purposes.
Yeah, for the purposes of, okay, I got it. It's just, there's a lot of new concepts in this whole thing. So got it. Okay. I look forward to future discussions. Thank you, Mr. Chairman.
Thank you, Representative Blumenthal.
Thank you, Mr. Chair. Good to see you, Professor Brillmeyer. Thanks for being with us today and for sharing your testimony. Would you just detail for us a little bit about your work and your expertise in the area of conflicts of law, and whether you've done any work in this area related to reproductive rights?
I have not specialized in reproductive rights. I wrote one article on the subject about 30 years ago on the question of whether you could travel if Roe against Wade was overruled, whether someone from an anti-abortion state would be allowed to exercise their right to travel to go to a pro-choice state in order to have an abortion. So that was in the early 1990s. Overall, I don't work in the area of reproductive rights. I work in international law and federal jurisdiction and conflict of laws. Conflict of laws being the relations between two states of the United States that both want to assert their authority over the same case. I have maybe 6 or 7 books on the subject, including a major case book. I have probably 60 or 70 articles on the subject, and I think I'm considered the primary expert on conflict of laws in the United States currently. I've been teaching at Yale since 1981.
Thank you. So, but while you haven't specialized in reproductive rights relevant areas, particularly this general area of law is one you've worked in a long time and have a significant amount of expertise. Would that be fair to say?
Yes, there's 3 main areas of conflict of laws: personal jurisdiction, choice of law, and enforcement of judgments. This is part of the enforcement of judgment side of conflict of law, and I'm considered a major expert in that subject. I've written maybe a dozen articles on the subject.
Okay. And would it be fair to say that, in your opinion, Section 1 of this bill, which deals with that clause act provision you mentioned, is constitutional?
Yes, it's drafted well and carefully, and it doesn't create any constitutional problems. That's my belief.
And elsewhere in your testimony, you discussed other potential measures that states could take to not enforce out-of-state judgments related to reproductive rights cases that were from SB 8 style cases. Would it be fair to say that Connecticut, in addition to Section 1 of this bill, could potentially take other measures to decline to enforce out-of-state judgments that we haven't in this bill as of yet?
Yes, the simplest thing that Connecticut might do would be simply to say, we're not going to enforce this sort of judgment when it arises under the kind of law that Texas has. That would be the simplest thing to do. To actually take some positive action, it could adopt a clawback statute such as the one that I described. It could adopt a mandatory restitution. There's other things that might do in regulation of the healthcare industry, but I don't purport to speak about the healthcare industry.
All right. Well, thank you very much, Professor Brillmeyer, for your testimony today and your patience with us. And thank you, Mr. Chair.
Thank you. Further questions or comments from the committee? Senator Kissel.
Thank you very much, Mr. Chair. Hey, Professor, thank you for coming to testify. And 41 years, that's a real long time.
Senator Kissel, your camera's off.
All right. Thank you, Mr. Chair. Thank you, Professor, for coming to testify. 41 years, that's a long time to be at Yale, and appreciate your insights regarding this. We are facing a short session. This bill it's dealing with a very lightning rod kind of fundamental base issue. Maybe not so much here in Connecticut, but certainly throughout the country. If for whatever reason we weren't able to pass this, do you see any immediate danger to anyone in Connecticut regarding the dangers about something happening in Texas that might be pushed to try to be enforceable in Connecticut?
Yes, it depends on how aggressive Texas wants to get, but so far they've been about maximally aggressive, and I can easily see that if there was, for instance, a public service organization that offered health care to individuals who, I'm thinking, for example, of Planned Parenthood, if there was a Connecticut group like that, and someone from Texas left Texas to go to Connecticut to have an abortion, Texas could very well try to apply its law, even though the doctors were Connecticut doctors and the clinic was located in Connecticut. And I think that's a very serious problem because our healthcare workers are vulnerable to being sued. They can't spend their time and their money defending suits from states that they have nothing to do with.
When you say healthcare workers, would it be the institution of Planned Parenthood? I don't know if it's a corporation or LLC or what it's sort of. I'm sure it's not a partnership, but wouldn't they be the ones that are sued and not the individual workers themselves?
It would be under this Texas law. It could be any of them. It could be a nurse midwife that the woman consulted with before she decided to have an abortion. It could be someone in her family that gives her the money for a taxi ride to the Planned Parenthood clinic. It could be someone soliciting funds to support Planned Parenthood only in Connecticut. And I'm just taking Planned Parenthood as an example. It would be any organization whatsoever, because the Texas law is written so broadly that it could authorize a suit against anybody that did anything that made it easier for the woman to get an abortion, or even to attempt to get the abortion, or to intend to have an abortion, even if you later change your mind. All of these things are illegal under the Texas law.
So even just providing information to an individual would be the grounds for some kind of long arm reach of
Abs-
Texas?
Absolutely, it could, because the case is under this very odd Texas idea of how to use the judicial power. The case is not brought by the state, so there's no political control over how that person chooses who to sue. They may be somebody who just has a grudge against the woman who had the abortion, or against her doctor, or maybe somebody who's kind of a little bit not all there, and says, here's my opportunity to sue and get $10,000. It's extremely broadly written. All you have to do is to contribute in some way to getting an abortion, or attempting to get an abortion, or intending to have an abortion.
And Professor, just one last question. Would we be the first ones subject to this, or has this started in some other, I'm guessing like Louisiana or some state closer to Texas? I would guess that this, in other words, is this already working its way through some court system so that we could like step back and say, well, this is being appealed because Texas went after Louisiana or Oklahoma or something like that?
Well, the law is very recent. And my understanding is that a small number of cases have been filed, but not very many because people don't know about it yet. I think the wave of cases that would be a real problem is in the future, but not very, very much, because a number of other states are toying with the idea of doing the same thing that Texas has done. I think there's about 8 or 10 states around the country that are considering the Texas model. And this would effectively divide the United States into two warring camps.
Well, I appreciate your insights regarding this. I'll have to really think about it. I know that when I even try to raise the issue of parental notification, and I'm not going to ask your opinion on that one way or another, that in and of itself becomes a lightning rod for a lot of debate. And I think I got a committee to raise it once in 30 years, and that was that. So, but people feel very strongly on both sides of this issue. And so what might be a very practical response to some state trying to extend its reach into our state. And, my druthers as a New Englander are, stay away from my state. We want to govern ourselves. Nonetheless, I can see even a small bill like this generating a lot of floor time, whether it's in the House or the Senate. But that's something for our leadership in the legislature to have to get its arms around. But your legal insights are I can't even, I want to guess how many presidents you've taught along the way, or people that we should know. But thank you for all your service here in Connecticut and teaching at Yale Law School for 41 years. Congratulations, ma'am. Really, that's pretty impressive. Thank you, Mr. Chair.
Thank you. Senator Kissel, maybe she'll let you come in and guest lecture class with her one day or something.
Gladly.
I don't think I couldn't even hold her coat.
Questions or comments from others on the committee? Questions or comments? Seeing none, Professor, thanks for being with us today.
Thank you.
Okay, next up I have Abigail Puzo.
Good afternoon. I'm testifying in support of SB 455, an act concerning revocation by dissolution of marriage. My name is Abigail Puzo. I'm an attorney who has been primarily practicing in the trust and estates area for the past 9 years. I'm a member of the executive committee of the Connecticut Bar Association's Estate and Probate section, and I led the subcommittee that originally drafted this proposed legislation. I want to thank the members of the Judiciary Committee, and particularly the chairs, for considering this bill and listening to my testimony today. I do want to note right at the outset that there are some very important technical corrections to this proposed bill as written that I detail in my written testimony that was submitted this past Friday. I'll mention a few of the more important corrections in my testimony today. This bill was prepared by our section and was reviewed and unanimously approved by the Executive Committee of the Family Law section of the Connecticut Bar Association. We feel this bill is important to our constituents. It solves a problem. Right now, under Connecticut law, there is a provision that revokes certain dispositions and appointments in a will for the benefit of a former spouse, but there's no similar provision under Connecticut law for non-probate transfers, meaning designations of beneficiary designations in life insurance policies, retirement accounts, or similar provisions in revocable trusts. As an estate planning practitioner, we often see this as a hole in the law. It's often talked about amongst practitioners, and we feel that this law fills this hole. What does the law do? It provides that upon a dissolution of marriage, except as provided by the express terms of a governing instrument, that dispositions in favor of a former spouse or designations of the former spouse as a fiduciary are revoked. We feel that this fulfills the intent of a majority of our constituents. Importantly, at least 30 other states have similar laws, and a law similar to the Connecticut bill proposed here was reviewed and basically blessed by the US Supreme Court in the case Veen versus Mellon in 2018. I did want to note a few key points and important technical corrections in the bill. And the first one is in the definition of a governing instrument. Importantly, a governing instrument is only not to include a will. It is to include a court order and a decree and a contract relating to the division of property. This is key because often in a divorce proceeding, as part of the divorce agreement, the parties agree to continue life insurance for the benefit of one of the spouses. And so by putting it in a divorce decree, it would cause this automatic revocation not to apply. So that's a key technical correction that needs to be made. It's important to know that this is a default law and it can be superseded by drafting either expressly to the contrary or to doing a designation post-divorce. So say you want to continue to benefit a stepchild, you could do so by redesignating them post-divorce. I know my time's up, so if anybody has any questions, I don't want to go past the time.
Thank you. Appreciate that. Representative Fishman.
Thank you, Mr. Chairman. There we go.
Hello.
So I have run into this 4 times. And I guess looking at this language, the law would go into effect July 1, this coming July. But which relationships would it apply to? Would it apply to, was it retroactive? Is it prospective?
As currently drafted, my understanding is that it would be retroactive. So it would apply to divorces that have happened in which there's a designation occurred pre-divorce and post-divorce. It would serve to revoke that. That being said, that is something that was recently brought up, and I don't know, if there was a strong feeling that that was an unfair result, that I think it could be modified to be prospective, meaning applying to divorces post enactment. Because then family law practitioners and estate planning practitioners could then advise their clients going forward once the divorce is finalized. This is what the result is under Connecticut law. If you do not want to benefit your former spouse, if nothing needs to be done necessarily, unless you want to invoke, designate somebody as a contingent beneficiary, but at least they would have notice going forward.
Okay, yeah, because the concern is there's always the argument on the other side, well, they knew and they intended to leave it that way. So we are faced with, people that are in that situation presently, and we don't want to relitigate all those issues. So, or have them to relitigate those issues. I guess the other concern is, let's say the dissolution judgment says that the life insurance shall remain in place. are we then calling for the holder of the policy to reaffirm as the designated beneficiary with the holder of the life insurance company?
I don't know if we necessarily need them to reaffirm. It's by virtue of the express language of the law, it would not be revoked, because basically the terms of the law say except as provided by the express terms of a governing instrument. So there would be no revocation. So I don't think there would not need to be any reaffirmation. It would be unnecessary.
Okay, but governing instrument, it says, does not include a decree of dissolution of marriage.
So in my markup to my written testimony, that was one of the very important technical questions technical corrections. When this was, drafted from what we had originally proposed, I think there was just a misunderstanding of it. So it really should read that A is a testamentary instrument. There should actually be a B before a court order and C before a contract relating to the division of property. And the only thing a governing instrument shouldn't include is a will. And the reason why that's excluded is because there's already Connecticut law governing that. So my written testimony includes a markup of this bill that really should be reviewed carefully, because that was just an error in how it was raised.
Okay, understood. I'll take a look at that. And that's all the questions that I had. Thank you, Mr. Chairman.
Thank you.
Thank you. And just on that point, Attorney, because I assume your written testimony has your contact information in there as well.
You know what? It does not, but I will send you both of you my contact information if that's okay after this.
Yeah, if you could get it to the committee clerk or administrator, because my guess is our drafting attorneys may have some follow-up questions for you based on this, and so
absolutely
reach out to you directly to work through this.
Okay, I will absolutely do that. Thank you very much for your time today.
Sure. Maria Laskowski. Okay. How about Sharon Dorn? Beth Hamilton, and Lucy Nolan. Lucy, you're on mute.
Thank you. My name is Lucy Nolan, Senator Winfield, Representative Stastrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. My name is Lucy Nolan. I'm the Director of Policy and Public Relations at the Connecticut Alliance to End Sexual Violence. I want to touch briefly on 4 bills. Beth Hamilton, who was scheduled to speak before me, was unable to do so, but she has a pretty intensive testimony on SB 5, but I just wanted to connect, I hope, a few dots there. We are very supportive of any of the language that talks about the dating app verification. We've worked with clients and survivors who have been victims of some kind of dating app problems, and it's been very difficult for them to be able to actually go forward with any kind of criminal process. And we also but we're a little concerned about if this language is really how it can happen. And but we are supportive and happy to work with anyone on it. The other is on Section 5 of SB 5. We support the efforts that define and draw attention to the prevalence of grooming as a tactic of sexual abuse and control. We're just a little worried that this language might be unclear. And I suggest with HB 5468 that maybe the two could be put together, because grooming is not just an online problem. It is something that happens in communities all the time, and the groomer is very good at making sure that the parents or maybe other community members don't believe the actual victim. And so it is something we need to do a lot of work on. And so I suggest that maybe online and also regular community grooming be put together and studied. We've had law enforcement who have asked us, what can we do about this? They know it's going to happen, but right now, until the child is harmed, there's really no step forward. The other piece is there's language in Beth's testimony about non-disclosure agreements. We always just want to make sure that victims are allowed to have the option to have a non-disclosure agreement, only because they may not want the public to know what happened. And as is often the case, unfortunately, victims are often the ones who carry some of the blame for what happened to them. And so we want to make sure that they have the opportunity to not have that public. We do support 5414, we really find that the need to protect patients seeking legal medical care in Connecticut. They deserve privacy and a shield against law enforcement from other states. And when they come to seek healthcare, particularly victims of sexual violence. And finally, we support 5470, an act concerning crime victims' participatory rights in violation of probation or conditional discharge. And Connecticut's a national leader in the collaborative approach to sex offender supervision, treatment, and management, which also reduces recidivism. I see my time is up. I just want to say that we have a post-conviction victim advocates group that works with the sex offender unit. And we find that some victims would like to be able to speak when at a parole discharge or at a violation, because they feel like that's a part of what they're not paying attention. They're ignoring what was going on with them, and they want to be able to speak to their actual, what happened to them before, but also they're concerned that the person could continue to do harm or operate, and that they could give the court the ability to assess a little bit more the effects on victims. So thank you.
Thank you. Questions or comments from the committee for Ms. Nolan? Questions or comments? Representative Pump?
Thank you, Mr. Chair. Hi, Lucy.
Hi.
I'm just wondering if you had any kind of a comment on the consent bill. I'm sorry, you didn't, 5472, you didn't specifically talk about that, did you?
Oh, yeah, no, Bridget Kessner, who testified earlier, testified for the Alliance on that. So yeah, absolutely, we support it.
Okay, I assumed so, but I just wanted to make sure it was on the record. Thank you.
Yeah, I thought 5 bills might be too many.
Thanks a lot. Okay, thank you, Mr. Chair.
Further questions or comments from the committee? Further questions or comments? Seeing none. Thanks for being with us.
Thank you very much.
Next up will be David Cohen.
Thank you. Chairman Winfield, Ranking Member Kissel, Chairman Staffstrom, Ranking Member Fishbein, and distinguished members of the Judiciary Committee. My name is David S. Cohen, Professor of Law at Drexel University in Philadelphia. Thank you for the opportunity to testify before you today in support of House Bill 5414, an act concerning protections for persons receiving and providing reproductive health care services in the state. Along with 2 other law professors, I've spent the last year studying the legal issues that would arise if the Supreme Court overrules Roe v. Wade, which is looking very likely to happen by the end of June. The best expert estimates are about half of the states in the country will ban abortion immediately or in the very near future if Roe is overturned. This bill prepares Connecticut for this new reality. Connecticut cannot change the fact that many states will make abortion illegal. But what you can do with HB 5414 is protect Connecticut healthcare providers and people who travel to Connecticut to obtain healthcare from the very real threat that other states pose. What I'm referring to is the threat that people in other states will try to investigate, sue, or prosecute people in Connecticut for providing reproductive healthcare to people who travel from anti-abortion states to Connecticut for lawful care. That has not happened yet, but we are very close to this reality. Based on our expertise, we strongly believe this risk will intensify in the coming years as states seek to ban abortion not only in their borders, but also when their residents seek abortion care in other states, such as in Connecticut. The essence of HB 5414 is that it will prohibit Connecticut government from assisting other states seeking to target Connecticut providers, the people who help them and the patients they serve. Sections 2 through 6 protect medical records from discovery, people from out-of-state depositions, summons, and extradition, and state agencies from having to cooperate with these out-of-state investigations. All of these provisions apply only to abortion care that is lawful in Connecticut. There is simply no legal or policy reason to use the Connecticut legal system to allow anti-abortion states to impose their laws on people who are following Connecticut law. Section 1 is related, but does something different. It creates a new cause of action protecting people in Connecticut from bounty-style laws like Texas's SB 8. It is a classic clawback provision. This new cause of action would discourage anyone from suing someone in Connecticut under one of these new laws and is an important way for Connecticut to fight back against this new type of extremism. HB 5414 is a cutting-edge intervention to protect abortion access, abortion providers, and abortion patients in Connecticut. HB 5414 will ensure that the people of Connecticut, when they are following Connecticut law, are free from the risk of prosecution and lawsuits from all over the country that are based on values not shared by this state. Therefore, I urge you to pass HB 5414 and show the country that Connecticut is once again, in these extraordinary times, the leader in protecting reproductive rights and justice. Thank you.
Thank you, Senator Kissel.
Thank you very much, Chairman Staffstrom. Thank you, Professor Cohen. I'm used to folks coming and testifying before our bills from Yale, whether it's professors or students. But Drexel, and I love Philadelphia. My mom was from Philadelphia and I've visited many, many a time. But I'm just wondering, how does a professor from Drexel find out about our hearing today? Like, were there some folks that reached out to you, or I'm just wondering, and it's not I don't view it as good or bad. I think it's the more information we have, the better. So appreciate you making the effort all the way from Philly.
Well, it's easy by Zoom, but thank you, Senator Kissel. So basically, my co-authors and I have been writing about this both in academic journals, and we've written a couple of op-eds in the New York Times that we included as attachments to our written testimony that was submitted yesterday. After we wrote our first one about some of the legal issues that would arise, Representative Blumenthal reached out to us to talk to us about the situation in Connecticut. So he put this on our radar. And then advocates in the state of Connecticut approached us and asked us to testify.
And just a quick follow-up. So given your position as a researcher and writer regarding this issue, you're sort of looking at what's happening in a bunch of states, with Texas being preeminent. And now Connecticut has this bill proposal that has folks like Representative Blumenthal sort of championing it. How many other states are sort of in our position that are contemplating similar legislation?
I'd say half a dozen or so. The specific provisions of this bill, I know California is considering very similar legislation. I believe Washington State is contemplating it. I know Maryland, Oregon, and New York are thinking about what they can do in the face of half the country banning abortion to protect their providers. I don't think they have any language yet. So it is a bunch of states around the country that are looking at the reality that their providers could get into legal trouble in other states, even though they're following the law in their own states and wanting to prevent that.
Okay. Thank you, Professor. Thank you, Mr. Chair.
Representative Pump.
Thank you, Mr. Chair. Good afternoon, Professor. Thank you very much for being with us. We're starting to, understand this term horizontal federalism and the fact that state laws can have on one another when rights and provisions guaranteed by federal courts are overturned. And many years ago, before I was elected, as you know, the state of Connecticut, in its wisdom, codified Roe into state law. And at the time, I remember the debates as a private citizen, which were, this is symbolic, this isn't needed, it's the law of the land. Do you see this as a similarly preemptive safeguard to what those folks with Roe?
Yeah, I see this as preemptive, but not at all symbolic. It is preemptive because right now, with Roe v. Wade being the law of the land, there is no risk that a Connecticut provider could be prosecuted in another state for performing a lawful abortion in Connecticut. If Roe v. Wade is overturned, which it's seeming very likely will happen in June, that risk will go up, and there will be real practical value in making sure that people in Connecticut are not hauled into court in other states to either be prosecuted, sued, or even provide testimony about one of their patients or someone assisting their patients. We've already seen just earlier this month, a legislator in Missouri introducing a bill that would make it illegal to aid or abet anyone leaving the state of Missouri to obtain an abortion. And so say someone that passes, Missouri has a long history of passing legislation like this, someone comes to Connecticut and now someone in Connecticut is subpoenaed to testify in Missouri against someone who assisted that person coming to Connecticut. This law, HB 5414, would basically say the Connecticut courts are not going to help Missouri enforce its anti-abortion laws across state lines.
Thank you. And thank you for the distinction between preemptive and symbolic. And I was certainly not saying that I thought it was symbolic, but that was one of the arguments against codifying Roe. Can you think of another example of a practice which might get criminalized, right? This is predicated upon another state's criminalizing something that is still legal in Connecticut. And obviously, Connecticut is never going to decriminalize murder or such a thing. But what if, for example, marriage equality or something like that, where conservative-leaning people might start to strip out provisions such as that? Do you think this would set a precedent for that?
I don't think so, because there are long-standing precedent that says marriages have to be recognized across state lines, although there is some wiggle room with that in the litigation around marriage equality. The full faith and credit position was never fully litigated in the Supreme Court because the Supreme Court said there's nationwide marriage equality. So because of that, there's that floor. Every state has to recognize marriages, that you don't have to worry about Connecticut marriages not being recognized in other states. Here, the problem is that Roe is about to be overturned or seriously whittled away. And we have seen the aggressiveness of anti-abortion states in going after people within their state, and we predict soon outside of their state as well. And so this would be protecting Connecticut people from the aggression of those states.
Yeah, well put. Thank you. And I agree with you completely. And I'm anticipating what might be blowback in terms of, we always have to think about setting precedent, whether positive or negative. And of course, that's subjective and it depends on how you feel about what's being enacted. I think these are really perilous times, and I appreciate reasonable voices like you taking the lead. So thank you for being with us today.
Thank you very much. And just on that point, I think the key to this provision, all of the provisions here, is that the care is lawful in Connecticut. We are not saying anything about care that might be unlawful in Connecticut. And it's hard to come up with a policy reason why anyone in Connecticut should be punished through the Connecticut court system for following the laws of the state of Connecticut.
I think that's a really important distinction and a very important clarification. Thank you.
Representative Dillon.
Thank you very much, Mr. Chair. And thank you for coming today. Is New York contemplating any action like this? Because the governor had been very vocal about providing, I think, even for people from other states, and I wonder if you could help us on what action they're contemplating.
So I don't know the specifics. I know New York providers and advocates are talking with legislators and the Attorney General's office, but I've yet to see specific language on any bills. But I don't doubt that something will be forthcoming, but it just is not here yet. But I know the people in New York are actively thinking about these exact same issues.
Thank you. And to the good senator who seemed to be equating Yale to a separate state, I just want to remind you that the Griswold case was argued by Tom Emerson of New Haven, who was a Yale law professor, and also that New Haven is part of the state of Connecticut. But thank you.
Thank you. Representative Jabitzky.
Thank you, Mr. Chairman. And thank you, Professor, for coming in or for zooming in to talk to us about this issue. When you had indicated that you didn't think this was going to open the door or set a precedent with regard to any other issues. Did I get your testimony right on that?
I don't think that's exactly right. I think it could open the door. I think there's two things. One, we are facing a crisis that is right around the corner in terms of public health in this country. And so I think the risk is so serious that it's worth doing something like this. And two, I think that this issue is singularly ripe for interstate attempts to enforce one state's law in another state, because what we are going to see is that travel for people who want abortions and no longer can get them is going to become the coin of the realm. The anti-abortion folks are going to start focusing on that and try to prohibit that or restrict it in some way. So I think there's going to be unique attention focused on this like it won't be on any other issue. That being said, it is possible. I can't predict the future.
Okay, well, I can't predict the future either, but I can certainly look at the past. And, I'm looking at a case such as the lawsuit against Winchester, the gun manufacturer. And I can certainly see, states that have very strong protections of the Second Amendment might try to do the same exact thing to Connecticut, which greatly limits the constitutional rights of its citizens. And I can certainly see, one of those states doing the flipperoo on Connecticut and trying to impose a treble damages claim against Connecticut residents for something similar. And, once you start down this path, I can't see any logical place where it would stop, other than a finding that all of these things are a violation of of various clauses. Let's interstate commerce. It could be full faith and credit. It could be, there's any number of provisions, a supremacy clause. Where does it stop? I think this takes a step that I don't know any other state that's ever taken this step. Before recently, and I'm concerned that it's going to open the door to significant liability for any number of issues. How would you react to that?
I think what we've seen from the anti-abortion states recently is this novel approach to opening up to almost limitless liability for the performance of healthcare or assisting people with healthcare. And that liability reaches out of state. And these are novel causes of action that really have no comparator in American jurisprudence. I think of the Section 1 that you're referring to as a response to that. And if we don't respond to that, we sort of leave. The US Supreme Court has said that these kinds of laws are okay as a constitutional matter. SB 8 in Texas, Idaho has a similar one that's about to be signed by the governor. And 8 to 10 other states have proposed others. It's going to ensnare citizens from all over the country, ensnare Connecticut residents, and it seems to me that it's important to protect them. I understand what you're saying, I absolutely do, but I think the glass has already been broken on this by this novel type of bounty law and the efforts to enforce it in ways that go against what I believe are fundamentals of American law. And we need a response from states that are protecting their citizens from these incredibly pernicious new types of civil liability from states that have policies that go fundamentally against the values of people of Connecticut and other states. And so I agree with you. I think that there is a path we are walking down, but I think that path was started by other states, and now it's up to the states that are going to be harmed to protect their citizens.
Okay, but so essentially we are opening the door.
The door's already open.
Well, but this reciprocal type of thing where essentially create a cause of action against a judgment. I don't know of any other instance in anywhere where getting a judgment against somebody is an actionable offense.
So Professor Brillmeyer, who testified earlier.
Gentlemen.
Sorry.
We're not debating.
My apologies.
The representative can ask a question if he has a question, and the professor can respond.
My apologies.
The question is, do you know of any other instance where getting a federal judgment against somebody is an actionable offense?
So two things about that. One, it's not a federal judgment. It would be a judgment in one state court. And two, there are clawback provisions in various parts of the law. I don't have a list of them in front of me. Professor Brillmeyer, who testified earlier, has a paper that discusses all sorts of ways in which clawback provisions are already a part of American and other countries' laws. So it is not unusual to have such a provision. So they do exist, and that's what this would be in the guise of. And once again, I apologize for interrupting before.
That's okay. Explain to me how getting a judgment, having a statute that makes it an actionable offense to get a judgment against somebody in a court of law, how is that a clawback?
You are clawing back money that you are required to pay that is unlawful in another jurisdiction, that the original basis of the lawsuit is unlawful in another jurisdiction. And these kinds of lawsuits do exist. There are examples of them. And again, I read Professor Brillmeyer's paper a week and a half ago, and I don't have them at the tip of my tongue right now. But I can forward her, it's a draft, so I can't forward it to you, but I'm sure I could get permission to forward it to you, and she has the data on that.
Okay, but this isn't just asking for repayment. This is asking for treble damages.
Right, which happens in clawback provisions sometimes too. I mean, when they work at their best, they dissuade people from bringing the case in the first place, so that no one would bring an SB 8 style case against someone in Connecticut out of fear of being sued. And that would save us all from all of the trouble.
Okay. And if Texas then does the same thing with regard to gun rights against people of Connecticut, and maybe they make it quadruple damages or quintuple damages, you're saying it's worth the risk?
I'm saying it's worth the risk given the public health emergency that's coming our way.
Okay. All right. Well, thank you. Thank you for your answers. I appreciate it. Thank you, Mr. Chairman.
Thank you. Representative Blumenthal.
Thank you, Mr. Chair. And thanks, Professor Cohen, for being with us today, for your testimony and all your work on this subject. I've got a couple of questions for you. You answered a lot of my other questions in your testimony and answers to other legislators. I'm going to start with a subject matter that Representative Dubitsky was just addressing. Is there any part of this proposed bill that is offensive or aggressive to other state, or is it purely defensive?
Everything about this bill is defensive. It would require someone using the laws of another state that really go against the laws of Connecticut, against a Connecticut resident or someone who uses Connecticut services following the laws of the state of Connecticut, and tries to bring legal action against these people because the other state's laws have problems with what happened in Connecticut. So it is purely defensive.
And would it be fair to say also that if other states choose not to bring liability or prosecutions against people in Connecticut or against healthcare that was provided here in Connecticut, that the bill would essentially, the law would not need to be used at all?
Correct. If that never happens, if the other states don't open the door to harming people of Connecticut, then there's nothing that this law would have to say. And it's also important to note that as written, the Section 1, the clawback provision, exempts torts brought by someone who was injured, brought by the patient being injured, and it exempts contracts claims brought by someone who is privy to the contract. And I think that those exemptions are, allow the kind of lawsuits that the previous representative was talking about if there was harm from, say, a gun manufacturer and there was a tort in this regard brought by someone who was harmed. This provision exempts those kinds of torts.
So would it be fair to say that if a crime or a tort or contract claim exists similarly in Connecticut to in Texas, say that this bill would have no effect on the investigation or prosecution or case related to that issue?
All of this is predicated on there not being a similar crime or tort in the state of Connecticut. So for instance, the Missouri bill that I talked about earlier, that would make it a tort, a new tort for aiding and abetting someone for crossing state lines to obtain an abortion. There's nothing similar in Connecticut. So someone wouldn't be able to enforce that in Connecticut.
Thank you. I would just say, first of all, thank you for being here and for answering all these questions. Also, sorry, one more thing. Based on your research and expertise, is any provision of this bill pose constitutional problems?
No, not at all. Professor Brillmeyer talked about the full faith and credit issues, but this is not about enforcing judgments. The full faith and credit clause applies to enforcing judgments across state lines. There's nothing in this bill that has anything to do with that. And states are free to create their own exceptions to their interstate cooperation around depositions and discovery and summons. And on the extradition matter, as long as someone was never originally in that other state, the Constitution does not require extradition. And this is written very carefully from that perspective and doesn't cross any constitutional lines.
Well, thank you for that answer and all of your other answers. Suffice to say, I agree with you. The provisions of this bill are not only constitutional, but very necessary given what we're seeing in other states and the impending overruling of Roe, or at least severely limiting of Roe by the US Supreme Court. We've protected Roe by statute here in the state of Connecticut, but that does not protect us against other states trying to impose their laws against Connecticut people, whether they be providers or doctors or people who are trying to provide assistance or care, even just here in the state of Connecticut, that's legal here in the state of Connecticut. And I think we need to prepare ourselves for that eventuality. It's coming down the pike. There's, in addition to the laws you mentioned, there's a law that's been proposed in Missouri that would make it illegal to assist in any abortion on a fetus that was conceived in Missouri. And you can imagine how broadly that and what kind of problems that would create. And I think what this bill says is it's about abortion rights and reproductive rights in one sense, but more than anything, it's saying Connecticut law has to apply in Connecticut. We're not going to let other states come here and impose their laws on our residents here in Connecticut. I think that's really important to say. We're going to put up this shield, but this shield only functions as long as if you're bringing your sword. If you put down your sword, then we'll put down our shield. So thank you for all your testimony today and your patience with this process. Really appreciate you lending your expertise.
Thank you.
Representative Fishbein.
Yes, thank you, Mr. Chairman. Just briefly, one of the problems I think with this is the individual in this scenario is not a Connecticut resident. So, you know, swords and shields aside, we do have states' rights, and Connecticut has decided to do certain things. And if residents of other states have decided to do other things with their legislative process, I don't know why we wouldn't recognize that. So just by way of comment. So thank you, Mr. Chairman.
Thank you. Further questions or comments? Seeing none, thanks for being with us, Professor.
Thank you very much.
Next up is Allison Hagany.
Good afternoon, Senator Winfield, Representative Stastrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. My name is Ali Hagani. I'm a student, Connecticut native, and the Policy Director of Every Voice Coalition, Connecticut. On behalf of our Student State Coalition, I'm testifying in favor of House Bill 5472, an act concerning sexual assault in the absence of consent. As you will hear from many who have suffered from it firsthand, the antiquated reasonable person standard that underpins Connecticut's current consent standard perpetrates victim blaming in numerous ways. For one, it signifies that an individual bears the burden of visibly resisting while someone is triggering their trauma responses. It also overlooks one's right to be actively informed during sexual activities. It abides by an outdated conception of sexual assault, a black and white narrative of the stranger in an alley with a victim who is visibly resisting. You would be appalled by how many circumstances of violence slip through the cracks of this current definition of consent. I'll never forget once during my freshman year when my friend called me late at night distraught. She had left her parents' dorm where they planned on having sex. Her partner pleaded with her for them to not use a condom, saying he would not feel anything with it on. He begged her, guilted her, pressured her, but she stuck to her guns, said no, and left, despite all his best efforts and the discomfort she was feeling. Later, another friend voiced a similar experience to me, but this time she engaged in sexual activity under the assumption that her partner was wearing a condom, as they discussed. He had removed it at some point, and when she realized, he sheepishly told her that he thought she didn't care. She had to rush to get Plan B and spent the next few weeks attentively monitoring her menstrual cycle, fearful of pregnancy and concerned about STIs. Both of my friends continue to heal from these experiences. While these instances include women, this non-informed element also affects men and non-binary folks who, for example, may be uninformed about their partner's use of birth control or sexual history. A 2018 study found that 32% of women and 19% of men reported non-consensual condom removal. Under the current model, all of these individuals, including my friends, would have been seen as having consented. Think about that. The model as it currently is tells individuals that they can be lied to, manipulated, and deceived, and despite that, that their experiences don't qualify as sexual assault and that their perpetrator didn't violate their consent. And stealthing is just one kind of sexual assault that is not encapsulated in this definition. House Bill 5472 presents you with an opportunity to not only change the narrative around sexual assault and consent, but to affirm the lived experiences of those who have suffered under its current standard. It's hard for me to articulate how much this bill is needed. It transcends logic, it affects me and my friends, and it's so foundational to the culture I believe Connecticut should uplift and strive for, a Connecticut of which I'd be proud. I urge this committee to advance House Bill 5472 out of committee. Thank you.
Thank you. Questions or comments from the committee? Questions or comments? If not, thanks for being with us today. Next up will be Rue Powell.
Hello. Good afternoon. Thank you so much for the opportunity to speak. I'm speaking on House Bill number 5468, an act establishing the crime of harmful communication with a minor. My name is Rue Powell, and I'm the founder of a nonprofit called SOSA, which stands for Safe from Online Sex Abuse. SOSA works to end the online sex abuse and exploitation of minors. We do this in a number of ways, including providing online safety education, using decoys, and the study of grooming patterns to identify online predators for law enforcement. Our work has resulted in arrests and subsequent adjudication of people who abuse minors online. At SOSA, we work with law enforcement at the federal, state, and local levels. Pardon?
Go ahead, ma'am. I think we had some noise.
We've worked with law enforcement at the federal, state, and local levels. And what we have found is that some states adopt laws that better protect children online. Grooming is more than an adult befriending a child, even on the internet. It's more than an adult and a minor being in the same chat room or server due to a shared interest like a video game or a hobby. The term grooming is a bit of a misnomer because it sounds tidy, but it's the manipulation of a minor in order for a perpetrator to achieve goals at the sake of a minor's health and well-being. At SOSA, we do speak with sex abuse survivors, but because we also put decoys online and we have communications with predators as minors, we're able to see the patterns of grooming and how certain predators are able to subvert current laws in place while still abusing children. I've communicated as a minor at a variety of ages, and we've spoken to numerous people about how they've been groomed. And unfortunately, what is abusive isn't necessarily illegal, and we see that time and time again. When I communicated as a 12-year-old, it was not considered criminal for someone to ask my 12-year-old decoy for photos of her feet or bare chest for the purposes of sexual gratification. We've been told that it is not a crime to be creepy. In another case, a perpetrator showed a pattern of behavior of reaching out to minors online to speak in a way that is sexual and abusive in nature and send images that are sexual in nature. He sent nude images, but because he was using his hand to shield just a portion of his genitals, it wasn't considered actionable. So at SOSA, we are in support of a lot of this being solved from a public health perspective. And our biggest hope is that through raising awareness, some would-be predators pursue rehabilitation before a crime is ever committed. And the issue with this now is that smartphones have only been ubiquitous for the past decade or so. So today's kids are experiencing an entirely new landscape of what abuse could be like. We've always been concerned about abuse from people who are in close proximity, but a child doesn't have to be in the same town or state or room as a predator in order to be abused. And in a lot of cases, they can be sexually abused without it being considered criminal. So ultimately, this bill is about child safety, and I believe that HB 5468 would have a significant impact on internet safety for minors in Connecticut.
Thank you. Question from Representative Callahan.
Thank you, Mr. Chairman, and thank you, Ruth, for coming in and highlighting so well why this is an issue and why legislation is needed to stop this abuse of children online. And in your opinion, this is, in your testimony, you did allude to this, but this is the first step towards luring them to other acts, such it could be used for trafficking or meeting. Would you agree?
Yes, I do agree that it can lead to any of those things, but also it can lead to crimes that happen without ever an in-person meet happening. So CSAM, which is child sex abuse material, what we've historically known as child pornography, is something that can happen without ever, meeting in person. And a lot of times the grooming starts, and eventually the goal is to collect CSAM and disseminate CSAM. But often a lot of it is just for, I'm trying to choose my words carefully here, self-gratification purposes. And they're doing that, at the sake of this, at the abuse of this minor in order for their own purposes. And that is something that we also see as well. And that is not considered, in a lot of these cases, it's not considered criminal. Like when I referenced the part about, asking for photos of feet or, a bare chest or that sort of thing.
And also, Rue, when it comes to getting these, you alluded also to how difficult it is to get these cases prosecuted. And how would this bill help?
Well, I think that a lot of times that these perpetrators understand where that line is drawn. When I communicate as, for example, a 15-year-old minor, the question is, well, when do you turn 16? Because they know that the age of consent is 16 in the state of Connecticut. Or if they ask for something, or if they send images, they will send really provocative, sexual, abusive images, but, technically it's not considered nudity, so it's not considered a crime. Or they'll ask for images that are sexual in nature, but because they don't meet a specific definition, it's not considered a crime. I think that there are other states that have been able to implement grooming statutes, and they've been able to do it well, and it's made their communities a bit safer. And so I think that Connecticut can do the same and make the internet safer for everyone online.
Well, I thank you very much. You've been very, very helpful in the process, and I appreciate you coming in today. Thank you.
Thank you.
Further questions or comments? Further questions or comments? If not, Ms. Powell, I want to thank you. Certainly, we had an opportunity to meet kind of at the beginning of the session on this proposal, and I've certainly found your expertise to be useful to me as this has moved forward. So I appreciate being with us again today.
Thank you for your time. I appreciate it.
Next up will be Nora Nidzleski Eichner.
Yes, thank you. I'm Nora Nijelski Eichner. You're very close. And I am a Connecticut resident. I am a commercial litigator. I am someone who has volunteered for Planned Parenthood and also worked on a number of abortion-related cases, including a amici brief in front of the Supreme Court. I'm also a Yale Law School grad, and I'm not going to in any way discuss or refer to anything that Professor Brillmeyer has already covered, being well aware of Professor Brillmeyer's excellence on all things related. But I wanted to talk a tiny bit about 5414 from the perspective of being a litigator who represents people who are caught up on the defensive side of any kind of litigation. And specifically, I have in fact represented abortion providers who have received subpoenas unrelated to anything happening currently in Texas or Missouri that force them to grapple with the limits of an out-of-state individual's ability to impose on them and the sort of incredible burden that being on the defensive side of litigation is when you have done nothing wrong, when you are in fact are operating merely according to the laws of your state, providing the services that your state has determined are health care that are necessary for patients and for citizens of that state. So the levels of confusion, of fear, what am I responsible for? What are the potential risks and costs me? How do I find an attorney? What's the right kind of attorney? What is this going to cost me? What kind of time am I going to need to expend? What sort of patient records might be at risk? Do I need to notify my patients? These are the kinds of things that go rushing through people's minds. These are the kinds of ways that we take time away from providers. We take time away from patient care. We force people to expend their energy and their money defending themselves, defending their practice, defending their beliefs, and ultimately actually defending their own state and their own state's laws. And those are not burdens that we should be asking healthcare providers to undertake. So I am fully in support of 5414. I think that as Professor Cohen has already spoken about with greater clarity and depth of knowledge than I can, this is a defensive law. It's a law designed to stand up for Connecticut, to stand up for our ability to have our own laws, to stand up for our own democracy and our own healthcare providers, our own individuals in the state. And I really request this committee to really consider the burdens that Texas, Missouri, other states are considering imposing on citizens in Connecticut. And to take the steps to stand up for them and move this bill forward. Thank you very much.
Thank you. Questions or comments from the committee? Representative Blumenthal.
Thank you, Mr. Chair. And I just wanted to say thank you, ma'am, for coming today and for sharing your expertise and your perspective with us. It's very significant, I think, for us to understand the burdens not only of what happens if someone gets a judgment against them here in Connecticut under an SB 8 style law somewhere else, but also, what's running through their mind and what other measures or funds they may need to spend in order to defend themselves against one of these aggressive laws from out of state. So thank you for your perspective and thank you for sharing your expertise with us.
And can I just add on that point? I think, someone had raised the question about treble damages. The judgment is not the only cost, right? The costs of time, of attorney's fees, there are a number of other things that go into being on the defensive side of litigation. And that's why consumer protection laws, for instance, frequently have treble damages clauses, because there's an understanding that people have really undertaken significant expense beyond just the judgment. So I really appreciate your bill for recognizing those costs and acknowledging them in the treble damages provisions.
Thank you for that answer. And thank you, Mr. Chair.
Further questions or comments? Seeing none, appreciate you being with us today.
Thank you.
Next up will be Sally Grossman.
Hi.
Thank you. My name is Sally Grossman. I'm from Windsor. I am here to provide testimony in support of HB 5414, an act concerning protections for persons receiving and providing reproductive healthcare services in the state. It's been deeply troubling to watch what's been happening across this country over the past few years, particularly when it comes to limiting the bodily autonomy of anyone with a uterus. So as someone with a uterus, the abortion bans like SB 8 in Texas are terrifying. The Supreme Court has shown that they're unwilling to intervene, and it seems almost certain that Roe v. Wade will be overturned. Connecticut needs to ensure that all people who have abortions or perform abortions within the state are protected from archaic, cruel laws that other states in this country have enacted. I've had multiple abortions. The first one was when I was in my early 20s. There was no rape, incest, fetal, or maternal health issues. I just did not want to have a child. I never once regretted my decision, and I was so grateful that I was able to get the healthcare I needed. But even though I'm now comfortable talking about it, it took almost 2 decades to get to this point. The thought that when I was in my 20s, my medical history could be used against me in a court of law is unfathomable to me. I have a daughter who just turned 5. So I'm appalled that any future medical decisions she could make regarding her body could lead to being sued or prosecuted, especially over something as personal as an abortion. While I'm proud to share my story in order to normalize a very normal and common procedure, there are many who are not as comfortable due to the shame and stigma others have placed on abortions. Everyone deserves access to safe, legal abortions, regardless of their zip codes. If they're unable to get that care in the state that they live in and choose to come to Connecticut, we need to ensure that our laws in our state are respected, and everyone who receives abortion care or who administers abortion care in Connecticut are protected. So I urge this committee to support HB 5414. Thank you.
Thank you, ma'am. And thanks for being here to share your story. Questions or comments? Seeing none, have a nice afternoon.
Thank you.
Anne LaMonica. Olivia Rinkus. Olivia Rinkus. There she is.
Thank you. Thank you. Thank you to Representative Staffstrom, Senator Winfield, and the members of the Judiciary Committee for the opportunity to speak. My name is Olivia Rinkus. I'm from the town of North Stonington. I just would like to testify in a couple of bills. First, I would like to testify in strong support of HB 5414, an act concerning protections for persons receiving and providing reproductive healthcare services in the state, because healthcare is a human right. I'm also testifying in opposition to several bills. I firstly am opposed to portions Section 5 of SB 5, and also opposed to HB 5468, an act establishing the crime of harmful communications with a minor, as well as HB 5470, an act concerning crime victims' participatory rights in a violation of probation or conditional discharge hearing. I'm opposed to the creation of new criminal acts in Section 5 of SB 5 and in SB 6458, or excuse me, 5468. While I understand the intention is to protect minors from coming into harmful contact, there's already several laws that would cover this. I'm concerned that the creation of these new crimes, which are written somewhat vaguely, will only result in the stacking of charges, or at worst in potentially creating a harmful misunderstanding where individuals could be charged with crimes they did not commit. I'm also opposed to HB 5470. I don't disagree that a victim has a right to participate in the initial trial, but I do not believe that there is a need for a victim to participate in a violation of probation hearing, unless of course it was a violation that involved or impacted them. Nor do I believe that their testimony, which presumably was used to obtain the initial conviction, should be reused in a conditional hearing, or a new testimony should be considered. I frequently hear the conflation of victims' rights with overly punitive practices, and this is very disappointing. We're already very over-reliant on incarceration in this state and in this country. and without negating any impacts that a victim has to live with. The weaponization of their testimony in this way really just impacts an individual's right to a fair trial and ultimately becomes yet another barrier to their right to return to society. Thank you again for the opportunity to speak in favor of HB 5414 and in opposition to Section 5 of SB 5, in opposition to HB 5468, and in opposition to 5470.
Thank you, Ms. Rinkus, for being with us again today. Questions or comments? Seeing none, I'm sure we'll see you soon. All right, next up is Christina Bennett. Ma'am, you're on mute.
I wanted to say thank you to Senator Winfield, vice chairs, ranking members, and all the members of the Judicial Committee. My name is Christina Bennett, and I'm testifying on behalf of the Family Institute of Connecticut, and I'm here to express my strong opposition to HB 5414. This legislation is not in the best interest of pregnant women seeking abortions. This is all about protecting abortion providers who have broken the laws of the state that they are currently in. And even if those laws are not upheld in our state of Connecticut, the fact that medical professionals could choose to disregard their state law is very concerning. And what interest do we have as a state of Connecticut in protecting abortion providers who are breaking laws in other states? Because they could come here to Connecticut and they could break other laws in our state, and there could be a precedent for that because we've protected them in order to come here. Would this or could this legislation enable them to come here to Connecticut, botch abortions without fear of consequence, perform abortions beyond the allowed gestational age, or even maybe not report abortions on minors who are being coerced into abortions? I believe this legislation, if passed, could harm those who are seeking abortions, putting them at a greater risk for physical and emotional harm. This legislation stems from a false belief that our laws in Connecticut on abortion are superior to other states, and therefore our laws should be the standards. But we don't even have parental notification. The majority of states across the entire country require a minor to notify their parents if they're having an abortion. In Connecticut, a minor has to notify their parents if they're going to get a tan. A minor has to notify their parents if they're going to get a tattoo or a piercing, but they don't even have to tell them if they're going to get a surgical abortion. But yet we think that our abortion laws in Connecticut are superior and other states should follow our example. And that is not true. We're not doing the best job when it comes to abortion laws and protecting pregnant women and their safety. The legislators in Texas or Mississippi or any other state, they are doing their best job to serve their women and their families. And we should be able to respect the laws of that particular state. And I've heard a lot of things today that simply are not true. There is not a public health emergency. There's not an influx of women from Texas coming to Connecticut to get abortions. One thing that's not been mentioned at all today is that over 40% of abortions are done by the abortion pill. And that is becoming the fastest growing way in which women are doing abortion. And the FDA has removed regulations on the abortion pill, allowing that to be sent through the mail permanently. So why are we thinking there's going to be a huge influx of women coming to fly in from Texas to Connecticut to get an abortion when we're seeing that the fastest growing way for getting abortions is the abortion pill? And also there's so many other states that women could go to that are closer to Texas than coming all the way to Connecticut. So there is no public health emergency. And the idea that we're trying to fight so hard to protect abortion providers in Connecticut, well, there are 3 pending lawsuits against abortion providers in Connecticut. If you look online, there are 3 pending lawsuits right now against Planned Parenthood of Southern New England, but we're not interested. I haven't seen legislation that's protecting the women who've been hurt by abortion providers. One of them being my own mother, which is why I do the work that I do, because she was abused by an abortion provider in Connecticut, in Hartford, who yelled at her when she said she didn't want to abort me. And she changed her mind because a janitor talked to her. He screamed at her and said, "Don't leave this room." And she ran out, and the janitor saved my life, thank God. But there are other women who've had botched abortions, and we're more interested in protecting providers from other states and here than we are protecting women in our own state who are suffering from botched abortions. Thank you.
Thank you. Questions or comments from the committee? Questions or comments from the committee? Okay, Representative Porter.
Thank you, Mr. Chair, and thank you, Ms. Bennett, for your testimony. I've been listening all day, and you certainly caught my attention with what you had to say. It's a lot different from anything I've heard said here today. And I thank God that your mom ran out and that you made it here. Yes,
Thank you.
Made it here. just a brief question. You talked about the work that you do. You know, your story, your testimony is the reason why you do this work. Could you just tell me what is the work that you're doing in Connecticut?
Sure. I graduated from Southern Connecticut State University in 2005. And at that point is when I found out that my mom was coerced into abortion when she was younger and that she walked out of the appointment, like I just mentioned. And when I found that out, I decided that for the rest of my life, and now I'm 40, so it's been 17 plus years, that I would help pregnant women who were being coerced into abortions like my mom. And so I've done various things. For 4 years, I worked as a client service manager at the ABC Women's Pregnancy Center in Middletown, Connecticut. And I helped pregnant women. I helped them with choosing adoption, with parenting, educational classes. I worked for the Family Institute of Connecticut, and I helped fight against some of the horrible legislation that Connecticut has unfortunately passed targeting pregnancy centers. They passed legislation accusing all pregnancy centers of false advertising. And I have to say that in 4 years of public hearing, not one single woman came forward to say that she was an actual client of a pregnancy center and that she was abused or hurt by false advertising. The only people who came forward were spies from NARAL Pro-Choice Connecticut and Yale students and abortion activists. So I worked fighting against this legislation that tragically has passed in Connecticut, but we're still fighting that. And now I work in I just adopted my son from foster care. So so I'm mostly at home now. Thank you. I just became a new mom and we adopted him at the beginning of the pandemic. And that was a really beautiful experience. So honestly, mostly I'm at home taking care of my 2-year-old. We had him since he was like 7 days old, and his mom placed him into foster care, which is really important. And I am grateful for the services that this state does when it comes to that. But I also travel across the country and I speak at pregnancy banquets and I help women. Just last week, someone called me from Queens and they were like, there's a girl who's being coerced into having an abortion. She's being pressured. Can you help her? And I was just on the phone, making phone calls, sending emails. And I found a pregnancy center for her in Jamaica, Queens. And I connected her and, there you go. So that's the kind of work that I do. And I want to speak today for the women who are not being heard. And I've had women come to me. I have a girl who I can connect to, anyone who wants to hear her story. She's 20 something years old and she had a abortion pill in Connecticut here and it caused her to lose her fertility. It was a botched abortion. Just from the pill, she couldn't walk. She was in the emergency room. She lost her fertility and her parents tried to sue Planned Parenthood and they didn't have the resources or the time to do it. So they just dropped it. And she came to me like, can you just please help me tell my story? So it really frustrates me that we're working so hard to protect abortion providers in Texas. Well, abortion providers in Connecticut have lawsuits pending against them. We're looking the other way when they botch abortions, all the way since, like I said, 1981, when my mom was yelled at by an abortion provider who screamed at her and told her, don't leave this room. Right. So I get it. Connecticut's a pro-choice state. We've codified Roe versus Wade into state law. That's not changing anytime soon. I understand those dynamics, but this is aggressive. This is radical. This is about politics. This is about putting politics over women's health. The majority of women who get abortions, tragically, are African-American women. And it's not because we just want to have abortions more than anybody else, but because we've been targeted by the abortion industry. That's why we're 3 times more likely to get abortions. In addition to that, over 70% of the abortions in Connecticut are done from women that are on Medicaid. So these are vulnerable women, women that are low income, women that are on Medicaid, women that are receiving services. And we want to protect some doctors that come from Texas possibly to come here. And who knows if they're willing to break a law in Texas, what if they've broken other laws? And I know someone said today that we could still prosecute them, but will we still prosecute them when we're not really prosecuting the abortion providers here who've botched abortions? I doubt that they will be prosecuted. So I think this is really about making Connecticut some kind of abortion sanctuary state so we can protect all sorts of shady abortion doctors at the cost of women's health and safety. And I want to speak for the Black, the brown, the women who are having abortions. I want to speak for them because this is putting them at risk. This is not protecting their health.
I appreciate that. Like I said, I find it really interesting. Of course, now we have these bills before us. I'm actually getting calls and people are reaching out to me around what we're doing. And the majority of them look like you and I. And I may have missed someone, but you're the first one that I've seen.
I'm the first one here.
Right, to speak on one of these bills. So that's why you caught my attention and I was listening more intently. I was listening intently to all of them, but you really did validate some of the things that have been said to me in conversation. And one that really resonates, and to be quite honest with you, I hadn't really thought about it, is that, when you talk about women of color and Black women in particular, they're not getting abortions necessarily because they want to, it's because they can't afford a baby or they're being coerced. And that had never really, well, can't afford, I understand, but the coercion part is something that I'm learning more about. So I really do appreciate you using this platform to educate us on the other side of this story and from a different perspective. So thank you again.
Thank you.
I wish you all the best in the work that you're doing.
Thank you so much.
You're welcome, Ms. Bennett. And thank you, Mr. Chair, for the opportunity.
Representative O'Day.
Thank you, Mr. Chair, and thank you, Ms. Bennett, for your testimony. I really have been sitting here listening all day, and like my good colleague just said, your testimony kind of really reached out to me, and so not all things fit all people, and the fact that you're out there working, trying to help women who may have an another choice, and besides the abortion route. God bless you, and congratulations on your baby.
Thank you.
Wonderful news. And I just went on the website. I found out where you are. I will reach out and
please
love to support you and your efforts in what you're doing for the community. Thank you.
Thank you so much. Thank you.
Further questions or comments from the committee? Senator Kissel.
Thank you very much, Mr. Chair. First of all, you don't look 40. And second of all, where do you get all your energy having a 2-year-old? I have no idea. But thank you for your passion, especially, as someone who tried to at least get a discussion on the parental notification. But Connecticut is strongly a choice state. And you said you accept that. But your passion is really, and I want to be associated with the remarks of Representative Porter and Representative O'Day, but you really brought a unique perspective that we don't hear a lot. And I appreciate your patience and your advocacy. It means a lot. And thank you so much for taking the time.
Thank you. And I would say, please continue fighting for parental notification. That is a common sense law that the majority of states do have. So please continue fighting for it.
Well, thank you for the encouragement.
I know it's an uphill battle, but.
Representative Veach.
Good. Thank you. I just wanted to mirror what my colleagues have said. Thank you for coming out and sharing and doing everything that you're doing. It really is important, and it was nice to hear what you had to say, and I thank you.
Thank you. Thank you.
Congratulations on your 2-year-old too. That's wonderful. God bless.
Further questions or comments from the committee? Further questions or comments? Seeing none, ma'am, thanks for being with us today.
Thank you all.
Next up will be George Saris.
Thank you so very much. That's a hard act to follow, I must tell you. Can you hear me?
We can. Go ahead, sir.
I'm trying to offer testimony on House Bill 5414, an act concerning protections for persons receiving and providing reproductive health care services in the state. Thank you, members of the Judiciary Committee, for providing me with an opportunity to share my thoughts on the proposed legislation to make the state of Connecticut a safe harbor for abortionists who have provided abortions in other states in violation of their state's laws. I think it's important to understand what the root issue is in the abortion controversy. Abortion has very little to do with a woman's right to choose. It has very much to do with a man's right to sleep around. I went to college in the late 1960s during the height of the free love movement. Free love is great for men. They can sow their wild oats as often as they please and then simply get up and leave. No strings, no apparent consequences. But what about women who freely love? Unlike men, they cannot simply get up after a nice fling and go on their merry way. Free love produces babies. It is the woman who literally bears the responsibility of the night's activities in the form of a child. It was all too often the case in the 60s that irresponsible, immature, self-centered males who had never really grown up and learned what it meant to be a real man, abandoned their children and the mothers of their children in pursuit of greener pastures. Unfortunately, that pattern continues today, that the men can soothe their consciences to a certain degree by telling themselves that if she gets pregnant, she can always get an abortion. Most people don't realize it, but the women who began the feminist movement in the 19th century were strongly pro-life. They understood correctly that abortion then as now, sometimes injurious to women and 100% fatal to their unborn male and female children. An article in the April 9th, 1868 issue of the official newspaper of the National Women's Suffrage Association stated, "The crime of abortion is not one in which the guilt lies solely or even chiefly with the woman. I hesitate not to assert that most of this crime of child murder, abortion, infanticide lies at the door of the male sex." The reason why these women were opposed to abortion is actually quite obvious. Abortion cuts to the core of what it means to be a woman, for only she can be the agent of one of the most miraculous events that can occur here on earth, conception and birth. The feminist movement in the late 1960s became pro-choice, self-defense. The question women asked over and over again was, where were the men when the babies were born? House Bill 5414 does not protect, primarily protects irresponsible men. Protecting women does not mean passing laws that allow and encourage those who call themselves doctors and who have taken a solemn oath to do no harm, a group that is primarily made up of men.
Thank you, Mr. Cyrus.
Make money off of vulnerable women.
Thank you,
Taking
sir.
advantage of irresponsible.
Yep. Question for you from Representative O'Day.
Yes, sir.
Thank you, Mr. Chair, and thank you, Mr. Cyrus. Just you were just finishing up on holding irresponsible men accountable, which I agree with wholeheartedly. If you could just finish that up for in a minute or less,
yeah.
30 seconds.
Protecting women does not mean passing laws that encourage a multi-billion-dollar industry that preys on defenseless women in the name of giving them freedom, and in the process puts to death millions of unborn women who, if given a choice, would certainly choose life. Protecting women does not mean passing laws that let men use women and then abandon those women when they get pregnant with their child and not just her child. Please vote no on House Bill 5414. Protect women. Don't pass laws that allow women to be. That was what I was going to say.
Thank you very much, Mr. Cyrus. And I agree with you. The conduct of the men in these situations, not all, but many of the men, is just reprehensible. And I appreciate your testimony in that regard. Thank you, Mr. Chair.
Further questions or comments from the committee? Seeing none, enjoy the rest of your afternoon, sir. Sarah Thaker, Gretchen Raffa.
Good afternoon, Representative Staffstrom, Senator Winfield, and honorable members of the Judiciary Committee. My name is Gretchen Raffa, Vice President of Policy Advocacy and Organizing at Planned Parenthood of Southern New England, testifying in support of raised House Bill 5414, an act concerning protections for persons receiving and providing reproductive health care services in the state. We believe all people should have access to quality, affordable, and compassionate health care as a basic human right, regardless of who you are or where you live. Here's the truth about abortion. Abortion is healthcare. Abortion is normal. And for 49 years, abortion has been legal and a constitutionally protected right in our country. It's also one of the safest medical procedures, and nearly 1 in 4 women in America will have an abortion by age 45. Every decision about pregnancy is deeply personal, regardless of the pregnancy outcome, and every person deserves the right to make their own decision with respect, free from shame and stigma, and without political interference. We know across the country, people's rights and decisions about their own bodies are being stripped away. State politicians have become emboldened, cruel, and vindictive, passing laws to eliminate abortion access for all. And their plan is working. Already, the courts have repeatedly upheld Texas's 6-week abortion ban, the most extreme in the country. And by this summer, the Supreme Court could overturn Roe v. Wade, overruling nearly 50 years of legal precedent and opposing the overwhelming majority, 80% of Americans who support legal abortion. When these abortion bans go into effect, we know the immediate burden is on patients, those already facing barriers to healthcare due to systemic racism and discriminatory policies that impact them, and on the clinics and providers in neighboring states trying to serve a massive influx of patients fleeing their communities to access care where they can. And anyone who can't travel due to distance or cost is forced to remain pregnant against their will. These bans are not based in science, they're not based in healthcare, and they're not letting up. When one state passes a restrictive abortion ban, other states use a similar playbook and take even a step further, leading to a wave of increasingly radical and extreme abortion bans across the country. These bills have no regard for civil rights, creating terrifying provisions where private citizens act as bounty hunters, spying on their neighbors and anyone suspected of trying to get an abortion banned under the law. Their reward is a 5-figure lawsuit, encouraging people to sue anyone they can, including healthcare providers and those who help someone get abortion care they need and deserve. We cannot let politicians in other states attack and threaten healthcare providers in Connecticut, and we can't let them intimidate any patient seeking legal medical care within our borders. That's why HB 5414 is necessary for this committee and legislature to consider. The state of Connecticut must protect our healthcare providers and patients who receive care within our borders from the egregious overreach of politicians in states across the country. Our providers should be able to deliver this care, this legal care, without the fear of repercussions from other states' laws. No one's life should be compromised or healthcare access denied because of who they are or where they live. This is not a drill. Abortion bans are happening across the country right now, and this is our moment in Connecticut to once again be a leader and do everything we can to protect access to abortion for the people who need it. Patients deserve.
Thank you.
Okay. Thank you.
Question from Representative Blumenthal.
Thanks, Gretchen. Good to see you. I was just going to say you could finish your last sentence or two.
I think you heard it, but patients deserve a shield against enforcement from other states when they seek legal health care in Connecticut. And that's why we're urging the committee to support this bill. Thank you.
Further questions or comments from the committee?
I just had one question for Ms. Raffa. I was going to ask, we heard earlier from Ms. Bennett about potential case in which her mother was coerced regarding medical care in a state. Does Planned Parenthood condone that in any way? And is that even legal in Connecticut?
Absolutely not. We do not condone coercion. Reproductive coercion has a long and painful history in our country and targets Black and Brown people the most. And so I just want to say that every person's decision about their pregnancy is their own. Whatever they determine they want to do with their pregnancy should be up to them, the people they trust, their medical providers, and yes, we want to support all people and their decisions regarding their pregnancy.
Thank you for that answer. And, I agree with you. Hearing that was very disturbing. And that's why I think this bill targets protecting only care that is legal here in the state of Connecticut. That certainly does not sound like it was legal and would not be protected by this bill. So thank you for joining us and for your testimony.
Thank you, Representative Blumenthal.
Further questions or comments from the committee? Further questions or comments? Seeing none, Ms. Raffa, thanks for being with us today.
Thank you.
Catherine Krashel.
You got it right. 1 second. My apologies. Here we go. Hi, my name is Katie Krashel, and I'm here to provide testimony in support of raised House Bill 5414, an act concerning protections for persons receiving and providing reproductive health care services in the state. Thank you for having me, Senator Winfield, and the other honorable members of the Judiciary Committee. I'm a Connecticut licensed attorney. I teach the Reproductive Rights and Justice Clinic at Yale Law School, and I've worked as in the healthcare field for nearly a decade. I'm also a board member and officer of Planned Parenthood of Southern New England, and my wife and I live in Mystic with our 1-year-old son. In the US, regulation of healthcare is a power vested in each state. The General Assembly, the Governor's Office, and various state agencies are charged with overseeing the provision of healthcare here in Connecticut, including reproductive healthcare. Bill 5414 will ensure that Connecticut law continues to govern the provision of abortion care in Connecticut by protecting providers, patients, and their support networks from states hostile to reproductive justice and abortion access. These states are passing outrageous laws designed to reach beyond their own borders and restrict access to essential health care. With this bill, Connecticut can be a model for other states on how to protect access to abortion care and refuse to let other states utilize our legal system to enforce their laws that seek to restrict access to medical procedures that enable people here in Connecticut to live healthy, self-determined lives. As Professor Cohen mentioned earlier, there is consensus among many legal experts across the US that the Supreme Court is poised to overrule Roe v. Wade later this year. At the same time, this countrywide floor of protection for abortion access is pulled out from under all of us. States hostile to abortion rights have taken action to threaten these rights beyond their own borders. Missouri has proposed legislation that would penalize anyone who helps a Missouri resident obtain an abortion, even if the abortion is lawful in the state where it is performed. Texas's SB 8 law allows anyone to bring suit against someone who provides or helps someone obtain an abortion after the 6 weeks gestational age. And at least 10 other states are considering copycat bills that would resemble Texas's SB 8 law. These states show no sign of relenting in their attack against equality and reproductive freedom. They will likely continue to aggressively attempt to ban abortion care sought in other states, and in so doing, may pose a threat to people in Connecticut lawfully providing abortion or assisting someone in accessing abortion. Bill 5414 presents an opportunity for our state to be a model and a leader in the ongoing fight for reproductive justice, particularly as Roe hangs in the balance. Bill 5414 will guarantee that abortion will continue to be legal in our state, regardless of the outcome of the case pending before the Supreme Court. A post-Roe world is not a mere hypothetical. We pose to our, just can I finish up one more little bit?
Like half a
The sentence. Sure, yeah. Our post-Roe world is not a mere hypothetical we pose to our students in a reproductive justice clinic, but a fast approaching reality that I'm thankful I've not had yet to experience in my lifetime.
Thank you. Representative Fishbein?
Yes, thank you, Mr. Chairman. Is it Kate? Could I call you Kate?
Yeah, Katie, please. Yeah.
Katie, yeah, no, okay. I heard something at the beginning that wasn't Catherine. So, hi, Katie. How you doing? Have you been here for our debate and testimony and all that stuff here today on this bill?
For most of it, I had to step away a few times, but for most of it.
Okay, yeah, all of us have to. So particularly with Professor Bromeyer, were you here?
I have reviewed her written testimony. Unfortunately, I was only here for the end of her remarks.
Okay, because it appears, getting away from the overreaching arguments here, wouldn't it be the most effective to just say that out-of-state judgments are not enforceable? I mean, if, let's say, a Connecticut provider was sued as a result of performing an abortion against someone in Texas. They only have assets here in Connecticut. Why couldn't we just pass a law that says that Texas judgment is unenforceable in Connecticut?
Sure. So I'll say one point quickly, but I would also encourage Representative Blumenthal, the sponsor of the bill, to speak up about how they decided on the mechanism that they use for the bill. But the first thing that comes to mind is that a lot of the costs that may be incurred, especially for bills that are modeled under SB 8, will happen before any judgment is entered. And I think that Nora mentioned this earlier when she testified, that one of the biggest burdens about these laws are the sort of administrative upfront costs and the burden to providers that they have to first defend themselves in court, and that these laws do not have a limit on the number of civil plaintiffs that could bring claims against them. So one of the biggest, I think, goals of the bill is to keep those cases from being brought in the first place. So whether they're successful or not, there is a mechanism to recoup the burdens that are imposed upon the people defending these outrageous lawsuits.
But I appreciate that. The problem is that this bill as drafted does not prevent those lawsuits. they would in effect require the lawsuit to go to judgment, and then have a Connecticut individual who has the judgment against them bring a subsequent action against the individual who brought the case successfully in the other state. That's the way this language works. So it wouldn't preclude the filing of an action. We don't have the power to preclude somebody from filing an action in Texas, right? It's only the end game that we can attack. So it just appears to me, if we just say, if this concept is viable, we just say that the judgment or something to this effect is not enforceable here in Connecticut. Because I guess the other problem is the treble damages, because because then the other state passes a law that says you get quadruple damages if Connecticut did, and it just goes back and forth. So I just didn't know if you had any perspective on a different tact here. And I know Professor Brillmeyer was asked about that. So I leave it up to you if you had any.
Yeah, sure. I mean, so the first thing I think of in response to your initial comment is that there are some upfront, like the bill, as you know, does more than just address the clawback and the new civil action that it provides. Like it stops the cases from using our mechanisms. It protects health records from being provided in discovery in those cases. It keeps our legal system from being used to enforce them, to enable those cases to proceed in the way that the plaintiffs in those cases would want. So it protects people from, it keeps our state's court system from being utilized to enforce it. And to your question about, I would defer to my colleague, Professor Brillmeyer. She's the expert. And if she was asked about it, I would 100% defer to what her responses were earlier. I'm sorry that I missed some of them.
Oh, no problem. I just didn't know if you were there for that. So, but thank you for the exchange, and thank you, Mr. Chairman.
Further questions or comments, Representative Blumenthal?
Thank you, Mr. Chair. First of all, thanks, Ms. Crashall, for being here and for sharing your testimony. If we added a provision in addition to the clawback provision to decline to enforce certain out-of-state judgments related to reproductive rights cases, like SB 8 style cases, is that something that you think you would support as well?
It's not something I've thought about deeply, but on first blush, I think that would be a wonderful addition to the bill.
Okay, and I'd be glad to work with the ranking member to add that to the bill as well if he's interested. So thank you, Mr. Crashall, for sharing your testimony, and thank you thank you, Mr. Chair.
Thank you. Further questions or comments? If not, thanks for being with us. I think we have Cindy Prizio with us.
Okay, here I am. Good afternoon, Senator Winfield, Representative Staffstrom, and all distinguished members of the Judiciary Committee. My name is Cindy Prizio, and I'm going to go down to my testimony. I'm the Executive Director of One Standard of Justice, an organization that stands up for fair and equitable treatment of those in our communities burdened with harmful stigma and injustice, often lasting a lifetime. OSJ and the Restorative Action Alliance stand unified in opposition to SB 5, HB 4568, 5470, and 5472. All of these things are harmful. It's a solution we don't agree with. We want to see our criminal legal system incorporate lessons from contemporary research, reduce dependence on punitive practices, and adopt restorative justice. Our policy changes can either perpetuate the cycle of harm or break it with genuine healing and harm reduction. Excessive criminalization and sentencing do not make us safer. They fill our prisons and shatter lives, but do nothing to heal the wounds of violence or sexual violence. Collectively, these bills place more adolescents and young adults in harm's way. Prevention, early intervention, the emphasis on education for both parents and children, safe options for treatment, These are the things that will get Connecticut better outcomes. By allocating funds in SB 5 to help survivors of domestic and family trauma with programs and services, restorative justice processes can teach the affected adults to work together civilly in the raising of their children. I'm going to skip now to 5472 concerning sexual assault and consent. Affirmative and enthusiastic consent is a must, but not because the law says so, because it's a healthy harm reduction and humanistic approach to sexual behavior, says Dr. Alyssa Ackerman, professor, RJ practitioner, and sexual assault survivor. Unambiguous consent as a social norm has a tremendous ability to reduce harm. It ensures that sexual encounters are authentic and uncoerced. However, codifying it into criminal law presents a variety of problems. Social norms should not be codified, but educated. Let's see. On affirmative or unambiguous consent, we urge the legislature to pause. The concept of consent is still being developed among public health professionals, defining consent that will not harm either side of the same coin. HB 5468, establishing the crime of harmful communication with a minor. The behavior being criminalized is defined in the broadest possible terms, relying upon the vague and shifting prevailing standards in the adult community, rather than making any connection to the potential harm being done to the minor. It legislates what is offensive rather than what is harmful.
Thank you, Ms. Prizio. We're at the 3-minute mark. Representative O'Day has a question for you.
Thank you, Mr. Chair. And just briefly, Cindy, thank you so much for your testimony. You've articulated very well my concerns with 5472. We agree with the concept, but I have a problem with codification language. And just from a defense standpoint, when there's a miscommunication, how do you define consent when there's no communication? I agree in the concept, that all assault is wrong of any kind, but the language gives me pause on how we're going to codify that. So you articulated it much better than I did. So, but with respect to 5468, I need your help in educating me how it's, the language, an adult, predator, an adult predator on a minor is a problem in and of itself. What are your concerns and how would you address it?
That's a harmful communication between an adult and a minor.
Yes.
So it sort of has grooming in there and online. It's sort of a catch-all bill. One of the things we believe in is that the bulk of people that are going to get caught up in more statutes is our 18 to 21-year-olds. And we've already done a fairly good job at criminalizing and incarcerating them. We believe that not only restorative justice must happen in the early grades, but we also believe that parents and children must get educated. Basically, these are behaviors that used to happen when I was a kid without the internet. It's just that the internet's a different tool now. And so we really believe in that a one-size-fits-all approach is not going to do it. And primary prevention and education, and by the way, treatment for people without them, being threatened by law enforcement and arrest. People who know that they might have a problem and need to seek help. Our system doesn't allow that.
All right. Well, I look forward to working with you on improving this legislation as it moves forward. Thank you very much, Cindy.
Thank you. Thank you, Tom.
Representative Callahan.
Thank you, Mr. Chairman, and thanks, Ms. Prizio, for coming in to testify. You said we would get people caught up in the legal system and what they need is help. How would we get them to help, to seek help without, if they haven't been detected in engaging in this type of behavior? For instance, a 40-year-old engaging in sexual conversations on a regular basis with a 13-year-old? How would we get them into help if they've not had a brush with the law?
Well, I think in my story, I was talking more about adults with children, and that I'm not lumping everyone in the same pot. I was saying some of the people may know that something's going on and they would like to seek treatment, but we don't allow that with 40 state mandated reporters. So I think state mandated reporters sometimes are counterproductive. In terms of a 13-year-old with a 4-year-old, we're the parents in this. Quite frankly, we all need to be educated on what to look out for. And that when, you're right, there's a lot of child on child sexual harm. But what we know is whether you get intervention or not, it is transitory and the child will move out of it. If we catch them up in the carceral system, then we're halting that sort of natural progression. And who knows, we're treating violence with violence. So
would you agree, Ms. Prizio, and thank you for your answer, would you agree that, but with the dawn of the handheld computer in the form of an iPhone or others, it's almost impossible for a parent to constantly be supervising the communication through apps and other means of communication?
Oh, totally agree. But I feel that, again, it's not one-stop shopping, right? We need to do multiple things to get, it's a needle in a haystack, I think. Quote unquote predators on the internet. I mean, are they really? Not all of them are. Are we going to call somebody who's 21 with somebody communicating with a 16-year-old a predator? I don't know. I guess it depends on the behavior. And so what I find is that I hear all the time that parents will say, like the child wants to go on a site and it's supposed to only be 18-year-olds and above, or 16, and the parents are like, oh, it's okay, you can go. I mean, I think we all need to sort of step up here. But the education we would get, and I know parents don't like this, but if parents can't control their devices with their children, then they need to let the schools step up and talk about healthy intimacy and healthy boundaries.
Thank you. You've made your position clear, and I appreciate your answer. Thank you.
Thank you.
Further questions or comments? If not, Ms. Prizio, thanks for being with us.
Have a great day, everybody.
You too. Madam Administrator, is that all she wrote?
That's all she wrote.
All right. Then I am going to declare this public hearing closed for today. We will not be meeting Wednesday as originally scheduled because the chambers are in session. So instead, we're having a rare Thursday public hearing this week, which is allowed considering we're in the last 2 weeks and all the technical stuff. So we are meeting Thursday, starting at 10 a.m. It is on judicial confirmation hearings for the new batch of judges. That meeting will be hybrid. I and I think Senator Winfield and Representative Fishbein and Kissel will be, and the nominees will be physically present in 2E on that day. Members are welcome to join us in person for the nomination hearing, but there is also a remote option too. And I'm told to remind everybody that if you are going to join us in 2E, because this is a hybrid format, I know some other committees have done this, but Judiciary has not yet. You have to bring your state laptop with you to that hearing. So for those who want to join us in 2E on Thursday, you're welcome to. But there'll also be a remote login option, and the nominees will be there. That is also, so that'll be for the public hearing portion, at least with the nominees, and then also the votes will be later that day on Thursday in that hybrid manner as well. So you can either vote physically there, or you can vote from your state laptop. Also, that is the process we're going to use for JF week. So we ask folks to hold every day during JF week, as well as Monday, April 4th, which is JF day, for potential committee meetings. And we will refine times as we get a little closer. Representative Porter, question on that?
Yes, thank you, Mr. Chair. I may have missed it, but what time are we going to be operating on Thursday?
10 a.m. we start. So our normal 10 o'clock start time on Thursday. And like I said, it'll be the nominees first, our normal process, then public hearing, short break after the public hearing, and then we do expect to vote on the nominees Thursday later in the day.
All right, thank you, Mr. Chair.
Like I said, either in 2E or remote option. All right. Unless anybody has anything else, we will see you on